हेलो। Any memos?
Madam, for reporting settlement, Madam, tomorrow.
Subsequent bail petition, my lord, kindly have it.
Right.
File.
Any adjournment? List 1, page 1, sorry, page 6, serial number 36 to 38.
Serial number 20, my lord. Serial number 20, my lord.
That is for admission, sir.
Admission, my lord, the copies have not been served on me. My lord. Even on the state also it is not served.
You are for?
Respondent number 2, my lord. Next week it may kindly be.
I represented 20 my lord, petitioner my lord. Kindly have it next week my lord. Copy Saramat.
Sir, 2018, after
1
5
week time, my
years,
lord.
you are saying that you have not received the copy. ಅಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು?
1 week time for
It took 5 years for you to note that they have not received the copy.
They have also not served it on the state
I
also.
don't know what you will. Noted.
1 week
Next.
time my lord.
My lord,
Furnish the copy, sir. Furnish the copy first.
Next week it may kindly be.
Next. First, collect the copy and endorse it.
Serial number 38 my lord. Serial number 38.
serial number 17, my lord. First it will post on 1st August.
Sir, 17, wait for some time, sir.
Yes, my lord.
This week any date.
Petitioner. Counsel for the petitioner prays for time. He undertakes to address the argument on the next date of hearing without fail. Submission is placed on record. List on. Please address the argument on the next date. Yes.
Page 7, serial number 39 to 40.
Hmm. 37, same. No further adjournment. Yes. Undertaking. Next. Next. Other interim order. He undertakes to address the argument. Next. Serial number? File it. Nothing.
Serial number 20.
39 nalli. Pays for time. Undertakes to address the argument on the next date of hearing without fail. Submission is placed on record. Next.
Serial number 21, petition has become infructuous.
21.
21, I'm filing a memo to that.
List one.
21.
This one. 21.
Ideal Sumana,
Sumana Nagar.
counsel for the petitioner filed a memo seeking permission to withdraw, dismissed,
Dismissed as infructuous.
dismissed as infructuous. Hmm. Wait for some, wait for some.
Serial number 26, my lord. Mr. Mushtaq Ahmad, advocate for a petitioner, is not well. He is admitted in the hospital.
Wait, come back, next.
List two. Page number 4, serial number 21 to 24. B.S. Prasad. B.S. Prasad.
Whom you are
List-
representing?
List
Whom
2.
you are representing? Who is the advocate, sir?
B.S. Prasad.
He is a respondent. Let him come, let him come. In his presence, I will adjourn.
My lords,
Next.
list number 2, serial number 15. My lords, kindly 2 weeks' time may be granted. My senior is out of station.
And for the
15 is for
For the
admission.
respondents.
Wait for some time. Next.
Page,
No, you are for the respondent number. Let the appellate be present. Wait for some time.
page 5, serial number 25 to 31.
Next.
It's number 1.
Number 1, serial number 22. National Council is not in state. Kindly have it till next week. Otherwise, tomorrow or day.
22 no admission ಇದೆ ಅಲ್ವಾ? ಅದು ಹಾಗೆ undertakes to address ಅಂತ ಮಾಡಿ.
Sir, list 1.
I mean,
List 1.
this one.
List 1, serial number 18, my lord. We are not to post memo hakidvi andru banbitide. Senior is out of station, my lord. 1 week adjournment may be granted.
Whom you are representing?
2 cases are there. In one I am petitioner and other one I am respondent.
No,
Club one.
you are representing which council?
Petitioner Balaji Raghunath.
Where is Mr. Jaiprakash? Let him be present. In his presence, I will.
My lords, list 1, serial number.
Wait for some time. I will call it.
List 1, page 1, serial number 1, preliminary hearing. P.P. Hegde, E.I. Sanmati, Prajwal P. Patil.
Appearing for the petitioner.
My lords, before my lords, this matter has to be connected with 2 other matter, my lords. By order dated 1/9/2022.
One,
1/9/2022, my lords, 1st September 2022.
ಇಲ್ವಾ? No such orders.
No, it's reflected in the website order, my lords.
No, it was posted on 31/8/2021. Week's time was granted to comply with the office objection.
Your lordship.
1/9, it was never listed.
Petition numbers 7694 and 6217.
Dealing ಎಲ್ಲ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ 12/9 ಗೆ. Which is the connected matter?
My lords, 2 writ petition, my lords, 7694 of 2020,
7?
694.
Huh.
Other one is, my lords, 6214 of 2020.
6, 2.
14.
In all, how many connected matters are there?
Along with this matter, my lords, 3 matters, my lords, totally.
No, on the last date, on 12/9, there was reference to some other.
Criminal petitions, my lords, that has been delinked. Those criminal petitions have been delinked, my lords. What has happened is, what has happened is, there was several criminal petitions that was filed. But my lords, the petitioners and his wife, my lords, have filed of similar petitions before this court. Now, those are, my lords, other matter. Those 76, the other one, my lords, 7694 is filed by accused number 2's wife, my lords.
Yes.
So those are the broad matters, my lords. There's a case of income tax. Offense under 271C, my lords, where cash transactions took place.
Put our list. Council for respondent submits that WP number 8255 of 2020, 7694 of 2020, 6214 of 2020 are connected with the present petition. There is reference to these cases in the order dated 12/9/2026. Office is directed to list all these cases together. Yes, office to delete the name of Shri P.P. Hegde, the senior counsel. Who is representing?
That's well be fine.
Yes.
My lords, the name of Sanmati may be deleted, my lords, and
Hmm?
maybe name of Sanmati may be deleted, my lords. My
will
name will be
represent?
affected. We both are standing counsels, my lords. I am representing in this matter, my lords.
ನಿಮ್ಮ ಹೆಸರು ಕೊಡಿ.
I have given my name.
ಅದೇ ರೀತಿ on the office to delete the name of Shri P.P. Hegde for the petitioner. And Srimati E.I. Sanmati for the respondent. Show the name of so and so respondent. Hmm.
But then also, my lord, that is status of the IT appeal, my lord, because criminal prosecution is launched, that's the same subject matter.
Hmm.
This one court was pleased to grant, say, my lord, in this another case on the ground that appeal is pending.
Hmm.
They may also kindly.
Because the background is, my lords, assessment order has been passed. That assessment order, my lords, by the assessee was challenged in CIT appeals.
Yes.
At that point of time, my lords, the entire matter was, they challenged the prosecution order in the High Court.
Hmm.
Well, after the CIT appeals, my lords, was held against the favor of assessee. Now, my lords, they have gone in before the tribunal. Now, tribunal, my lords, in fairness, has allowed their appeal.
Hmm.
So therefore,
But our stand, my lords, is that irrespective of what happens to the assessment order, the prosecution, my lords, is an independent proceedings altogether, my lords.
Now,
two
what is
aspects,
your
my lord.
grievance?
Legality is one aspect, but
Yes.
factually what has happened is one aspect. I pray
What is your grievance now?
grievance is, my lord, once appeal is allowed, prosecution cannot stand. Now they themselves now submit, my lords,
Hmm.
as against assessment order. We had filed an appeal, now the appeal is allowed. Once the appeal is allowed, assessment order goes out.
Oh.
The entire prosecution is based on the assessment order. The assessment order says, my lord, that there is suppression of some income, etc.
Yes.
That foundation itself is now gone because of the appellate order. Appellate order set aside, it has set aside the original assessment order. I will also try, my lord, instructive counsel will also produce, my lords,
Yes.
the document. They may also kindly produce it, my lords, so that
That is the income tax application order. not-
then the question of law for my lord consideration is this.
Yes.
Interim order may continue
When it can be posted?
1 week. Next week.
Next Monday?
as my lord.
Next Monday?
As,
Well, of
Yes.
Tuesday, Wednesday, no, Monday is income tax appellate matter.
Tuesday, next Tuesday.
please, please.
Yes.
Interim order may kindly continue.
Interim order ಇದ್ರೆ I extend ಮಾಡ್ತೀನಿ.
Grateful.
Serial number 2, PMC Demandappa.
Petitioner in this case, my lord. PF has been paid. The police report is saying that R2 is not available in this address.
Hmm.
Will take fresh address.
Sir,
Kindly grant 1
since
week.
2016, you are taking steps.
No, it took in,
8 years have lapsed.
it took PF in 10/7/23.
PF you may pay 100 times.
I'll find the correct
But,
address, man.
No, ಇದೇನಿಲ್ಲ ಸುಮ್ಮನೆ. Pass over, verify the order sheet and make submission.
Serial number 3.
Sufficiency of service of court notice to petition number 1. 3 served on blood relative. Blood relative ಅಂತಾನೆ ಇದೆಯಾ? Order sheet ಕೊಡಿ. Court notice to the petition. You have to wait at the. Court notice issued to respond petitioner number 1 to 3 is served on their blood relative named therein. Petitioner is called out absent, services held as official. ಏನಕ್ಕಿದೆ ಇದು? Yes, what is the stage here? What is the stage in this matter?
I'll verify my notes.
The petitioner is not coming
Please. move. Kindly pass it.
They are not
on to-
represented. Verify,
Please. move.
verify. Verify the stage with which the matter is pending before the trial court.
Please. move.
Pass over.
Serial number 4, Srinivasan.
Furnish the correct address, my lord, fresh address. Lordship may kindly grant me some time. Man.
Which
I
one?
had taken steps, it has not been served.
You have taken hand summons.
And someone sold it there, but
Sarva
Sarva
ಇಲ್ಲ.
illa party is not, I was told melody.
Summons ಅಲ್ಲಿ ಸರ್ವಾಗಲ್ಲ, court summons is
ಇಲ್ಲ
steps
court
ತಗೊಳಲ್ಲ.
summons ಇನ್ನೊಂದ್ಸಲಿ ತಗೊಳ್ತೀನಿ sir,
Why it
correct.
is to be?
I'll address, I'll furnish the correct address.
Sir, since 6 years, the stage, same stage. 6 years.
1 week time ಕೊಡಿ sir, ಇದ್ರಲ್ಲಿ I will.
Ultimately ಅಷ್ಟೇ ಅದು. ಪ್ರತಿ ಸಲ ಅದೇ.
ಇಲ್ಲ, this is the second time coming.
Ultimately 1 week time, 1 week time, another 6 years. What purpose will be served? I do not
I
know.
understand.
Hmm? It will be a burden to you, it will be a burden to us.
Please, my lord.
No purpose would be served.
I understand, my lord.
Hmm.
It's a small matter, my lord.
Sure, yes.
It's a
I
small
know,
matter, criminal appeals ಇದು.
I know.
Appeal dismiss ಆಗಿದೆ.
But what will you do unless you serve the copy? You are not in a position to serve 6 years.
Lordship may kindly grant me 2 weeks. I'll also take a hand summons once again.
Yeah,
I'll
that's
direct
what
the
I
party.
understand. Once order ಆದ್ಮೇಲೆ you have not availed that opportunity. Again and again ನಮ್ಗೆ ಬೇರೆ ಕೆಲಸ ಇಲ್ವಾ ಮಾಡೋದಕ್ಕೆ? Why it should be reissued? There must be some reasonable grounds. Steps. Issue hand summons. For what purpose? I do not find any reason.
Finally, a week's time may be granted. I'll take
No.
the steps.
You go through the order sheet and make submissions. Also,
Serial number 5, Anil Kumar HS.
pass over.
Serial number 6, Ramana MBV, Rohit.
For the respondent, ma'am.
Counsel for the petitioner filed a memo seeking permission to retire from the case. ಏನ್ ಹಾಕಿದ್ದಾರೆ? It stated that a notice is served. Notice is sent to the petitioner, first petitioner. And the postal receipt is attached.
Lord, if I may,
With the
on
notice.
the same transaction, there is another two checks, my lord, it's been numbered as 6654.
1 minute. Petitioner. It is stated that since long, the council has not received any instructions from the petitioner. And all the papers along with no objection wakalat have been sent to the petitioner through speed post. Memo is placed on record. Counsel for the petitioner is permitted to retire. Petitioner is called out absent. Yes, what is that?
My lord, there's another matter arising out of the same transaction, my lord, it's
Hmm.
6654 of 2019.
Hmm.
My lord, both the matters have similar thing, and I think counsel for the petitioner has also filed his memo of retirement of that matter.
When that is posted,
My lord, that has not been, no matter, that matter has not come
I mean,
up.
counsel for the respondent submits that. Criminal petition number 6654
Yes.
of 2019 is connected with the present petition. Hence, office is directed to list both these cases together next Monday.
Obliged, my lord.
Serial number 7, Aparajita Riga.
Counsel for the petitioner filed a memo seeking permission to convert the petition into criminal appeal. memo accepted. Petition will other be converted into criminal appeal for statistical purposes, criminal petition dismissed. Next.
Serial number 8, Vandana PL.
Millards, I appear for the petition.
Hmm.
I have given NOC Wakalat, my lords.
We've received the NOC today, I'll file it in the course of the day, my lord. And we've been informed that the matter for trial court is acquitted, my lord. So we'll look into it and file the necessary memo.
You look into the order sheet and make submission. You also say what is the stage before the trial court. Pass over.
Serial number 9, Pradeep HS.
Petitioner, Your Honor. When filing memo, the petition becomes infructuous. Kindly dismiss, consider the same and dismiss.
So the petitioner filed a memo seeking dismissal of the petition as is rendered infructuous. Memo is accepted, petition dismissed. The same is rendered infructuous.
Master.
Next.
Serial number 10, Rangnath Reddy.
Proceed. Counsel for the petitioner is absent in representation. The order is dated 23/8/2023. Reads as under. In spite of that, steps against respondent number 2 is not taken. Hence petition against respondent number 2 is dismissed for default. Next stage in. Next.
Serial number 11, Annapurna Bordale.
My lords, I seek for a week's accommodation to furnish the fresh PF, my lords.
Counsel for the petitioner pays for time. Have you served personally respondent number 2?
No, my lords, we have
Oh.
served it through the court. my
Then why? In spite of, there is an order to serve respondent number 2 personally on 11/11/2021.
Yes, my lords, we have served it, my lords. We have filed a memo.
Have you produced the memo?
Yeah, yes, my lords. We have filed it on 26 November 2021, my lords, before this honorable court.
No, hold on. Huh? Verify, ma'am. Please verify when you have filed the memo.
Obliged, my lords.
Serial number 12, Chandrasekhar Reddy MV.
Appear for the petitioners, my lord. Fresh steps have been taken for fresh addressment
When you paid the PF,
today, my lord.
counsel for the petitioner submits that he have paid PF for issuance of notice to respondent number 1 and 2. Office is directed to issue the notice immediately. Next.
Number 13, Prema Kumar AL.
Counsel for the petitioner is absent no representation. The petition is of the year 2020. Till date, respondents are not served. I do not find any reason to adjourn the matter, however, to afford final opportunity this time. Next.
Hearing on IA, serial number 14, Vandana PL, K. Narayan Swamy.
My lords, I appear for the petitioner, my lords. My lords, this application was filed seeking to dispense the production of certified copies of Annexure A and B, my lords.
What is A and B?
FIR and the PCR, my lords. But now we have the certified copies, my lord.
Produce it.
Please, my lords.
I'll dismiss this application.
Please, my lords.
Learned counsel for the petitioner submits that she is having the certificate copies of annexure A and B, and the same will be produced before the court. In view of the same, IA 1 of 2020 filed for seeking dispensation from producing certificate copy, annexure A and B dismissed. This time. Next.
My lords, interim order may kindly be extended.
Interim order is extended till next date of hearing. 15 days. Next.
My lords,
ಅವ್ರು ಕೊಡ್ತಾರೆ ತಗೊಳ್ಳಿ.
interim order may kindly be extended.
Yes, extend.
Serial number 15, Satish K. Column.
Here for the petitioner.
Yes. Who filed the application?
But state has filed.
Yes.
Last occasion, Lord, on 25/6/2024. After hearing the matter for some time, Lord, there is a direction to secure the investigation papers. 25/6, Lord.
25/6.
Yes, if I am correct, Lord. 25/6.
Investigating office, SGP to secure investigation papers.
Please, ma'am.
You have secured. You have secured it.
My lords, sir. Secured, my lords.
Yes, it is there.
Please.
Yes, you have filed IA 1 of 2024. You are pressing it, or can it be heard on merits?
Heard on merits, my lords.
Yes. Learned SGP submits that as per order dated 6/2024. Investigation papers collected and this and submitted that she is ready to address the arguments on merits. And counsel for the petitioner. Yes, ready.
Next week.
Pays for a week's time to address his argument on merits. In view of, as the matter could be disposed of after hearing. IA 1 of 2024 is dismissed. Both the learned counsel are directed to address their arguments on merits on next date of hearing without fail. Get ready and address your argument. Subject to the condition, interim order is extended. Yes.
For admission, serial number 16, Shams Ahmad Katan, Muzaffar Ahmad.
I'm appealing for response. 2 million. They have already given university the response.
Hmm?
Filing memo, we have retirement, and we have response 2 million.
For respondent number?
2.
2. When you filed the memo?
Memo,
ಈಗ
university ಕೊಟ್ಟಿದ್ದೀವಿ.
ಯಾರು?
ತಗೊಂಡೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ respondent 2 ನಮ್ಮಿಂದ.
Who is appearing for respondent number 2?
Respondent 2, Muzaffar Ahmad.
My lords, there was intimation on 27/2/2024, my lords. It was intimated that the petitioner counsel has expired.
Whom you are representing?
Your Lordship, the advocate on record has expired, Your Lordship. Notice has sent to the parties. Yesterday they came to me, Your Lordship. My wakalat is also there along with my senior.
Why the notice was issued to the petitioner when you are on record?
No, Your Lordship, they are not in my touch. They are in touch with my senior, Your Lordship. They are not my client. It is senior's client. Senior has lost the eyes, Your Lordship, at.
I'm not concerned about your senior, sir. What about you? When
Yesterday,
you filed wakalat?
along with my senior only, I have filed wakalat.
Still you hold you hold wakalat for petitioner.
I hold, Your Lordship, but I have no I had no instruction from the petitioners because they are directly contacted, they were directly contact with my senior. So yesterday only they have informed me that your lordship to continue with this, their wakalat, your lordship.
So you are asking the court to do your work,
No, your
to
lordship.
contact the party,
No,
get their wakala.
no, your lordship. I need some this
What
one.
is this, sir?
I will pay.
Why it should be done?
I will apply for this.
You are
one copy.
misleading the court.
Your lordship, I will, this one, I will prepare this.
When you are having the wakala, when you sign the wakala,
I brought,
why the notice is to be issued to the
your
petitioner?
lordship, I brought this before the honorable court, your lordship.
When,
Mm,
is it your submission, whether it was
I-
recorded?
I myself has informed that your lordship, the advocate has died.
Really, on which date? You are asking the court to do your clerical work, contacting the party and asking them to contact the council and sign the wakala.
Hmm.
Is it?
No, your lordship.
And pay the fees.
No, your-
When you have made the submission,
Date I don't remember.
go through it and make submission.
Serial number 17, T. Raghavan.
My lord, you post it day after tomorrow, my lord, on first. I'm for petitioner, my lord.
Seventeen,
Day after tomorrow, it may be posted.
why, sir? 2017 matter.
Yes, my lord. Advocate and record is not in session. He'll come tomorrow evening. Day after tomorrow, it may be posted.
Counsel, proxy counsel for the petitioner prays for time. And submit that the counsel on record will address the argument on the next date of hearing without fail. Criminal petition is of the year 2017. I do not find any reason to adjourn the matter. However, to afford final opportunity, listen. It is posted finally, sir. You have to
Yes.
address the argument on the next date of hearing. Next.
Sure. Much, lord.
Jay Prakash Rao, Balaji Raghunathan. For the respondent. Not the post memo was posted, my lord, my senior is out of station. Direction that is kindly.
Yes.
It may kindly be adjourned, my lord. Seniors.
Counsel for the respondent number 1 to 3, please for time. Both the learned counsel undertake to address their arguments on the next date of hearing without fail. Submissions are placed on record. Please come. Next date, both of you should address the argument.
Yes.
Yes.
Serial number 19, Vijay Kumar Prakash, Ganesh R.
Taking for 1 week time, inconvenience. Senior colleague is unaware.
Counsel for the petitioner prays for time. Counsel for the respondent is absent, no representation. Counsel for the petitioner undertake to address this argument on the next date of hearing without fail. The petition is, the submission is placed on record. List finally. at
Interim
the
order.
last chance. There was no interim order.
Interim order.
Next.
Serial number 20, Veeranath Jithivdi, Arvind Babu.
See, in the morning, they submitted, my lords, that a copy has not been produced to R2 and to the state, my lord.
Where is the counsel petitioner?
They submitted in the
Veeranath
morning. my lord.
Jithivdi.
Pass over.
Serial number 21 disposed, 22 urgent, 23 Keshav Murthy B, VB Ravi Shankar.
Yeah, pay for the petitioner. madam.
Have it, 23 now.
Yes, sir. In this case, the petitioner has challenged the issuance of notice against this petitioner. It is in page number 33, Your Honor.
Is the sole accused?
Yes, so accused. The respondent has filed a private complaint, making allegation of this property has been purchased by creating and fabricating documents. The PCR came to report to the Amruthalli police. The Amruthalli police have filed a B report. The matter was set down for the sworn statement. During that stage, the police have issued this notice in question, page number 33. Page number 33. Your Honor.
Yes.
Page number,
On the basis of the order passed by the magistrate.
no, the magistrate has not passed it. There is order sheet also produced. The entire order sheet I have produced before this court in page number 32. Is that 31 is our typed copy. Nowhere it has been,
When B report was filed,
B report has been filed, Your Honor, on 5/1/2018. Sorry, it has been filed on 8/8/2017 itself. Complaint notice was issued on 28/10/2017. The counsel for the complaint placed time on 5/1/2018.
is that order sheet?
Order sheet is, typed copy is in page number 31, Your Honor. The relevant page is in page number 32. 8/8/2017, the complaint absent, accuser absent, EA filed for accused, avoid final report and call on 27/10 in the left-hand side. B report submitted, concerned police put up with file. On 28/10/2017, issue notice to the complainant and by 5/1/2018. On 5/1/2018, the advocate for complaint pressed time to file objection to B report on 2/2/2018. The matter was set down for the complaint sworn statement partly recorded on 15/6/2018. The notice may kindly be looked at 27/10/2018.
Thereafter,
Thereafterwards, the memo, sworn statement was recorded, some document was marked. Thereafter, further statement was been, further recording of the
the
statement.
further development in the matter.
I have to verify, madam, in the trial court. I have
You
to
have to verify, sir.
I will verify. It is a old matter, it has been listed. But, on the prime,
Get it dismissed.
I will verify.
If
No,
you are not interested, why you have to keep the
I will-
petition pending?
I will verify. Day after tomorrow, I will verify in the trial court what has happened.
Very, very sad state, sir.
No, just I checked it, it is, B report accept agide anta bandide, I verified in the E court. I will verify in the trial.
You verify your counterpart. ಏನಾಗಿದೆ ನೋಡಿ order sheet. next.
Party is not, sir. I have to,
Kind submission.
day after
my lords.
tomorrow.
That's a kind submission in this regard, my lords. There is a direction to the concerned ACP to investigate into the matter and to submit a report, my lords. And that is still pending. And I seek a short adjournment to verify with the ACP of Amruthalli, my lords. I tried to contact from the morning, my lords, but I was unable to contact.
You can contact before 4:30, please, and make submission.
Yes,
Notice.
Serial number 24, Muduraj.
ಇದೊಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ ಸರ್. Petition may be infructuous, kindly dispose it as infructuous.
24, counsel for the petitioner submits that the investigating officer has already filed the charge sheet, hence the petition has rendered is become infructuous.
No.
Hence pays for dismissal of the petition. Commission memo ಹಾಕಿದ್ರೆ memo ಅಂತ ತಗೊಳ್ತಾರೆ. Based on that petition dismissed as the same is rendered infructuous. Yes, next.
Serial number 25, Raghavendra AV. AV Raghavendra.
Petitioner you.
So. Yes,
Opinion for the petitioner, Your Honor. Who is the petition is filed by the complaint, Your Honor. It's a 138 an act, Your Honor. The complaint has been dismissed for the non-prosecution, Your Honor. Dismissed for non-prosecution.
yes.
It's in
When
page,
you file the PCR,
the complaint has been filed, Your Honor, in the year of 2015, Your Honor. Nine seven 2015, the complaint has been taking a cognizance, Your Honor. Issue a notice to the accused. Accused has been present in the year of 2016, Your Honor. So the respondent has been
when
present
it was dismissed,
for the dismissed for non-prosecution duty on the COVID, Your Honor. Thereafter, the court has been issued a notice to the complaint. The notice has been not been duly served to the complaint, Your Honor.
when it was dismissed.
Dismissed, Your 26/12/2022, Your Honor. Was in the typed copy in the page number of 36, Your Honor. Of the court order sheet and the page, typed copy is the page number 43, Your Honor.
Yes, 2015, it was filed on 27/4/2015. Till 2022, no steps.
No, Your Honor, his accused has been regularly present, Your Honor. Thereafterwards, he has not been present before the court. And then issuance of NBW from the after the COVID, Your Honor, 4/3/2021, Your Honor. And then 8/9/2021 is also complaint, accused has not been present, Your Honor, issue NBW. Subsequently, Your Honor, thereafterwards, Your Honor, in the 3/9/2022, Your Honor, the court has been issued notice to the complaint, Your Honor.
But repeatedly, the NBW was issued. In
To the
spite of
accused,
that,
Your Honor.
the same could not be executed.
Because Your Honor, the matter has been likely be to settled, Your Honor. The out of the court has been the accused, who is the petitioner and the respondent has been talking over, Your Honor. Subsequently, after when the
Petitioner and the respondents were talking over phone.
for
But
the
he was
settlement,
not available for execution of the NBW.
for the settlement, Your Honor. Hence, the complaint is not be prosecuted, Your Honor. That's thing only, the complaint is not.
Why it is to be now restored?
Lordship,
To
for the-
talk to him and settle it out of court.
Lordship, because after that, the matter has been dismissed, Your Honor. The accused has been turned over.
Naturally, when you are not interested, why should the accused?
And
The
it,
court cannot be a platform for you to arm twist the accused.
when
When
the,
you are not interested, leave it.
this thing, Your Honor, thereafter, the complaint has been, he has been suffered a lot, Your Honor. that
ಅದೇನೋ
thing.
ಗೊತ್ತಿಲ್ಲ sir, no. But no reasonable grounds.
Give a chance to the,
ಏನು ಇಲ್ಲ, ಏನು ಇಲ್ಲ.
only the dismiss for non-prosecution, that's thing, Your Honor.
Yes.
Because
What is the course open to the trial court?
The complaint
When
is
the
not,
complainant is not present, he is not taking steps for issuance of NBW.
thereafter, the court has been issued,
Repeated NBW was issued, it was not executed.
thereafter, the court has been issued a notice to the complaint. The notice is also not been due to serve to the complaint is also.
So now in ನಿಮ್ಮ ಮನೆಗೆ ಬರ್ಬೇಕಿನ್ನು.
Sorry, Your Honor.
Complainant was absent, advocate was absent, accused was absent,
I will be
and the court has to maintain this file forever.
given opportunity to
To
you,
enable you to speak over the phone and
Not-
compel to compromise.
not like that, Your Honor. Because kindly given opportunity for the 6 months, Your
ಇವೆಲ್ಲ
Honor.
ಇದ್ ಮಾಡಲ್ಲ.
ಅಲ್ಲ, speedy disposal ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. We are the, within the 6 months.
Disposal ಯಾರ್ ಮಾಡ್ಬೇಕು sir?
This honorable court has been given direction to the.
Direction I will give. Who has to dispose
I-
of it
In the
speedily?
meanwhile, I keep the, secure the accused and keep the present to the court, Your Honor.
Mhm.
Look, kindly it may please issuance of to the respondent also matter be likely be settled, Your Honor.
Settle ಮಾಡ್ಕೊಡಿ.
ಅಲ್ಲ,
ಮಾಡ್ಕೊಡಿ.
this honorable court has
Nothing.
been issued notice to the respondent.
No.
Even till respondent is not been appeared before the court, Your Honor.
Order sheet ಕೊಡಿ. Order and response to the petitioner. The petitioner complainant has filed a PCR before the trial court on 27/4/2015. Even though the accused has appeared before the trial court, there was no progress in the matter. Later, the accused remained absent and the NBWs were issued repeatedly. But the same could not be executed. On subsequent dates of hearing, neither the complainant was present, nor his counsel was present, and the accused could not be presence of the accused could not be secured. Noting all these facts and circumstances, the trial court passed the impugned order dismissing the complaint for default. Next paragraph. It is the contention of the learned counsel for the petitioner that the complainant and the accused were in touch with one another over phone, and they were trying to settle the dispute amicably. But in the meantime, the court proceeded to dismiss the complaint, and on such grounds, he prays for restoration of the petition. The very submission made by the learned counsel for the petitioner discloses that the complainant remained absent deliberately before the trial court. And even the notice that was issued to the complainant was unserved. Under such circumstances, the petition cannot be allowed to restore the complaint, to enable the complainant to arm twist the accused and hoodwink the court by trying to compromise the matter out of court without being present before the court. Under such circumstances, I do not find any reason to entertain the petition dismissed. Dismissed.
Hearing B group, serial number 26, Mustafa Ahmed, Rajesh Shettigar.
On the record, Advocate Mr. Mustaq Ahmed is not well, my lord.
Counsel for, proxy counsel for the petitioner, please for time.
Senior citizen
So,
is not well, my lord.
proxy counsel for the petitioner, please for time. He submits that the counsel for the petitioner undertakes to address his argument on the next date of hearing without fail. Submission is placed on record, list file.
Interim order may kindly be extended, my lord.
Subject to the above condition, interim order is extended. No further date will be given.
Serial number 27, Prasanna Kumar S.
I appear for the petitioner, my lords. Lords, I pray for time, my lords, in this matter. We have engaged a senior counsel. My lords, we have engaged a senior counsel, my lords, and there is an inconvenience today.
Counsel for the petitioner, prays for time. The petition is of the year 2020. I do not find any reason to extend the matter, however, to afford final opportunity. Next.
Serial number 28, K. Satish, E.B. Patil.
For the respondent number 3, Your Lordship. Respondent number 3 needs to be treated with locate, Your Lordship.
Yes.
Respondent number 3 needs to be treated with locate. ACB not enforced.
I could not understand.
But
Respondent
the
number 3 locate can matter for me. ACB.
ಮಾಡಿದಾರ ಕೊಡಿ ನೋಡೋಣ ಯಾಕೆ
but at the time of my lord filing the writ petition, but anti-corruption bureau was in force. But in its place, my lord, this honorable court has declared that my lord, anti-corruption bureau is unconstitutional. But in its place, my lord, the Lokayukta police is to be.
ಅದಾಯ್ತು. Why the Lokayukta police is respondent number 3? ಈಗ ಏನು, what is the relief you are seeking in this?
If it is under section 17A of PC Act, Your Lordship. They have challenged the order.
My lord, the first relief, my lord, they have sought for the quashing of the order constituting ACB, my lord. That has become infructuous now, my lord, and they have sought for the quashing of the complaint
registered by ACB. Now
That-
ACB matters are transferred to Lokayog.
Insofar as first relief is concerned, my lord, it does not survive any of
Yes,
the
Hmm.
order of the honorable division bench. Second prayer, my lord, survives. But
Secondarily, you have clubbed both
only
the
one prayer,
prayers.
my lord, ಎಲ್ಲದ್ರಲ್ಲೂ.
There is only one prayer.
the portion,
No second prayer.
portion of my lord, first prayer does not survive.
Prayer ಮಾಡ್ತೀರಿ ಅಂತಾನೆ ಗೊತ್ತಾಗಲ್ಲ ನನಗೆ.
But at that time, my lord, it was anti-corruption bureau was in place.
ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು. Is it the way of making the drafting the prayer column? ಎಲ್ಲದನ್ನು ಕಮ ಹಾಕೋದು ಎಷ್ಟು ಪ್ರೇಯರ್ ಇದೆಯೋ ಅದೆಲ್ಲದು ಕಮ ಕಮ. Yes, now what is the stage in crime number 13 of 17?
Lordship, I need to seek instruction regarding this.
I think there is a stay in the matter, my lord.
Stay there.
Stay the matter ಅಲ್ಲಿ. That
I'll
complaint-
locate that. Find out what is the stage.
But there is an interim order to the effect that, not in view of the order passed by the division bench, my lord, where there is a direction that, my lord, not to file charge sheet. Is the interim order grant?
Investigation is completed.
That I need to seek instruction.
Sir, this is the bare requirement. When you file an wakalat, you are supposed to know.
Please, Lordship, I
Then
appear.
why are you before this court?
Lordship, I appear for respondent number 3, Lokaयुक्त, Your Lordship.
Ah.
He has challenged the order of government, Your Lordship. Respondent number 1 is HCGP, Your Lordship. I'll file my formal objection regarding this, Your Lordship. As
Immediately.
pertains to the trap case where the petitioner herein is involved, I need to seek instruction regarding on the basis of crime number, Your Lordship. In this, crime number is not annexed, Your Lordship, whereas FIR is not annexed.
You have the crime number.
C. Next year C. is
Can you not
crime.
verify with the crime number?
Please, I'll
Why are you giving the lame excuse?
I'll seek instruction Your Lordship, regarding the investigation of the state.
Sir, you are representing a very prestigious institution.
Please.
You should know that.
Please.
Is it the way of safeguarding the interest?
Seek instruction regarding.
Then it is not sufficient to stand up and say, I am representing so and so. You owe a duty.
Yes.
Neither you are assisting the court, nor you are safeguarding the interest of the respondent number 3. So you are happy with the mere filing of the wakalat and saying that I am representing so and so. ಇದಕ್ಕೆ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರಾ ಎಡ್ಯುಕೇಶನ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು ಇಷ್ಟೇನಾ? ಐ ಫೈಲ್ಡ್ ವಕಾಲತ್, ಐ ರೆಪ್ರೆಸೆಂಟ್ so and so. What is the stage? I don't know. I seek instructions. ಎಲ್ಲಿಂದ ಕಲ್ತ್ಕೊಂಡ್ ಬರ್ತಿರೋ? Counsel for respondent number 3 prays for time to get instructions and to make his submissions. The writ petition is of the year 2020. Counsel for the petitioner and respondent number 3 are directed to verify the stage of the investigation that is pending before respondent number 3 and to make their submission without fail. List on. Next. ಅವರಿಗೆ ಇಲ್ದಿದ್ದು ನಿಮ್ಗೆ ಯಾಕೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ? ಎಸ್ ನೆಕ್ಸ್ಟ್. ಸರ್, ಸ್ವಲ್ಪ ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ ನಿಮಗೆ ಮನಸ್ಸಿದ್ರೆ ವಕಾಲತ್ ಹಾಕಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬರಬೇಡಿ ದಯವಿಟ್ಟು.
Apologies, Your Lordship. I'll seek.
Don't feel proud that you have filed the wakalat for so and so.
Interim order may be extended.
Next.
Not till date, my lord, there is an interim order. It may be extended, my lord.
Extend ಮಾಡಿ.
Serial number 29.
Appearing for the petitioner, my lord. I seek week's time. Kindly have it next week, my lord.
Yeah, okay.
We are engaging senior counsel in this matter, ma'am.
Counsel for the petitioner prays for time.
My lord, there is interim order.
There is no interim order, sir.
My lord, it's there.
Please show me where is the interim order. ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಹಿಂದಿಂದು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಲಿ ಅವ್ರು. ಸುಮ್ಮನೆ ಮೆಕ್ಯಾನಿಕಲಿ ಇಂಟ್ರಿಯಮ್ ಆರ್ಡರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ವೇರ್ ಇಸ್ ದಿ ಇಂಟ್ರಿಯಮ್ ಆರ್ಡರ್? ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ.
My lord, there was the interim order granted on 16/7/2021.
ಏನಾಯ್ತು? ಅದ್ರ ಮೊದಲು ಇರ್ಬೇಕಲ್ವ ಇಂಟ್ರಿಯಮ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
My lord, I have a copy.
Read this order. You please read that order.
10:21.
So and so appears for the physically and represents Lata Shetty, learned senior counsel for the petitioner. Learned senior counsel submits that the interim stay granted earlier has been extended by virtue of the stay order in by order dated 13/7/2021 in passed in WP 6435 of 2020. Hence, the praise for interim order to be extended in the writ petition till 2/8/2021.
So you prayed for extension of interim order. What is the order passed by the court?
Your court still submits it.
Your application for extension of interim order was disposed of. ಅಲ್ಲಿ ಏನಾದ್ರು extended ಅಂತ ಇದೆಯಾ order?
No.
Then how can you seek every date of hearing, extend the interim order, extend the interim order? Unfortunately, we are also extending the interim order. Where is the interim order? Is it not misleading the court?
Fine.
Then what action is
For
to
the
be
last
initiated?
This
And
is
you
all.
still maintains interim order. It is nothing but misleading.
I'm sorry, my lord.
ಕೊಡಿ. ನಮ್ಮವರು ಹಿಂದೆ ಮುಂದೆ ನೋಡೋಣ. ಇಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಬಿಡೋದು. ನಮ್ದಲ್ಲ, ನಮ್ಮ ಅಪ್ಪಂದಲ್ಲ. Counsel for the petitioner prays for time. He undertakes to address the argument on the next date of hearing without fail. Submission is placed on record. Subject to the condition that the counsel for the petitioner addresses his argument on the next date of hearing Interim order is extended till next date. List finally as a last.
Sorry, ma'am.
Next.
Serial number 30, Vijay Kumar Bhatt, additional SPP.
This case, my lord, we have to file a report. As per the interim order passed by this honorable court on 16/3/2020, there was a direction to the police to submit the report.
What report?
The two FIRs has been filed against the petitioner. The annexure A and B.
My lord, I pray for some time in the matter, my lord. 2 days accommodation may be granted.
I have produced the photographs.
4 years have already lapsed.
Yes, my lord. I got the instruction that, my lord, charge sheet has been filed and it is committed to the sessions court also. With respect of the other accused, my lord. I'll secure those papers, my lord, and I'll make my submission. 2 days time may be given, my lord.
Because my client is at Karur. I have produced the CC.
1 minute.
Their ground was that the plea of
1 minute,
LEB.
madam. Within 7 days on the March 2020.
After that, Corona.
After that, ಅವಾಗ್ಲೇ ಇತ್ತು. Again, July 2021, again it is reiterated and directed the police.
Yes, ma'am.
They must have held a preliminary inquiry as directed by this court. Please verify.
Yes, my lord. 2 days accommodation.
This court today order dated
60.
19, on 16/3/2020. Director. The Banshankari Police and Subramaniapura Police, who registered crime numbers 16 of 2020. Both crime number 16 of 2020.
ಹೌದು.
Huh?
ಒಂದೇ ದಿವಸನೇ 2 ಕ್ರೈಮ್ ನಂಬರ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದು 12:30 ಒಂದು 1:30.
Registered in both the police stations. Comma. To hold a preliminary inquiry regarding the plea of LEB raised by the petitioner and to submit the report within 7 days. But however, no such report is submitted. Again on again on 19/7/2021. The coordinate bench of this court once again reiterated his order and directed to submit the report. And also to find out the status of the case. But till date, no report is received. On the other hand, under SGP, taking time to get instructions in the matter. Even though I do not find any justification for adjourning the matter. List finally as a last chance. Yeah, okay. Next
Interim
Monday.
order may be extended. Madam.
Monday. Next, interim order idre extend ಮಾಡಿ. Yes, but you have to get ready to address the argument.
Please.
And
Yes,
in the
madam.
meantime, you have to submit the report. Next.
Serial number 31, Umesh L, Alima Banu, Alima Amin.
ಅದು 32 na. Hmm? Counsel for the petitioner and the respondent, number 3, are absent, no representation. It is noticed that on 31/1/2022 and again on 31/3/2022, there was no representation. The counsel for the petitioner had not appeared before the court, but it was only the counsel representing respondent number 3 present. The petition is of the year 2020. We do not find any reason to adjourn the matter, however, to afford final opportunity list on.
Serial number 32, Natraj Balal, Prasanna VR.
Appear for the first test point, my lord.
I am for the petitioner,
Yes,
seeking time for.
My lord, in this case, my lord, the order impugned has already been confirmed by the Honorable Court in another criminal petition 67 of 2018 filed by the first respondent, my lord. The articles of the temple were directed to be handed over to the petitioner, my lord, earlier, the first respondent earlier. Then, my lord, at the
is the
final,
impugned order.
my lord, impugned order is, my lord, annexure E, directing the,
Allowing the application under 457.
yes, my lord. But where, my lord, the learned sessions judge, my lord, directed the petitioner to hand over the articles to the assistant commissioner. The assistant commissioner, my lord, is directed to take the possession of the articles belongs to the temple because it is a notified institution.
Now, where is the order passed by the coordinate bench of this court?
My lord, that, my lord, I will place it on record, my lord. Criminal petition 67 of 2018, my lord, day after tomorrow or, my lord, any other day. I have challenged the very same order, my lord, before this honorable court, saying that I am the president of the committee of management, and earlier, my lord, the certain materials have been directed to be handed over to me as a president of the committee. However, my lord, this honorable court was pleased to hold that, my lord, the temple belongs to the under the supervision of the government, being a notified institution. It is the assistant commissioner who is the authority to possess all the
But
assets.
why you have not placed that order before this court?
My lord, I will place it, my lord. Now, my lord, I have traced, my lord, tomorrow or day after tomorrow, my lord, so let me have this matter, my lord, so that I can place it.
Submit that the order impugned in this petition is already confirmed by the coordinate bench of this court. He prays for 2 days' time to produce the copy of the said order this time. Next.
Serial number 33, Ayappa KG, Archana
Please,
Trimurthy.
apply.
It's appearing for the petitioner, my lords. The petitioner, my lords, petition number 1 is the editor of a news daily in Coorg, my lords, Kaveri Times. Petitioner number 2, my lords, is the reporter.
Petition number 2.
Sorry, apologies. Petitioner number 1 is the editor, petitioner number 2 is the news reporter, my lords.
Yes.
Lords, the complaint that is, which is the impugned complaint in this petition
is at page number 21, Annexure C, my lords. FIR is Annexure D, page number 23. 23 of the petition, my lords. That is the FIR, Annexure D. 21 is the complaint. Present petition is to challenging this FIR and complaint, my lords. Lords, the allegation against the petitioners is that they published certain articles in their newspapers, which are in a which criticize the respondent number 3 and 4's actions, my lords. And the allegation is that these articles have a nature of inciting communities against each other and causing riots. My lords, I will take my lords through the complaint averments, my lords.
Yes.
On page number 21. The respondent number 2 is a Shirastedar connected with respondent number 3's office, my lords. Respondent number 3 is IPS, respondent number 4 is IAS. Both were serving in the district administration at the time of the impugned FIR. Annexure C, page 21, the complaint, my lords. I will just read out the complaint averments. Manyare, ನಾನು ಕೊಡಗು ಜಿಲ್ಲಾ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರ ಕಚೇರಿಯಲ್ಲಿ ಶಿರಸ್ತೇದಾರನಾಗಿ ಕರ್ತವ್ಯ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 4/5/2020 ದಿನಪತ್ರಿಕೆಯಾದ ಕಾವೇರಿ ಟೈಮ್ಸ್ ನಲ್ಲಿ ಪಿ ಮತ್ತು ಸಿ ಯೊಳಗೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ಮತ್ತು ಪ್ರಾಕೃತಿಕ ದುರಂತ ಎಂಬ ಶೀರ್ಷಿಕೆಯಡಿಯಲ್ಲಿ ಕೊರೋನಾ ಮುಕ್ತವಾದ ಕೊಡಗು ಜಿಲ್ಲೆ.
I have already read it.
Lords, my lords.
So read it next.
Yeah, my lords. The relevant article, my lords, is that the article which forms subject matter of the complaint is at page number 27, my lords. And the other article is at page number 28. So, my lords, a plain reading of the complaint will reflect that the articles which are published in the newspaper run by petitioner number 1 and 2 are only critical of the district administration. They are in no way connected with any of the offenses. The offenses invoked against the petitioners are 153, 505(1)(b), 505 clause 2 and 34, my lords. They are no way involved. But my lords, if I may read out the language, my lords, of 153. Section 153, my lord, of the IPC.
Yes.
Wantonly giving provocation with intent to cause riot, if rioting be committed, if not committed. Whoever malignantly or wantonly, by doing anything which is illegal, gives provocation to any person, intending or knowing it to be likely that such provocation will cause the offense of rioting to be committed, shall, if the offense of rioting be committed in consequence of such provocation, be punished with imprisonment of either description for a term which may extend to 1 year or with fine or with both, and if the offense of rioting be not committed, with imprisonment of either description for a term which may extend to 6 months or with fine or with both. This is 153, my lords. 505, my lords, of IPC. Statements conducing to public mischief. 505, my lords. Whoever makes, publishes, or circulates any statement, rumor, or report, A, with intent to cause or which is likely to cause any officer, soldier, sailor, or airman in the Army, Navy, or Air Force of India to mutiny or otherwise disregard or fail in his duty as such, or B, with intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against the public tranquility, or with intent to incite or which is likely to incite any class or community of persons to commit any offense against any other class of community. The relevant portion here, my lords, is 505(1)(b), which is with intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against the public tranquility. My lords, in the entire complaint averments, the articles that are impugned they only say, ಕೊಡಗು green zone ಆಗಿದೆ, red zone ಯಾವಾಗಾಯ್ತು, dealing ಮಾಡ್ತಾ ಇದ್ದೀರಾ? And these are all questioning the district administration. Subsequently, Corona, when the impugned articles were published, your first wave of COVID was happening. So they have posed some questions where respondent number 3 has made a film about flood relief that she is undertaking. And she spent around 2 lakhs for that.
Is it the language that could be used by a reporter? By
But
an editor?
The reporter, my lords, he just says he's questioning the district administration.
Questioning it is okay.
Please.
What is the wordings that are used
I will just
against the district administration?
I'll just read out the relevant portion, my lords.
What is the heading?
Corona P and C ಇವಳಿಗೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ಮತ್ತು ಪ್ರಾಕೃತಿಕ ದುರಂತ. This is the heading of the
Annexure J, I am asking. ಎಲ್ಲಿದೆ ಅದು? J, why you are produced?
My lords, the relevant annexures here are only annexure E and F, my lords. They are the 2 articles on the strength of which
Why you
the
have produced annexure J?
my lords, that is not relevant, my lords. Apologies.
Why you have produced?
Apologies, my lords. Not relevant to the case. It is only annexure F and annexure E, my lords, which are
There must be some reason to produce this annexure J.
apologies.
An apology.
Produced earlier, my lords.
See the language used in that.
Those articles don't form subject matter of the.
Then why you produce it as annexure?
Fourth estate, apologies. Regret the apology. So the relevant annexes is only E and F, my lords. That's all. So E and F, they say P ಮತ್ತು C ಒಳಗೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ಮತ್ತು ಪ್ರಾಕೃತಿಕ ದುರಂತ, page number 27. ಅಲ್ಲಿ page number 27 ಸ್ವಾಮಿ. ಆಮೇಲೆ annexure F dated 9/6/2020 ಅದರಲ್ಲಿ ಕಾವೇರಿ ಟೈಮ್ಸ್ ಕಚೇರಿಗೆ ತಲುಪಿದ ಅನಾಮಧೇಯ ಪತ್ರ, page number 28. ಇಷ್ಟೇ ಸ್ವಾಮಿ. ಈ ಎರಡೇ articles are the strength on which the criminal prosecution is initiated against the petitioners, my lords. In these, they are just asking some basic questions. Apart from that, there is nothing to invoke the offenses under 153 or 505, my lords. If I may just read, my lords, in the complaint only, on page 22. ಇದರಲ್ಲಿ ಕೊರೋನಾ ಮುಕ್ತವಾದ ಕೊಡಗು ಅಂತ ಇದೆ, page number 27 ಅಲ್ಲಿ. It is the second column from the left and first paragraph. So second column from the left and first paragraph. ಅಲ್ಲಿ ಒಂದು asterisk mark ಇದೆ ಅದ್ರ ಕೆಳಗಡೆ. That is the relevant portion. So
Yes.
ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಕೊರೋನಾ ಮುಕ್ತವಾದ ಕೊಡಗು ಜಿಲ್ಲೆ ಗ್ರೀನ್ ಝೋನ್ ಆಗಿದೆಯೋ ಅಥವಾ ಡೀಲಿಂಗ್ ಝೋನ್ ಆಗಿ ಮಾರ್ಪಾಡಾಗಿದೆಯೋ ಎಂದು ಕೊಡಗು ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕಿ ಡಾಕ್ಟರ್ ಸುಮನ್ ಪನ್ನೇಕರ್, ಜಿಲ್ಲಾಧಿಕಾರಿ ಅನೀಸ್ ಜಾಯ್ ಕಣ್ಮಣಿಯೇ ಜನತೆಗೆ ಉತ್ತರಿಸಬೇಕು. ಈ ಇಬ್ಬರು ಅಧಿನಾಯಕಿಯರನ್ನು ಜನತೆ ಹೊಗಳುತ್ತಿದ್ದಾರೆ. ಕೆಲವರು ರೆಡ್ ಝೋನ್ ಎಂದು ಘೋಷಣೆ ಆಗಿರುವ ಮೈಸೂರಿನಿಂದ ಕೊಡಗಿನೊಳಗೆ ನುಸುಳಿ ತಿತಿಮತಿಯಲ್ಲಿ ಅಲೆದಾಡುತ್ತಿದ್ದಾರೆ ಎಂಬ ಗಂಭೀರ ಆರೋಪ ಕೇಳಿ ಬಂದಿದೆ. ತಿತಿಮತಿ ಆನೆ ಚೌಕೂರು ಮೂಲಕ ನುಸುಳಲು ಪ್ರಯತ್ನಿಸಿದಾಗ ಸಾಧ್ಯವಾಗಲೇ ಇಲ್ಲ, ಆದರೆ ಮಾಲ್ದಾರೆ ಚೆಕ್ ಪೋಸ್ಟ್ ಮೂಲಕ ತಲುಪಿದೆವು ಎಂದು ತಮ್ಮ ಸಾಹಸಕತೆಯನ್ನು ಕೇಳಿ ಮೈ ನವಿರೇಳಿಸುತ್ತಾರೆ. These are all reports from the ground, my lords. That is being.
There must be some meaning to that. ಸುಮ್ನೆ ಸೆನ್ಸೇಷನ್ ಆಗಿ ಏನೋ ಬರೆದ್ರೆ ಆಯ್ತಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. This is just reporting, my lords. What is?
You specifically named 2 officers.
Please, my lords.
But what is the basis? What is the allegation? I could not understand.
The allegation is that
ನುಸುಳ್ತಾ ಇರೋರು ಯಾರು? ಎಲ್ಲಿಂದ ನುಸುಳಿದವರು?
ರೆಡ್ ಝೋನ್ ಇಂದ ಸ್ವಾಮಿ. ಮೈಸೂರಿಂದ,
ಯಾರು?
ಮೈಸೂರು ರೆಡ್ ಝೋನ್. ಜನರು ನಾರ್ಮಲ್ ಪೀಪಲ್ ಹೂ ಆರ್ ಇಂಟು ರಿಯಲ್ ಎಸ್ಟೇಟ್, ಲ್ಯಾಂಡ್ ಮಾಫಿಯಾ, ಅವರು ರೆಡ್ ಝೋನ್ ಇಂದ ಇಲ್ಲಿ ಕೊಡಗು ಗ್ರೀನ್ ಝೋನ್ ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ ಅಂತ. That is the allegation, ಅಷ್ಟೇ. This is only reporting. He is only asking. This is the question that is being asked to the district.
ಅಷ್ಟು ಈಸಿ ಆಗಿ ಆಗೋದಿಲ್ಲ. You should justify. What is that?
Given a short adjournment, I will just.
I will not. Please.
ಅಲ್ಲ, ಒಂದು short adjournment ಕೊಟ್ಟರೆ ಸ್ವಾಮಿ.
Please proceed.
ಒಂದು
Let me understand what you are trying to say.
Please. ರೆಡ್ ಝೋನ್ ಇಂದ ಮಾಲ್ದಾರೆ ಚೆಕ್ ಪೋಸ್ಟ್ ಮೂಲಕ ಸುಮ್ಮನೆ ಬರಲು ಸಾಧ್ಯವಿಲ್ಲ ಅಲ್ಲವೇ? ಹೀಗಾದರೆ
Then what is the red zone?
red zone, my lords, red zone and green zone according to the land use, my lords.
What is the definition
red
or
zone-
meaning?
Green zone andre where you cannot start commercial activities on a whole.
Eಲ್ಲಿದೆ ಅದು definition ಇಲ್ಲಿ?
Definition is there in the zoning laws, my lords. I've not produced it here.
Hmm.
So that is the definition, my lords.
Okay.
My
green
understanding.
zone, ಏನು prohibited area?
Howದು prohibited.
For-
Prohibited for commercial activities.
Next.
So this is one allegation.
ಅಲೆದಾಡುತ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಅಲ್ದಾಡೋದು prohibited.
ಅಲ್ದಾಡ್ತಿದ್ದಾರೆ ರೆಡ್ ಝೋನ್ ಇಂದ ಗ್ರೀನ್ ಝೋನ್ ಬಂದು they are making use of the land ಅಂತ. And what are these two people do?
ಅಲ್ದಾಡುತ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ making use of the land ಅಂತ.
ಅಲ್ಲ ಅಲ್ದಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಜಸ್ಟ್ ಇನ್ ಕೊಲೋಕಿಯಲ್
Word ಇರೋದು
ಅಲ್ದಾಡ್ತಿದ್ದಾರೆ. ಹೌದು ಕೊಲೋಕಿಯಲ್ ಸೆನ್ಸ್ ಅಲ್ಲಿ ಅವ್ರು ಇಲ್ಲಿ ಸುತ್ತಾಡ್ತಾ ಇದ್ದಾರೆ ಅಲ್ಲಿ ಬಂದಿರೋರು.
Is it prohibited?
No, the meaning of this ಅಲ್ದಾಡ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ they are looking to convert this green zone also into red zone in an unauthorized manner. And what are the what is it? R3 and R4?
ಯಾವ ಡಿಕ್ಷನರಿ ಮೀನಿಂಗು? ಅಲೆದಾಡುತ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ರಿಯಲ್
No,
ಎಸ್ಟೇಟ್
no,
ಮಾಡ್ತಾ
that
ಇದ್ದಾರೆ.
is they are coming from ಅಲ್ದಾಡ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ that is the connotation. Similarly, page 28 also annexure F ಅಲ್ಲಿ
ಇರಿ ಅಲ್ಲಿ ಮುಗಿಲಿಲ್ಲ.
ಅಷ್ಟೇ ಅಲ್ಲಿ ಅಷ್ಟೇ ಸ್ವಾಮಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಷ್ಟೇ. The rest is not relevant for that. Only this one paragraph. That is in complaint allu they only speak about this portion. The rest is about different issues. This is one paragraph.
No, there is further.
ಅದು ಕೆಳಗಡೆ ರೆಡ್ ಝೋನ್ ನಿಂದ ಮಾಲ್ದಾರೆ ಚೆಕ್ ಪೋಸ್ಟ್ ಮೂಲಕ ಸುಮ್ಮನೆ ಬರಲು ಸಾಧ್ಯವಿಲ್ಲ ಅಲ್ಲವೇ? ಹೀಗಾದರೆ ತಬ್ಲಿಗಿಗಳು, ಕೊರೋನಾ ಪೀಡಿತರು, ಹೋಮ್ ಸ್ಟೇಗಳಲ್ಲಿ ಉರುಳಾಡುವವರು ನುಸುಳುವುದಿಲ್ಲ ಎಂಬುದು ಏನು ಖಾತ್ರಿ ಎಂದು ಜಿಲ್ಲೆಯ ಜನತೆ ಪ್ರಶ್ನಿಸುತ್ತಿರುವುದರಲ್ಲಿ ವಾಸ್ತವವಿದೆ ಅಲ್ಲವೇ? ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕಿ ನಿಯಮ ಉಲ್ಲಂಘಿಸಿ ಬಂದಿರುವವರು ಯಾರು ಎಂದು ಪತ್ತೆ ಹಚ್ಚುವುದರೊಂದಿಗೆ ನುಸುಳಲು ಸಹಕರಿಸಿದವರು ಯಾರು ಎಂಬುದನ್ನು ಪತ್ತೆ ಹಚ್ಚಿದರೆ ಗ್ರೀನ್ ಝೋನ್ ನಲ್ಲಿ ಜನ ನೆಮ್ಮದಿ ಮತ್ತು ನಿರಾತಂಕದಿಂದ ಬದುಕಬಹುದು ಎನ್ನುವುದು ಜನತೆ ಒತ್ತಾಯ. Apologies. The red zone and green zone here refers to the government's categorization during COVID, my lords. Red zone ಅಂದ್ರೆ ಜಾಸ್ತಿ ಕೋವಿಡ್ ಇನ್ಫೆಕ್ಷನ್ಸ್ ಇದೆ, ಗ್ರೀನ್ ಝೋನ್ ಅಂದ್ರೆ ಕಡಿಮೆ ಇದೆ ಅಂತ ಹೇಳಿ. This was the categorization, not the land zoning.
ಮತ್ತೆ ಏನೋ ಹೇಳ್ತೀರಾ ಅಲ್ಲೆಲ್ಲೋ ಇದೆ ಝೋನ್ ಅಲ್ಲೋ ಇದೆ.
ಇಲ್ಲ, that is another definite, but here in the context of this article it is with respect to COVID. So I apologize. With respect to COVID. So red zone ಮೈಸೂರಲ್ಲಿ ಜಾಸ್ತಿ ಕೋವಿಡ್ ಇದೆ, ಅವರು ಗ್ರೀನ್ಸ್ ಬರ್ತಾ ಇದ್ದಾರೆ.
ರೆಡ್ ಝೋನ್, ಗ್ರೀನ್ ಝೋನ್, ಏನೋ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಅಲೆದಾಡೋದು ಅಂದ್ರೆ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮಾಡೋದು ಎಲ್ಲದನ್ನೂ ಹೇಳ್ತೀರಿ.
Apologies. This is in COVID context. I apologize. COVID context. I've only looked at one para. Second para I've missed. Apologies for that. It's COVID. ಇವ್ರು ಏನು ಮಾಡ್ತಿಲ್ಲ, ರೆಡ್ ಝೋನ್ ಇಂದ ಗ್ರೀನ್ ಝೋನ್ ಬರ್ತಿರೋರ್ನ ದೇ ಆರ್ ನಾಟ್ ಸ್ಟಾಪಿಂಗ್ ದೆಮ್. ಅಂಡ್ ಹಿಯರ್ ಇಲ್ಲಿ ಕೋವಿಡ್ ಪೀಡಿತ ಆಗ್ತಾ ಇದೆ ಕೊಡಗು, ಎಲ್ಲಿ ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ R3 and R4 ಅನ್ನೋ ಒಂದು ಪ್ರಶ್ನೆನ ಇಲ್ಲಿ ದೇ ಆರ್ ಪುಟ್ ಥ್ರೂ ದ ಆರ್ಟಿಕಲ್. ಸಿಮಿಲರ್ಲಿ annexure F, page 28 ಅಲ್ಲಿ.
Return to the district administration regarding that earlier to publishing of this.
I'll have to
news
seek
item.
instructions.
Have you helped the district administration in any manner?
I have to seek
Whatever the
instructions.
information received by you as a editor or press reporter,
Please, ma'am.
have you communicated it to the district administration?
That I'll have to seek instructions. Not aware of that.
You have not stated anything in your petition.
No, as a petition, it just refers to the complaint averments, my lords. I've told that it's the freedom of the press and I've taken the.
ಆಯ್ತು. Freedom of press ಆದ್ಮೇಲೆ you owe a duty as a press reporter.
I'll just seek instructions on this. Any date may be given next week. I'll
It
seek
is not
instructions.
your privilege to comment the district administration by referring to the officer by name
Please, ma'am.
and making defamatory words, addressing them in such a bad light.
Please. Ma'am. Any date next week, my lords. I'll just seek
Date
instructions.
ಕೊಡೋದೇ ಇಲ್ಲ. It will be disposed of today.
Short
Don't
adjournment.
be under the impression.
ಇಲ್ಲ, so short
ಏನಾದ್ರು
adjournment.
question ಕೇಳಿದ ಕೂಡಲೇ date ಅಂತ
ಇಲ್ಲ,
ಕೊಟ್ರೆ
sir, ಆತರ
ಹೋಗುತ್ತೆ.
ಅಲ್ಲ.
Don't be under the
Short
impression.
adjournment. This
You have to
generally,
justify your petition.
please, my lords, even if we construe this as defamation, a FIR cannot be registered for the same, my lords.
Yes.
153 ಮತ್ತೆ 505 ಕೆಳಗಡೆ ಬರಲ್ಲ. Defamation ಅಂದ್ರೆ ಇದೆ separate section.
Why 505B could not be invoked?
From here, I'll just read out the relevant portion of the complaint, sir.
ಆಯ್ತು, ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಆಯ್ತು. ಮತ್ತೆ
Complaint ಅಲ್ಲಿ last one paragraph ಅಷ್ಟೇ. Page number 22. Page 22, the third paragraph from bottom. Page 22 or second paragraph from top. So. ಇದರಿಂದ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರಾದ ಶ್ರೀಮತಿ ಅನೀಸ್ ಕಣ್ಮಣಿ ಜಾಯ್ ಅವರ ಗೌರವಕ್ಕೆ ಧಕ್ಕೆ ಉಂಟಾಗಿರುವುದಲ್ಲದೆ ಸಾರ್ವಜನಿಕರು ಪ್ರಚೋದನೆ ಮತ್ತು ಉದ್ವೇಗಕ್ಕೆ ಒಳಗಾಗಿ ಸಮಾಜದಲ್ಲಿ ಅಶಾಂತಿಯ ವಾತಾವರಣವನ್ನು ಉಂಟು ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಯಾವುದೇ ಸತ್ಯಾಸತ್ಯತೆಯನ್ನು ಅರಿಯದೆ ವರದಿಗಾರ ವಸಂತ್ ಹಾಗೂ ಸಂಪಾದಕರು ತಮ್ಮ ಕಾವೇರಿ ಟೈಮ್ಸ್ ದಿನಪತ್ರಿಕೆಯಲ್ಲಿ ಪ್ರಕಟಪಡಿಸಿರುತ್ತಾರೆ. This is the one bit that speaks about the ingredients. However, ತಾವು 505 ನೋಡಿದ್ರೆ clearly says with 505 1B with intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against public tranquility. Here, through the articles, my lords, I am not trying to induce the public. I am only asking some questions to the district.
Cannot have intent.
I mean, intent tell us for me. Intent is the main. I don't have that intent.
Then what was your intention?
My intention was to just ask, in martidira tavu.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು whether you have drawn the attention of the district administration prior publishing this news item.
No, my lords, I am not, I don't have instructions.
I asked you.
I don't have instructions
If
from
that
the.
was your intention, that was your good intention, that was your simple intention,
Please.
that could have been done by you.
I don't have instructions in this, my lords.
Not writing some article in the newspaper by referring to the individual names of the officers and making fun of them.
Well, we're only posing a question.
Question to
We have the
whom?
fourth estate. Question to the administration, my lords.
Why you have not drawn their attention? Why you have not given the representation to them? See, this is what happening in the district.
Lords, if I may just get a short adjournment. I'll just confer on this.
Nothing.
It's very
Yes.
short. It may be taken up tomorrow, my lords. I will just take a
No, sir,
short adjournment will come. It may be taken up tomorrow.
I'm appearing for the respondent number 4, my lords. My lords, my learned friend has already read that is annexure F, my lords. So
Yes.
I don't want to repeat the same thing, but
Yes,
I have filed my statement of
you are
objection.
for respondent number 4.
Please, my lords.
Yes,
My lords, in my statement of objection, I have produced annexure respondent, annexure R3, my lords. In that, my lords, here they have published ಕೊಡಗಿನ ಮಹಿಳಾ ಅಧಿಕಾರಿಗಳು ಕೊಡಗಿಗೆ ಮಹಿಳಾ ಅಧಿಕಾರಿಗಳು ಒಪ್ಪುವುದಿಲ್ಲವಂತೆ. And in that, he has made serious allegations, my lords.
ಎಲ್ಲಿದೆ? Where is it?
In my statement of objections, my lords, R3, my lords.
R3 ಆಯ್ತು. Where is the publication?
I have produced, my lords. I have produced in my
Along with the
statement of
statement.
objections. It is there, my lords.
That was not produced along with the petition?
No, my lords.
ಎಲ್ಲಿದೆ ಇವ್ರ statement of objection?
Number 4.
Not 1 or 2 articles, my lords. ಕೊಡಗಿಗೆ ಮಹಿಳಾ ಅಧಿಕಾರಿಗಳು ಒಗ್ಗುವುದಿಲ್ಲವಂತೆ.
ಎಲ್ಲಿದೆ page number? Annexure?
R3, my lords. Last document, my lords. I read, my lords.
R3 ನಲ್ಲಿ ಏನಿದೆ? ಸಂಸ್ಕೃತಿಯನ್ನು JCB ಇಂದ ಮಣ್ಣು ಮಾಡುವ ಮುನ್ನ ಎಚ್ಚೆತ್ತುಕೊಳ್ಳಿ.
Lord, we have also produced along with our statement of objection as
One
R
minute, 1 minute.
4, my lord. Annexure 4, R4.
Yes, got it.
My lords, in that, my lords, he has stated that ಕೊಡಗಿನಲ್ಲಿ ಮಹಿಳಾ ಅಧಿಕಾರಿಗಳು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವುದು ಯಾಕೋ ಸರಿಯಾಗಿಲ್ಲ ಎಂದು ಗುಸುಗುಸು ಕೇಳಿ ಬರ್ತದೆ. ಕೊಡಗಿನ ಆಯಕಟ್ಟಿನ ಆಡಳಿತದಲ್ಲಿ ಮಹಿಳಾ ಅಧಿಕಾರಿಗಳು ಅಧಿಕಾರ ಚಲಾಯಿಸಲು ಬಂದಾಗಲೆಲ್ಲ ಏನಾದರೊಂದು ಅನಾಹುತ ಜಿಲ್ಲೆಯಲ್ಲಿ ಕಾಡುತ್ತಿದೆ ಎಂದು ಕೆಲ ಹಿರಿಯರು ಮೆಲುಕು ಹಾಕಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ. ನೋಡಿ ಕೊಡಗಿಗೆ ವರ್ತಿಕಾ ಕಾಟಿಕೇರ್ ಪೊಲೀಸ್ ವರಿಷ್ಠ ಅಧಿಕಾರಿಯಾಗಿ ಕರ್ತವ್ಯಕ್ಕೆ ಬಂದರು. ಬೆನ್ನ ಹಿಂದೆ ಮತ್ತೊಂದು ಕ್ರೂರಿ ಭಯೋತ್ಪಾದಕ ಟಿಪ್ಪು ಜಯಂತಿ ಆಚರಣೆ ನಡೆಯಿತು. ಕೊಡಗು ಹತ್ತಿ ಉರಿಯಿತು. ಸಂಘರ್ಷ ನಡೆದು 2 ಅಮಾಯಕರ ಹೆಣ ಬಿತ್ತು. ಮಾನಸಿಕವಾಗಿ ಕೊಡಗು ಇಬ್ಬಾಗವಾಯಿತು. ಜಿಲ್ಲಾಧಿಕಾರಿಯಾಗಿ ಶ್ರೀ ವಿದ್ಯಾ ಬಂದು ಪ್ರಾಕೃತಿಕ ವಿಕೋಪದಿಂದ ಕೊಡಗು ತಲ್ಲಣಗೊಂಡಿತು. ಉತ್ತರ ಕೊಡಗು ತನ್ನ ಸೌಂದರ್ಯ ಮತ್ತು ಚಿತ್ರಣವನ್ನ ಪ್ರಾಕೃತಿಕ ವಿಕೋಪದಿಂದ ಬದಲಾಯಿಸಿಕೊಂಡಿತ್ತು. ಆಗಲೂ ಕೆಲ ಅಮಾಯಕರು ಸತ್ತರು, ಅನೇಕರು ಬೀದಿಗೆ ಬಿದ್ದರು. ಶ್ರೀ ವಿದ್ಯಾ ವರ್ಗಾವಣೆಗೊಂಡ ನಂತರ ಮತ್ತೆ ಮಹಿಳಾ ಅಧಿಕಾರಿ ಅನೀಸ್ ಕಣ್ಮಣಿ ಜಾಯ್ ಬಂದರು. ಜೊತೆಗೆ ಮಹಿಳಾ ಪೊಲೀಸ್ ಅಧಿಕಾರಿ ಡಾಕ್ಟರ್ ಸುಮನ್ ಪನ್ನೇಕರ್ ಆಗಮಿಸಿದರು. ಉತ್ತರ ಮತ್ತು ದಕ್ಷಿಣ ಕೊಡಗು ಒಟ್ಟಿಗೆ ಪ್ರವಾಹದಲ್ಲಿ ಮುಳುಗಿ ಹೋಯಿತು. ಅನೇಕರು ಮನೆ ಮಠ ಕಳೆದುಕೊಂಡು ಬೀದಿಗೆ ಬಿದ್ದರು ಎಂದು ಜನತೆ ಮಾತನಾಡಿಕೊಳ್ಳುತ್ತಿರುವುದು ಸೋಜಿಗವೋ ವಾಸ್ತವೋ ಗೊತ್ತಿಲ್ಲ. ಕೊಡಗಿಗೆ ಇದೀಗ ಜಿಲ್ಲಾಧಿಕಾರಿ, ಪೊಲೀಸ್ ವರಿಷ್ಠ ಅಧಿಕಾರಿ, ಹೆಚ್ಚುವರಿ ಜಿಲ್ಲಾಧಿಕಾರಿ, ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿ ಎಲ್ಲರೂ ಮಹಿಳೆಯರೇ ಆಗಿದ್ದಾರೆ. ರಾಜ್ಯ ದೃಶ್ಯ ಮಾಧ್ಯಮವೊಂದು ಇವರನ್ನು ಮಹಾಲಕ್ಷ್ಮಿಯರೆಂದು ವರ್ಣಿಸಿತು. And even, my lords, he has made a defamatory article, my lords, on 9/6/2020, my lords. ಕಚೇರಿ ತಲುಪಿದ ಅನಾಮಧೇಯ ಪತ್ರ ಎಂಬ ಶೀರ್ಷಿಕೆ ಅಡಿಯಲ್ಲಿ ಕೊಡಗಿನ ಅಧಿಕಾರಿಗಳ ಬಗ್ಗೆ ಯಾರು ಚಕಾರವೆತ್ತುವಂತಿಲ್ಲ.
Annexure?
My lords, annexure F only, my lords. Annexure F.
Now you read annexure R3.
R3, my lords.
R3 you just now read.
Please, my lords.
What is that you are reading
My lords, now, my lords, annexure F, my lords.
in the petition?
Petition, my lords. Here in that, my lords, even they have stated under P ಮತ್ತು C ಒಳಗಡೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ಮತ್ತು ಪ್ರಾಕೃತಿಕ ದುರಂತ ಎಂಬ ಶೀರ್ಷಿಕೆ ಅಡಿಯಲ್ಲಿ ಕರೋನಾ ಮುಕ್ತವಾದ ಕೊಡಗು ಜಿಲ್ಲೆ ಗ್ರೀನ್ ಝೋನ್ ಆಗಿದೆಯೋ ಅಥವಾ ಡೀಲಿಂಗ್ ಝೋನ್ ಆಗಿದೆಯೋ ಎಂಬ ಕೊಡಗು ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕಿ ಡಾಕ್ಟರ್ ಸುಮನ್ ಪನ್ನೇಕರ್, ಜಿಲ್ಲಾಧಿಕಾರಿ ಅನೀಸ್ ಜಾಯ್ ಕಣ್ಮಣಿ ಜನತೆಗೆ ಉತ್ತರಿಸಬೇಕು. ಈ ಇಬ್ಬರು ಅಧಿಕಾರಿಯರು ಜನರು ಹೊಗಳುತ್ತಿದ್ದಾರೆ. ಕೆಲವರು ರೆಡ್ ಝೋನ್ ಮತ್ತು ಘೋಷಣೆಯಾಗಿರುವ ಮೈಸೂರಿನಿಂದ ಕೊಡಗಿಗೆ ನುಸುಳಿ ಅಲೆದಾಡುತ್ತಿದ್ದಾರೆ ಎಂಬ ಗಂಭೀರ ಆರೋಪ ಕೇಳಿ ಬರುತ್ತಿದೆ. And apart from that, my lords, even on it was 9/6/2020, my lords, ಅನಾಮಧೇಯ ಪತ್ರ, in that, my lords, they have stated that ಅಧಿಕಾರಿಗಳ ಬಗ್ಗೆ ಯಾರು ಚಕಾರವೆತ್ತೂ ಇಲ್ಲ. ಮಳೆ ಇರಲಿ, ಕರೋನಾ ಸಂಕಟವಿರಲಿ, ಅಧಿಕಾರಿಗಳಲ್ಲಿ ಇತ್ತೀಚೆಗೆ ಪೈಪೋಟಿ ಕಂಡು ಬಂದಂತೆ ಇದೆ. ಸ್ಪರ್ಧಾ ಯಾವ ವಿಚಾರದಲ್ಲಿ ಎಂದು ನೋಡಿದರೆ ಪ್ರಚಾರ ತೆಗೆದುಕೊಳ್ಳುವುದರಲ್ಲಿ, ಪ್ರಚಾರ ವಿಷಯದಲ್ಲಿ DC SP ಪೈಪೋಟಿಗೆ ಬಿದ್ದಂತೆ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ ಬಳಸಿಕೊಂಡು ನಾ ಮುಂದು ತಾ ಮುಂದು ಎಂದು ಹೊರಟಂತಿದೆ. ತಮ್ಮ ಬೆಂಬಲಿಗರ ಪತ್ರಕರ್ತರಿಂದಲೇ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ ಬಳಸಿ ಪ್ರಚಾರಕ್ಕೆ ಉಪಯೋಗಿಸಿಕೊಳ್ಳುತ್ತಿರುವುದು ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗಿದೆ. ಉಸ್ತುವಾರಿ ಸಚಿವರು ಶಾಸಕರನ್ನು ಕ್ಯಾರೆ ಮಾಡದೆ ಅಧಿಕಾರಿಗಳಿಬ್ಬರು ಪಬ್ಲಿಸಿಟಿ ತೆಗೆದುಕೊಳ್ಳುತ್ತಿದ್ದು DC ಈ ಪೈಪೋಟಿಯಲ್ಲಿ ಮುಂದಿದ್ದು DC-ಯನ್ನು ಕಿರುಚಿತ್ರವೊಂದನ್ನು ನಿರ್ಮಿಸಿರ್ತಾರೆ. ಇಂಥವರಿಂದ ಕೊಡಗನ್ನು ರಕ್ಷಿಸುವವರು ಯಾರು ಎಂಬುದಾಗಿ ಸದರಿ ಪತ್ರಿಕೆಯ ವರದಿಗಾರ ಹಾಗೂ ಸಂಪಾದಕರು ತಮ್ಮ ಪತ್ರಿಕೆಯಲ್ಲಿ ಪ್ರಕಟಿಸಿದರು. So all these allegations of, my lords, it's defamatory in nature, my lords. Even, my lords, even in on 15/6/2020, my lords, he has published an article. ಹಳೆ ನರಸಮ್ಮ DC-ಗೆ ಈ ಬಗ್ಗೆ ತಿಳಿಯದೆ ಹೋಗಿದ್ದು ಜನತೆಯ ದುರಂತ, ಎಳೆಯ ಹೆಣ್ಣು ಮಕ್ಕಳ ಭವಿಷ್ಯದಲ್ಲಿ. That is annexure R2, my lords.
Why are you jumping from that? This once-ala
No, my lords,
once-ala
because annexure F, everything was read by my learned friend, my lords.
Also.
So I'm just.
Then again you came back. Now we are referring to annexure
R2, my lords. ಆರೋಗ್ಯವೆಂದರೆ RSS ತಾನೆ. So in that title, my lords, here they have made specific allegation, my lords. ಗೋಣಿಕೊಪ್ಪ ಪೊಲೀಸ್ ಠಾಣೆ ವ್ಯಾಪ್ತಿಯ 10ನೇ ತರಗತಿ ವಿದ್ಯಾರ್ಥಿನಿಗಳು ತನ್ನ ಮೇಲೆ ಕೆಲವರು ದೌರ್ಜನ್ಯ ಜಿಲ್ಲಾ ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕರಿಗೆ ದೂರು ಸಲ್ಲಿಸಿ ದಿನಗಳು ಉರುಳಿದೆ. ಗೋಣಿಕೊಪ್ಪ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಸೂಕ್ತ ನ್ಯಾಯ ಸಿಗದ ಕಾರಣ SP ಮೇಡಮ್ಗೆ ದೂರು ದಾಖಲಿಸಿದ್ದಾಳೆ. ದೂರು ದಾಖಲಾಗಿ ವಾರಗಳು ಉರುಳಿದ್ದು ಎಳೆಯ ಹೆಣ್ಣು ಮಕ್ಕಳ ಭವಿಷ್ಯದಲ್ಲಿ SP ಅಥವಾ DC ಆಗಬಹುದು. ಇಂಥ ಮಕ್ಕಳಿಗೆ SP DCಗಳು ಯಾವ ರೀತಿ ಮಾರ್ಗದರ್ಶಕರಾಗಿರ್ತಾರೆ ಎಂದು ಕಾದು ನೋಡಬೇಕು.
Yes. How section 153 is applicable?
My lords. My lords, the statement made, my lords, it creates in the minds of the people, my lords, what is administrative officers
You
are
have
doing,
not
my lords,
alleged,
which also causes to the, it may also leads to the riot, my lords, because
no, it
there
is
every
not your,
possibility, my lords.
it is not your case that it amounts to defamation. Have you invoked any provisions? No. Then you invoke 153, 501, 505, 501 idea.
Why not 5?
505 minutes.
Why not?
505(1) B,
505 is also
505(2)
in-
and 153.
501 is also in.
505(1) B.
501, I am asking whether that is invoked.
505, my lord.
501 illa.
501.
505,
505,
section 1,
B.
clause B,
Yes.
that is invoked. 505 clause 2 is invoked and 153 is invoked.
Yes, that's GP.
My lord, we have filed our objections, my lord. And in the objections, my lord, is stated, my lord, the petitioners were in the habit of publishing these newses, my lord. And it is in the complaint only two, it was given only with respect of two news items, my lord. But they were in the habit of publishing these kind of newses. And my lords should also consider the time in which these news items were published, my lord. It was during Corona period, my lord, all the people were so distressed. And if they come to know about these things, my lord, which is also false, lord, they may also create the problems in the society, my lord. The riots may also happen because of these news items, my lord. And the officers, my lord, they have not implemented anything which was not the order of the state government or the central government, my lord. They have only issued guidelines according to the directions of the state government and the central governments, my lord.
Yes.
And my lord, even after, my lord, this complaint was registered, they keep on publishing these newses, my lord.
Even after complaint.
Even after the complaint, my lord. And notice was also issued under section 107 and 111 of CRPC by the executive magistrate to the petitioner. And that was stayed by this honorable court also, my lord. And a direction was issued to the petitioners not to publish such false news, my lord. In spite of that, my lord, they have issued, they have published these news, my lord, which
No, that order was passed by
this honorable court, my lord. I couldn't get the
Criminal
order copy,
Revision
my lord.
Petition 19 of 2020, my lord.
That I have stated in my objections, my lord, in para number 15, page number 11 of my statement of objection. May I read para number 15, my lord?
Yes.
It is submitted that on the report of the Madikeri Town Police, the Taluk Magistrate and Tahsildar Madikeri rightly initiated proceedings against the petitioners under section 107 and 111 of CRPC, and the said proceeding is not in retaliation as alleged by the petitioners. And in spite of issuance of show cause notice, the petitioners failed to appear before the Taluk Magistrate, which proves the acts and deeds of the petitioners. And thereafter, the further proceedings came to be stayed by the Honorable District and Sessions Judge Kodagu Madikeri in Criminal Revision Petition number 19 of 20. Wide order dated 23/6/2020. And in spite of directions of the Honorable Court, not to make false allegations against respondent number 3, the petitioners have continued their illegal acts and still the petitioners are continuing the illegal publication and articles which caused heavy damage to the reputation of the respondent number 3.
Yes.
Based on these facts, my lord, a complaint was given to the police, my lord, and it is yet to be investigated, my lord. The allegations in the complaint makes out a offense under section 505 also, my lord. And the police may be permitted to investigate the veracity of those allegations, my lord.
ಏನಿದು ಸ್ಟೇ ಇತ್ತ ಇದಕ್ಕೆ?
Stay.
Lords, if I may submit.
1 minute, I'll come back. How to shift?
The no coercive steps to be taken ಅಂತ ಹೇಳಿದ್ರು. In 2020, 16, 11, 2020.
Where is the stay?
No coercive steps to be taken. That is the, not a stay order per se, my lords. No coercive steps to be taken ಅಂತ.
There is no stay.
Sorry, my lord. File stay ಅಂತ ಬರ್ದು. File stay ಅಂತ ಬರ್ದಿದ್ರು ಅದಕ್ಕೆ.
ಬರ್ಕೊಳ್ತಾರೆ, ಬೇಕಾಗಿದ್ದು ಬರ್ಕೊಳ್ತಾರೆ.
Sorry, madam. Stay extended ಅಂತ ಇರುತ್ತೆ, so I thought it's a stay of investigation.
ಅದು nobody knows what is the stay, what is the interim order. Unfortunately, it continues forever.
Yes, ma'am.
Interim order extended. Neither the court knows it nor the council.
I'll verify whether they have completed the investigation or what is the stage of my lords.
Yes.
If I may submit, my lords, with respect to section 153 IPC, as to how the ingredients are not attracted, based on citation on record, so. But relevant paras are para 6, 7, 8, 10, and 11. I'll just read the relevant para. Para 6 -ally. The essential ingredients to constitute the offense under section 153 IPC are as follows. The accused did an illegal act. The accused was done malignantly. The act was done malignantly or wantonly. The act was done with the intention to provoke or knowing that it will provoke a person to cause the offense of rioting.
Yes.
So all these three ingredients have to be fulfilled in order for section 153 to be attractive. Para 7 al ಹೇಳ್ತಾರೆ so. The word malignantly and wantonly are not used synonymous in the section. The word malignantly used for the purpose of expressing higher degree of intensity or ill will, while the word wantonly means causing harm or damage deliberately. The Oxford Advanced Learners Dictionary defines the word malignantly or as having or showing a strong desire to harm somebody. Similarly, the word wantonly is explained as in a way that causes harm or damage deliberately and for no acceptable reason. para 8 also.
Hmm.
Both these terms convey that the two expressions malignantly or wantonly used in sections 153 IPC indicate that there must be a higher degree of malice or evil that is projected or evident in the act alleged. The provision further requires that the act alleged to be done must be illegal. The word illegal is defined in section 43 of IPC to mean everything which is an offense or which is prohibited by law or which furnishes the ground for a civil action.
Yes.
Similarly, my lords, para 10L, further, to bring home the guilt of the offense under section 153 IPC, it is necessary that the act gives provocation to a person and also provokes or is likely to provoke a rioting. Though for the offense to be attracted, actual rioting need not occur.
Yes.
Para 11 on a perusal of the allegations of the FIR in this present case, it is evident that the act done with the petitioner is neither malignant nor wanton, nor is it illegal. The act is also not capable of giving provocation or knowing that the provocation will cause rioting. The word rioting is defined in section 146 IPC as whenever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object of such assembly, every member of such assembly is guilty of the offense of rioting. From the nature of allegations stated in the FIR, it is not possible to come to a conclusion that the act of the accused.
It's all on facts of that case.
Yes, my lords.
Yes.
In the present case as well, my lords, the act done by the petitioners is not illegal. And the act done, there is no higher degree of malice.
So you can
or-
write anything in the newspaper,
My lords, I concede the fact that it might be defamatory. I am not.
not only defamatory, sir.
Lords, I will come to the.
Amounts to writing, it amounts, there was an intention.
My lords, when for it to amount to writing, there should be a higher degree of malice or evil.
What
Nowhere
higher
in the article, I just question, my lords, what is happening? Our green zone in the red zone ಬರ್ತಿದ್ದಾರೆ. ಇಲ್ಲಿ ಈ ತರ ಆಗ್ತಾ ಇದೆ. What is happening? I'm only posing a question.
That was the wordings used.
Please,
This, FIR would not have been registered.
my lords, the FIR is already, the contents are already defamatory in nature. They can initiate defamation against me.
Not only
Here,
defamatory.
well, here they have initiated state prosecution under 153 to only simply harass the petitioner, my lords. The statements made, my lords, under 153 will not, do not attract the ingredients as 153 contemplates. There is no malice, there is no evil that is attributed to the acts of the petitioner. I am the media. I have reported these issues in the district, my lords. I am a readership of 10,000. I am only putting this news across. There is nothing that happened. There is no writing that subsequently followed. Nowhere in their objections have they stated.
It is not the requirement of law.
It is not, my lords. But even otherwise, the words used by the petitioners in their articles are not, when juxtaposed with section 153 IPC, they do not tantamount to malignant or higher malice or evil so as to attract the offense under 153 minutes. That is my submission. Subsequently, my lords, section 196 of CRPC is one. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, that is not relevant. Apologies. Apologies. The next one is with respect to 505 minutes.
Yes.
505 clause 2, 505 clause 1 subclause B is non-cognizable. 505 clause 2 is cognizable. Place on citation on records.
Why not?
505
Ah.
clause 1 is non-cognizable in nature. 505 clause 2 is cognizable. So I am on the section of 505 clause 2, sir. If I may read out the bare provision of 505 clause 2, which is one of the offenses that is arraigned, that is initiated against me. Statements creating or promoting enmity, hatred or ill will between classes. 505 clause 2, sir. IPC. 505
That
clause
was
2.
invoked.
That is also invoked, my lords, in the FIR. More section ಇದೆ. ಒಂದು 153, ಇನ್ನೊಂದು 505 subsection 1 clause B. The other one is 505.
So clause
2.
1 was invoked.
Clause 1 is also invoked. Clause 2 is invoked. 153 is also
Two is
invoked.
also invoked.
2 is also invoked. So there are 3 sections in total.
So according to you, 505 1 is cognizable,
505 1 is non-cognizable. my lords.
non-cognizable.
Non-cognizable. In that 505 1B, the only relevant portion will be whoever makes, publishes or circulates any statement, rumor or report.
505(2) is cognizable.
Yes, my lord.
505 clause 2 is cognizable, 153 is cognizable, 505 1B is not. Two offenses are cognizable. Literally, section 505 1B, it only says whoever makes, publishes or circulates any statement, rumor or report.
I've already read it.
Yes, 505 clause 2, my lords.
Yes.
Statements creating or promoting enmity, hatred or ill will between classes. Whoever makes, publishes or circulates any statement or report containing rumor or alarming news with intent to create or promote, or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, caste or community, or any other ground whatsoever, feelings of enmity, hatred or ill will between different religious, racial, language or regional groups or castes or communities shall be punished with imprisonment, which may extend to 3 years or with fine or both. Here, my lords, there is no allegation as to what are the two communities. Yav community mele, yav community na now, with by virtue of these articles, are we pitting against each other. There is no whisper with respect to this in the complaint, or even a prima facie reading of the articles will not suggest the same.
Sir,
There are several, yes, my lords. Hatred or ill will.
on ground of religion, race, place of birth, residence, language, caste, community, or any other ground.
Please, my lords, here,
It includes everything.
please, my lords, if I may refer to the citation. Here, yav ground allo adagilla, sir. That is our contention. Just refer to the relevant paras.
Which citation?
ಇನ್ನೊಂದು ಕೊಟ್ಟೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ? ಇದಾ?
It is
Sandeep Arjun.
Sandeep Arjun Pudale,
Yes.
High Court of Bombay, my lords.
Yes.
Adralli, para 17 of the petition, of the citation. Para 17, sir.
One. Yes.
ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, in Bilal Ahmad Khalu Supra, the apex court, whilst considering the prosecution case, whether the appellants therein, by spreading news that members of the Indian Army were indulging in commission of atrocities against Kashmiri Muslims, and whether the same would attract penal consequences under sections 153A and 505 clause 2 of the IPC, has in para 15 observed as under. The common feature in both sections being promotion of feeling of enmity, hatred or ill will between different religious or racial or linguistic or regional groups or castes and communities, it is necessary that at least two such groups or communities should be involved. Merely inciting
Was
the
referring to the facts of the case, referring to two communities.
Yes, my lords. In the facts of the case, we're not referring to any community.
ಇಲ್ಲಿ
There is
community
no
ಮೇಲೆ ಇಲ್ಲ.
community at all.
No community, that question does not arise.
Yes, my lords. So there being no community, 505 clause 2, the prosecution cannot be sustained against.
What I have said.
Yes, my lord.
502 part 2 not only refers to community, it refers to so many other things.
Yes, my lords. Illi community illa. They are not specifying which community.
Need not be.
On whatever ground.
Need not.
On whatever ground, they are not, there is no community. So 505, as per the Honorable Supreme Court, it's only between communities, my lords. Not merely inciting the feeling of one community or a group.
Of that case refers to community.
Please, my lords.
505(2) will not restrict it only to between two communities.
My lords, here it only says different religious, racial, language or regional groups or castes or communities.
You read
Here-
you have already read this section.
Yes, my lords. In
It
that,
does not restrict only to the communities.
yes, my lords, it is either a community
Hmm.
or different religious, racial, language or regional group or caste.
Or
Here,
any other ground,
my lords, that is on the grounds of religion
or any other ground.
Whatsoever.
or community or any other ground on
Hmm.
grounds of religion.
Yes.
On grounds of religion, race, place of birth, on any ground, if there are two communities, my lords, on
Not
any,
necessarily, sir. Again and again, don't refer to communities.
must have persuade.
That is not the fact
If I may
applicable to this
persuade.
case.
If I just, if I may read out the section again, my lords. If I
You
may,
have
that-
read it, I have read it, I understood it.
Please, my lords. ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ, basically it is any
What
ground,
is meant by any other ground?
or any other ground on grounds of the reason for the enmity or hatred. It is not communities. my
So
lords.
on any other ground which lead to amenity, section
E-
505
enmity
can be invoked.
Yes, my lord, between groups
ಅಷ್ಟೇ.
and castes,
Next.
adu.
Hmm.
So therefore, my lords, in my humble submission is,
Yes,
in the present case, 505 clause 2 cannot be attracted.
yes.
505 clause 1 also cannot be attracted. At the most, it is a defamatory statements for which they can take recourse by filing a PCR, my lords, before the magistrate courts, my lords. Initiating prosecution against them under 153, 505 1B and 505 2 is wholly unwarranted under the law, my lords.
Yes.
It is misusing the state petitionary to arm twist the petitioners, which is the fourth estate, my lords. They are doing their job as the media. So that cannot be the ground, because just because they've published the articles, they could have gone, my lords, they've not initiated a single defamatory case against me till date.
That is left to you, sir. You cannot.
But they have not initiated, my lords.
Yes.
If they were, ಅವ್ರು ತೇಜೋವಧ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಅವ್ರು ನನ್ನ ಮೇಲೆ ಒಂದು ದಾವೆ ಹೂಡಬಹುದಾಗಿತ್ತು. ಇಲ್ಲಿ ತನಕ ಹೂಡಿಲ್ಲ ಅಷ್ಟು. They only initiated this criminal prosecution against me, which is by arm twisting, to arm twist the petitioner. That's all.
Anything in reply? Any? Nothing.
Pardon.
That's all. So good. Petitioners being accused number 1 and 2 have filed this petition under invoking Article 226 and 227 of Constitution of India, read with Section 482 of CRPC, seeking issuance of writ in the nature of certiorari to quash the FIR produced as per Annexure D that is in crime number 36 of 2020 of Madkeri Town Police Station. And also to issue the writ in the nature of mandamus, directing respondent number 3 and 4 to pay compensation and damages for violation of the fundamental rights of the petitioners. Third solution. When counsel for the petitioner contended that the petition number 1 is the editor and petition number 2 is the news reporter. ಏನದು ಪತ್ರಿಕೆ ಹೆಸರು ಕಾವೇರಿ ಟೈಮ್ಸ್.
Kaveri Times.
ಏನದು ಡೈಲಿನ?
Also.
ಡೈಲಿ
Daily in Coorg.
Huh?
In Coorg. Kannada Dinapatrika in Coorg.
ಡೈಲಿ ನ್ಯೂಸ್ ಪೇಪರ್. ಕಾವೇರಿ ಟೈಮ್ಸ್ ಅಂತ ಕಂತಾರೆ. ಡೈಲಿ ನ್ಯೂಸ್ ಪೇಪರ್ ಪಬ್ಲಿಷ್ಡ್ ಫ್ರಮ್ ಕೂರ್ಗ್, ಕೊಡಗು. Respondent number. The Shiras are attached to the office of respondent number 3. File the first information as per Annexure C, alleging against the Shiras are attached to the office of respondent number 3. File the first information against the petitioners, alleging commission of the offence punishable under Section 153, 505(1)(b), 505(2), read with Section 34 of IPC. It is alleged that the petitioners have published some news items in their newspaper with an intention to give rise to the riots in the village. But the news items published by the petitioners are only for the purpose of creating awareness amongst the general public, and it was not with an intention to give rise to a riot as required either under Section 153 or under Section 505 of IPC. Next, counsel submitted that the petitioners, being the media person of the fourth estate in the Constitution of India, and they were certain privileges and also rights in reporting the matters to the general public. There was no intention, no malice in publishing the news items. News items. Next part. Learned counsel drawn the attention of the court to various news items published in the newspaper Kaveri Times to contend that even though there is reference to the names of the deputy commissioner and the SP of the district at the relevant point of time, it was not with an intention to commit any offense as alleged. These publications were published during COVID-19 pandemic. It was only with an intention to create awareness among the public, general public. If it is the contention of the complainant that the publications amount to defamation, they could have recourse to law by filing private complaint. But no such steps were taken invoking the penal provisions. The counsel for the petitioner has placed reliance on the decision of Kerala High Court in Sanjeev S versus State of Kerala, represented by Public Prosecutor 2023 SEC Online Kerala 1948 in support of his contention that to invoke section 153 IPC, the accused must commit an illegal act with an intention to an illegal act which was done malignantly, MALIGNANTLY, or wantonly. And further, the act must have been done with an intention to provoke or knowing that it will provoke a person to cause the offense of rioting. The counsel submitted that the word malignantly is used for the purpose of expressing higher degree of intensity or ill will, and the word wantonly means causing harm or damage deliberately. When such words are used in section 153, it mean that there must be higher degree of malice or evil that is projected or evident in the act of the accused, unless such basic ingredients are proved, the FIR could not have been registered invoking section 153 IPC. We also place reliance in the decision the Bombay High Court in Sandeep Arjun Kuble versus State of Maharashtra 2023 SEC Online Bombay 519 content. Section 505(2) is cognizable offense, where 505(1) is non-cognizable offense. And to invoke section subsection 2 of 505, at least 2 communities should have been included. But in the present case, no religion, no community is referred to in the publications. There is no two groups in the community. And under such circumstances, section 505 could not have been invoked. When the council submitted that the complaint was deliberately filed to arm twist the petitioner and to prevent them from publishing the news items in the daily newspaper, which amounts to preventing the petitioners from publishing the news, publishing the daily newspaper and violating the rights of the petitioner. When no ingredients of either section 153 or 505 of IPC could be made applicable to the case, the FIR is liable to be quashed. Accordingly, it pays for allowing the petition. Per control and counsel for respondent number 3, respondent number 3 is not represented for the.
We represent respondent 1 and 3, ma'am.
Per control, Leonard SCGP for respondent number 1 and 3, opposing the petition submitted there. The petitioners being the editor and news reporter of Kaveri Times daily newspaper are in the habit of publishing the news items and making it sensational at the cost of the individual officials. It was made with an intention to provoke the general public for rioting. These news items were published during COVID-19 period when there was which was a very sensitive period. The petitioners have specifically referred to the names of the deputy commissioner and the SP in the district and used all languages only with an intention to give rights to the right in the society. Respondent number 3 and 4 have followed the guidelines of either state or the central government to arrest the COVID situation effectively. But the same was made fun of by the petitioners by publishing the news items and making it very sensational. The news item, the allegations made in the news item had no basis whatsoever except to provoke the general public to riot against the district administration. Then next part, when counsel for the submitted that even though there was a prohibition from publishing such news items, the petitioners proceeded to publish several such news items, making false allegations. The intention and the malice on the part of the petitioner was evident from their conduct. Then counsel also submitted that even though 2 news items were produced by the petitioner, to plead innocence, there are several such news items published in the daily newspaper, which squarely attracts section 153 and 505 of IPC. The matter is still at the stage of investigation, and under such circumstances, the criminal proceedings is not liable to be quashed. Accordingly, it is for dismissal of the petition. Next, learned counsel for responding number 3. Supporting the contention taken by the learned ex-CGP submitted that. The deputy commissioner and the superintendent of police, both being ladies, were referred to by their names in the news items repeatedly to show them in bad light. The intention of the petitioners are very clear, which squarely attracts Section 153 and 505 of IPC. There are many more such applications referring to responding number 3 and 4 personally and making fun of them only on the ground that they are lady officers. Prima facie, there is absolutely no basis for such news items that is being published, except with an intention to provoke the general public, to cause riot, and it is part of the playing public mischief and promoting enmity between the sections of the society. Hence, the petition is liable to be dismissed accordingly, paid for dismissal. Here is the materials on the board. The informant has filed the first information as per NHSC, stating that during corona, that is COVID-19, when the 2 lady officers were heading the district administration as DC and SP, news items were being published by the petitioners by giving false information and provoking the general public with the intent to cause riot and also promoting enmity, hatredness, and ill will between two classes. Section 153 of IPC refers to wantonly giving provocation with intent to cause riot. Whenever such act of the accused malignantly or wantonly to give provocation to any person intending or knowing it to be likely that such provocation will cause the offense of rioting to be committed, the same is punishable under the section. Similarly, under section 505, 1B, any statement made to cause public mischief with an intention are likely to cause fear or alarm to the public or to any section of the public thereby to induce them to commit an offense against the state or against the public tranquility. Subsection 2 of section 505 refers to such publications containing rumors or alarming news with an intention to create or promote the feeling of enmity, hatredness, or ill will on any other grounds. Next, on perusal of the news items produced by the petitioner as per annexure E and F, and also produced by the respondent number, respondents 1 to 4, discloses that several such news items were published during COVID-19, referring to two lady officers who are working as a deputy commissioner and the SP in the district. And alleging that the people from red zone are illegally entering green zone, that is Kodagu district. And there are no persons to question the district, the officers concerned. Officers concerned. As we all know, during COVID-19, the public were very sensitive as nobody was knowing what was happening. What was the reason for COVID-19 and how to arrest it. Under such a delicate period, the petitioners have came up with publication mainly referring to two lady officers by their names and also alleging that they are not taking any steps to arrest the COVID-19 in the district. But on the other hand, they are only after publicity by using the public money which was meant for taking care of COVID-19, spreading of COVID-19. If we go through the paper publications referred to by the informant, definitely it would give provocation to the general public to cause rioting. It would place the topmost officers of public administration in bad light. And prima facie, it is with an intention to cause mischief and to alarm the public and induce them to commit an offense. The act alleged against the petitioners, prima facie, is to promote enmity or hatred against the district administration. Under such circumstances, both section 153 and 505 of IPC is squarely attractive to the facts of the case. Next paragraph. When counsel for the petitioner has placed reliance on the decision of Kerala High Court in Sanjeev S. Supra, wherein the High Court has referred to the essential ingredients to constitute the offense under section 153 of IPC, and explained in detail the meaning of the word malignantly and wantonly used in the penal provision. It is stated that these words are not used synonymously in the section, as the word malignantly is used for the purpose of expressing a higher degree of intensity or ill will, while the word wantonly is used to show causing harm or damage deliberately. There is no dispute with regard to the position of law or the ingredients that are required to constitute the offense under section 153. When the requirement of law to attract section 153 or section 505 are applied to the facts of the case, and I'm of opinion that prima facie the offense is made out by the complainant. The learned counsel for the petitioner has also placed reliance on the decision in Sanjeev Arjun Udle, where the facts and circumstances of the case are entirely different as it relates to where the High Court of Mumbai referred to the decision of the apex court in Bilal Ahmad Alu. The reference is there from Alu. To state that to consider the contention of the prosecution, that by spreading news that the members of Indian Army were indulged in commission of atrocities against Kashmiri Muslims, whether it attracts section 153A and 505(2) of IPC, the apex court held the common feature in both sections being promotion of feeling of enmity, hatred, or ill will between different religions, race and linguistic groups. It is contended by the learned counsel for the petitioner that there is no such groups in the present case. But the Honorable Apex Court, on the basis of facts and circumstances of that case, made observation with regard to the same. But the reading of section 505, it is not the requirement of law that there must be two religion, race, or two groups on the basis of place of birth, residence, language, caste, or community. But the requirement of this section is creating or promoting enmity, hatred, or ill will between classes on any ground whatsoever. In the present case, since the allegation is against the district administration, by referring to the officers heading there, prima facie, it is the intention of the petitioners to create so-and-so enmity, hatred, or hatred, so-and-so. The next part. Admittedly, the matter is still under investigation. At this stage, it cannot be, at this stage, the contention of the petitioner that the petitioners have not committed any offense either under 153 or 505 or 5PC cannot be accepted. The other contention taken by the learned counsel for the petitioner that at the most, the publications may amount to defamation, and the respondents have not taken any action to remove the penal provision for defamation, also cannot be a ground to allow the petition, as it is for the respondents to invoke the penal provision either under section 153 or 505 or to allege defamation. Simply because the respondents have not filed any complaint alleging defamation against the petitioners, it cannot be concluded that they have not committed the offense under 153 and 505 of IPC. In view of the discussions held above, I am of the opinion that the prima facie materials to constitute the offense alleged, and therefore the FIR registered by the respondent produced and request. Accordingly, I answered the other point in the negative and proceed to pass the dismissal.
It's liberty to challenge
Challenge what?
the charge sheet if they file later.
ಅದು ಗೊತ್ತಿಲ್ಲ ನೋಡೋಣ.
Number 34, Ganapati Bhatt, yes, sir, Jawab.
Yes, my lord. I'm appearing for petitioner. By virtue of, my lord, amendment of, my lord, criminal procedure code. My lord, now, my lord, the provision which is, my lord, 417. We have challenged, my lord, the validity of 376 in this case. Prayer, my lord, at page number 42. This is a petty case, provided, my lord, that we have appealed and appeal, my lord, has been rejected on the ground that there is no provision is there to entertain the appeal under 376, which is challenged before this honorable court. Now, by virtue of, my lord, the new act, I have to insert, my lord, section 417 in place of that. Please, my lord.
I will read it as it is the penal provision which is presently in force.
What's the date fixed ಮಾಡ್ಬಿಟ್ರೆ
That CRPC is repealed now.
repealed now.
Now,
417 has been inserted. ಒಂದು 3-4 days ಅಲ್ಲಿ ಅದನ್ನ amendment ಮಾಡೇ ಬಿಡ್ತು because my lord that even though read, my lord, in case, my lord, your lordship comes to, my lord, conclusion as against me, ultimately, my lord,
why
that
foresee that?
please, my lord.
Why you
Allala,
foreseeing
I'm
that?
not saying that the procedural aspect we can complete, have it day after tomorrow, and we will make amendment of that. Because, my lord, virus of 376 itself is challenged.
ಎಲ್ಲದನ್ನು ವೈರಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಬಟ್ counsel for the petitioner submits that in view of repealment of CRPC, we may have to amend the petition, including the prayer made in the petition. and
First
hence
prayer.
prays for 2 days time. He undertakes to file necessary application within 2 days and to address this on the next date of hearing without fail. Submission is placed on record. This time.
Short day,
Within 2 days, you file necessary application.
Please.
Serving the copy on the other side.
please.
Get ready to address the argument on the next date of hearing.
What is the next date of 6th? Please, much.
But within 2 days, you have filed the
Please,
application.
please, much.
Serial number 35, Satish K, Jeevan J. Nirgi.
Counsel for petitioner, Manoj. Manoj, in this matter also, Manoj, the third respondent is ACD. I have to Manoj, simply look at it as a party and then sort of set of copy to the.
When that decision came,
My apologies, Manoj.
why you have not taken any steps in that regard?
No, please, Manoj.
File necessary application. Also,
Final hearing, serial number 36, Venkatesh PS, R. Shashidhara.
1 minute.
Venkatesh PS.
Petitioner Manoj. Highly password.
ಯಾಕೆ engaged in the corridor.
Kindly password.
Also,
37, 38, Arjun. 39, Somsekhar KM.
37 is password.
which one?
37, serial number 37.
37, Arjun.
Next.
Serial number 39, Somsekhar KM, Akash Kande.
39 ಹೋಗಿಲ್ವಾ ಅಜ್ಜನ ಆಗಿಲ್ವಾ ಇಲ್ವಾ ನಾನು ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಪ್ಲೇಸ್ ಫಾರ್ ಟೈಮ್
Serial number 40, Siddharth B. Muchandi, Chetan B. Angadi, MP Srikanth.
Respondent number 2 in this case.
Petitioner in two matters.
Why there are so many connected matters?
There are different accused, my lord, have filed separate petitions. I am insofar as, my lord, one accused who is a, my lord, attesting witness in a document.
One.
Please.
In all, how many connected matters?
Totally 6 matters.
In 8939 accused number?
My lord, he's 8939. He's the accused number 2. And 8938. 8938, please.
Number?
He's, my lord, accused number 2 again.
Huh?
Accused number 2.
Why?
No, the two separate matters, arising out of, my lord, similar offences, but their complaint is common and relating to, my lord,
Two criminal cases.
two criminal cases,
Crime
two FIRs, 2 charge sheets were filed.
Crime number?
My lord, CC, it's a charge sheet, my lord, CC number 761 of 2015. In criminal petition number 8938, this first matter. And 8939, my lord, CC number 762 of 2015.
ಇವ್ರು ಯಾರು? The other petition ಯಾರು? ಚೇತನ್ ಅಂಗಡಿ?
Angadi Chetan.
ಬಿಡಿ. Who are the petitioners in the other petitions?
My lord,
Any idea?
I do not have, my lord, the details. They are argued by different independent counsels, my lord, are present.
Yes, respondents.
Respondent number 2. Raised time for hearing. Senior arbitration.
Yes, who are the accused? Under sheet ಕೊಡಿ. Are the offense alleged? Similar allegations in both the cases?
In both the cases. Offenses alleged, my lord, of 403, 420, 467, 468, 474, 120B IPC.
Same complainant in both the cases?
Please. The complainants are different, but are arising out of the same, my lord, incident. One is by the husband, one is by the wife. Lord, my lord, with regard to, my lord, a property which was owned by a university. And
Similar
then
allegations?
Similar allegations.
Huh.
And let me kindly see the complaint in the first matter. I'm referring to, my lord, criminal petition number 8939 of 2008. It's, serial number 40. That is, let me kindly turn to page number 34, annexure C. My husband is the chancellor of so-and-so university, which is situated at so-and-so. On 19/5/2015, when I was with him in his office at university, he received a registered post addressed to the university. When on opening the envelope, he was shocked to see a letter by Mr. So-and-so addressed to the board of directors, Mrs. So-and-so, claiming that my husband and I had transferred the shares to the company to him for a consideration that he is holding 90% share capital of the company, and he has requested to register his name in the records of the company as a shareholder partner. Further, he has sent the same some enclosures which were copies of the new duplicate share certificate and security transfer forms. The share transfer forms had both signatures of me and my husband, wherein neither my husband nor I had signed any such securities transfer forms or anything else as claimed by Mr. So-and-so. It seems that Mr. So-and-so somehow had gotten my and my husband's lost new duplicate share certificates. Further, he has forged our signatures and fabricated securities transfer certificate forms based on the fabricated documents, is claiming that shareholding in Mr. So-and-so. In the above circumstances, the above Mr. So-and-so has committed forgery and fabrication of documents, and based on the forged documents, is trying to cheat me and my husband for my valuable securities, claiming to be the shareholder of the business alliance. So this is the allegation. They say that there are forgery of certain signatures on the document, and there's created certain documents by forging signature of this respondent number 2 and her husband. In this complaint, as my lords will see, there is no mention of this present petitioner. We are referring to, my lord, the petitioner in criminal petition 8939, on Mr. Manjunath. And in the entire complaint, my lord, there is no mention about this complaint. Then further statement is being recorded at page number 36. Annexure D may kindly be seen.
No, initially FIR is against only one accused.
And only one accused. That your honors will find at page number 31. The name of only one accused is mentioned.
He is accused number?
His present petitioner is accused number 2. The name accused is accused number 1. Then a further statement came to be recorded after a few days, after about 1 month. That is at page number 36, Annexure D. Further statement of Mr. So-and-so in crime number so-and-so. Additional complaint against Mr. So-and-so, and the name, our name is found, Advocate B. Manjunath. Then other names have been made. On 25/2015, I had filed an FIR against Mr. So-and-so as he had fabricated the share transfer certificates and forged my signatures for the same, and falsely claiming 90% share in the Alliance Business School. Based on such forged and fabricated document, there is an impending civil suit in OS number so-and-so before the city civil judge at Mayo Hall, Bangalore, in respect of the dispute of Mr. So-and-so. On 11/6/2015, it came to my knowledge through my advocate that the above civil suit, Mr. So-and-so has filed an application to implead himself in that case and has produced certain new documents claiming to have been executed by me and my husband, Mr. So-and-so, in respect of the alleged share transfer.
Filed the application to implead?
That is the accused number 1.
The suit is filed by?
The suit is filed by, my lord, in this matter, the suit is filed by the there are multiple suits were filed. I think, my lord, this, because some suits were filed by the respondent also, my lord, some suits were filed by the appellants also. But I'm not sure, my lord, I'll not provide the details of that suit. Then, my lord, the filed an application for implead himself in that case and has produced certain new documents claiming to have been executed by me and my husband, Mr. So-and-so, in respect of the alleged share transfers. Yesterday, I got access to the photocopies of these fabricated documents, and I've been shocked to see extent of these fabrication and criminal act. The photocopies of the fabricated documents that I've seen are memorandum of understanding dated so-and-so, share purchase agreement dated so-and-so, special power of attorney dated so-and-so. Copy of the fabricated documents are produced herewith. These documents were never executed or signed by me, nor my husband, Mr. So-and-so. In fact, I nor my husband had ever knew of the existence of such person, namely Mr. So-and-so, on 29/1/2015. Equally shocked in the fact that I did not know of the existence of any of these people who are allegedly claimed to be the witnesses of the document. It is also pertinent to note that these documents have surfaced now after I have filed the above FIR against Mr. So-and-so. And one of the documents, the share transfer certificate, shows fudging of the date from 29/1/2015 in one case to another date as on so-and-so, clearly showing the criminal intent and acts of these perpetrators. I would like to express my anguish over this most reprehensible behavior against a woman, and also given my health, these perpetrators have indulged in these most heinous acts of forgery, fabrication, manipulation of outright cheating which has serious legal consequences, and also fact that these activities have been carried out against women. Also, the above said documents have been fabricated in collusion with the alleged witness signatories, namely Mr. B. Manjunath, K. Srinivas Reddy, and Prasad Jairam. I also believe that many other have part of this criminal act and includes Mr. Mahesh, Virender, Sriram, Sukanya Reddy. Hence, kindly take suitable actions against all the accused along with the prime perpetrator. That's similar the first time when my name has been spelled out.
You are a witness to those.
Witness to document. I'll point out, Milord, the specific. Then the Honor will turn to Milord the page, the document number 30, page number 38, Annex E, that is the charge sheet. In the charge sheet at page number 41, my name is found as accused number 2.
How many accused are there
In all, Milord, 6 accused are there
in both the cases?
in both the cases. Except Milord first accused, all other Milord are the witnesses who have attested the documents.
Yes.
Specific allegations at page number 44 as against this petitioner. The page number 44, fourth paragraph from the top. Share purchase, fourth paragraph, it's the unnumbered paragraphs. Page number 44, I'm reading reference 44.
Yes.
Fourth paragraph, share purchase agreement.
Yes.
Share purchase agreement ದಿನಾಂಕ ಸಂತೃಪ್ತಿ ಸಾಕ್ಷಿ 2 ಡಾಕ್ಟರ್ ಸೊ ಅಂಡ್ ಸೋರ್ ಅವರು 1,20,000 ಶೇರ್ಗಳನ್ನು ರೂಪಾಯಿ 36 ಲಕ್ಷಗಳಿಗೆ A1 ಸೊ ಅಂಡ್ ಸೋರ್ ಅವರಿಗೆ ಖರೀದಿಸುವಂತೆ ಹಾಗೂ ಸಾಕ್ಷಿ 1 ಪ್ರಿಯಾಂಕಾ ಸೊ ಅಂಡ್ ಸೋರ್ ಅವರಿಂದ 1,05,000 ಶೇರ್ಗಳನ್ನು ರೂಪಾಯಿ 31.5 ಲಕ್ಷಕ್ಕೆ A1 ರವೀಂದ್ರ ರೆಡ್ಡಿ ಅವರು ಖರೀದಿಸುವಂತೆ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಸಾಕ್ಷಿ 2 ರವರೆಗೆ ಸಹಿಗಳನ್ನು ಫೋರ್ಜರಿ ಮಾಡಲಾಗಿದೆ. ಈ ಸುಳ್ಳು ಸೃಷ್ಟನೆ ದಾಖಲೆಗಳಲ್ಲಿ A1 ರವೀಂದ್ರ ರೆಡ್ಡಿ ರವರು ಸಾಕ್ಷಿಗಳಾದ A2 ಮಿಸ್ಟರ್ ಸೊ ಅಂಡ್ ಸೋ ಹಾಗೂ A4 ಪ್ರಸಾದ್ ಜಯರಾಮ್ ಅವರು ಸಾಕ್ಷಿಗಳು ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. That is not the allegation that they are the witness to the document. That's the only allegation against this petitioners are concerned.
Yes.
Otherwise, there is no allegation. What's the requirement in law, the Supreme Court and this Honorable Court has held, is whether we were part of the forgery, where we are aware, or whether we are we've got any benefit out of this forgery is what the requirement in law is. Then you only kindly turn to next document, page number 46. That is the share purchase agreement which is produced. In page number 62, document starts at page number 46, annexure F, and the last page of the document is page number 62. In the center of the page on the left side, my signature is found, Mr. Manjunath. As a witness, not attesting witness, he has signed.
Page number 62.
62. Page 62, my lord.
Immediately you have signed it.
I have signed as a witness. There is no dispute regarding my signature on as a witness. Then the next document, these are 2 documents which is alleged against
This
me.
is in shares purchase.
Share purchase agreement. Matters also, my lord, before the competent civil courts, there are multiple suits, not multiple suits have been filed. And the
You are
civil.
also signatory to the power of attorney, special power of attorney.
No, my lord, only these 2 agreements, the share purchase agreement as well as, my lord, this memorandum of understanding. These 2 are documents which have been signed by me.
Yes.
And last, one more document is at annexure G, page number 63, which is the MOU. That is at page number 69. My signature is found at page number 69.
You admittedly signed the 2 documents.
2 documents as witnesses. There is no dispute regarding signature. At this point of time, my lord, my
No, what is the suit? Who has filed it? What is the stage now?
regarding the suit, my lord, I'll have to, my lord, make it because what had happened is there is first is.
Then you contend that the very same similar contention is, the matter is pending before the civil court.
My lord,
Have to say,
I would have produced because what's happened is at the point of time, the civil suits filed, my lord, one is not petition before the, not the company law for the NCLT. Well, therefore, after the orders were passed, matters came before the civil court. Matters were pending before the civil court. My lord, those in the matters where the applications were filed to implead themselves, my lord, these documents were brought in. My lord, my submission before this honorable court, my lord, that is a dispute with regard to, my lord, the accused number 1 and the complainants, my lord, in both the matters. insofar as my role is concerned, Lord, what is the role of the accused, Lord, what the apex court has
Where
said?
is the charge sheet?
Charge sheet is filed.
Column number 17 or 7?
Charge sheet, as I read out, Lord, page number 44 is the allegation against me. The charge sheet is submitted in the year
This is the
2015.
charge sheet.
15 charge.
Yes. 44, page number.
Page number 44. That is the specific allegation against me is that I have signed ಸಾಕ್ಷಿ ಆಗಿದ್ದು A2 ಹಾಗೂ A4 ರವರು ಸಾಕ್ಷಿಗಳಾಗಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ.
Forgery, no, it is alleged.
It is but not as so far as not these as far as these petitioners are concerned, because insofar as this accused number 2 is concerned, there is not a thing allegation against.
For charge sheet, it is the allegation. What is your name, petitioner's name?
Manjunath, P. Manjunath. What is spelled out in the charge sheet, in both the charge sheets, Lord, is this thing as witnesses they have signed. Admittedly, even the further complaint is given after about 1 month. There also, my Lord, there is nothing that is stated that I have forged the document. As a witness, my Lord, I have signed. Not only this, my Lord, other accused also have been named. And, my Lord, similar situations, my Lord, where the apex court and, my Lord, this honorable court.
Apex court, first you give me the details of the suit. Filed by whom? What is the relief claim? What is the stage?
Let's say it may kindly be taken up at 2:30, my Lord, I will not secure the decree.
Yes. You are representing them. You are representing the petitioner in how many cases?
2 cases, sir.
Which are those? 7790.
89 and 90.
Accused number, petitioner is accused number.
He's accused number 1.
7789 90. Accused number 1. ನಿಮಗೆ ಯಾರು ಪೆಟಿಷನರ್ ಅನ್ನೋದೇ ಗೊತ್ತಿಲ್ಲದೆ ಏನ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರಿ?
Both accused number 1.
Accused number 1. And what about 60027? ಯಾರು ಅದಕ್ಕೆ? ಚೇತನ್ ಅಂಗಡಿ.
Is accused number 5, my Lord. 5, 6 and 7.
ಯಾರು?
Ado, insofar as other connected petitions, my Lord. One where, my Lord, Advocate Chetan, my Lord, is appearing. Srinivas and others, my Lord.
They are
Accused numbers 4, 5 and 6.
4, 5.
Sorry, 5 and 6, my Lord. 5 and 6.
5 and 6.
Please.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ? You get the details of this.
I will produce, my Lord, those relevant documents also, whatever orders have been passed.
Court officer. 40.5 ನಲ್ಲಿ ಏನು ಫರ್ನಿಶ್ ಕ್ಲಿಯರ್ R2 ಯಾರು? ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಯಾರು ನೋಡಿ? You represent both the complainants? Yes. Yes. Yes, you take notice for respondent number 2 in serial number 40/40.5. Same complainant. Who is representing the complainant? H.K. Srivastava. H.K. Srivastava. So and so undertakes to file wakalat for respondent number 2, 40.59. Yes, parcel 230. Next week. Let him produce it. Nimdena, there is some. You are accused number 1, main accused.
What?
Email. Tell her.
On submission, my lords.
Yeah.
My lords. My lordship has instructed me to verify the status of the lower court, my lords.
Which one?
First list, order number 2, my lords.
Serial number?
Serial number 2, my lord.
What is the stage now?
My lords, it has infatuated my on dated 36/2020, my lords, by order of acquittal, my lords.
36/2020?
36/2020. It was infatuated and order of acquittal.
Order of acquittal.
Yes, my lords.
I will record it and dispose it.
Please.
Then it is, serial number 2.
3, serial number 3, my lords.
3 na?
Please, my lords.
Then it is CGP submits that. By judgment dated 36/2020. Petitioners accused. Petitioner, sub-petitioner, one also. RI is unlawful. Quitted. Hence, the petition has become infructuous. Submission is closed on record, petition is dismissed. For the first year, counsel for the petitioner is absent no representation. Even when the matter is passed over twice. ಅದಾದ್ಮೇಲೆ Leonard SHP.
My lords, if I may make a submission. Serial number 11, my lords. Your
Serial
lordships had asked me to verify if we had personally served on respondent number 2, my lords.
Which one?
Serial number 11, my lords, list 1. My lords, the person who was handling this matter, my colleague at that point of time, I'm unable to get in touch with him. A short accommodation may be given, my lord. I'll
Furnish
verify
another
and
copy.
I'll verify
There
and
is
I'll
demand.
furnish the copy, my
Yes,
copy, my
it
lord.
may not take more than 5 minutes to copy it.
My lord, I
And
tried
give it.
getting in touch with them,
You
but
need not have to contact anybody.
I'll have.
Make the copy, serve the copy, that's all. Get the copies and serve it.
My lords, it's for respondent number 2, my lords.
Who is representing
That is
respondent?
the complainant, my lords. There's no one, my lords. They have been issued PF, my lords. I had paid the PF. However, they have not been served. Respondent number 2 is Mrs. Dilshad Banu. my
I
lords. She's
asked
the
you to
complainant.
verify why you have not taken hand summons and served on respondent number 2. There is a specific order.
My lords will ensure that it is done, my lords. A short accommodation
at
may be
this stage.
given, my lords.
Several years back, that order was passed. 3 years back.
Apologies, my lords.
Till today, you have no clue about that. Verify and tell me what you.
My
are
lords,
going
a
to do.
short accommodation, if it is granted, I'll do it.
For what
At least a
purpose?
day or 2, my lords.
For what purpose?
For verifying and confirming.
File a memo to the day. Yes. Second list ಇದು ಬಂದೇ ಇಲ್ಲ ನಾವು ಇನ್ನು. ನೋ ಆಗಲ್ಲ ಮಾರ್ನಿಂಗು ಆಗಲ್ಲ ಬಟ್ ಇಲ್ಲಿವರೆಗೆ ಬರ್ಬೇಕಲ್ಲ ಇಟ್ ವಿಲ್ ಟೇಕ್ ಎ ಲಾಂಗ್ ಟೈಮ್ ನೋಡೋಣ ಯಾರು ನಿಮ್ ಕಲೀಗ್ಸ್ ಯಾರಾದ್ರೂ ಇರ್ತಾರಲ್ಲ ನೋಡೋಣ ಏನು ನೋಡೋಣ ಅಲ್ಲಿವರೆಗೆ ಬರ್ಬೇಕಲ್ಲ ಸರ್.
See, number 15, please, ma'am. See, number 15, second lister. I'm not keeping your eye for the appellant. May be taken up in the next week. Afternoon. See, number 15, 138 of NA Act, acquittal. Next week it may be taken up.
ಅಡ್ಮಿಷನ್ ಇದೆ
Admission.
15 ಅಂತ ತಗೊಳ್ಳಿ. Waste of time. He undertakes to address the argument on the next date of hearing without fail. Submission is placed on record as 27. 27 to 11 years ಆಗಿದೆ. A question may arise, ಅವ್ರಿಗೆ ಕೊಟ್ರಿ ಅಂತ. His matter is pertaining to 2023. Yours is 13. That makes the difference. 2027. Sorry, serial number 27. Counsel for the petitioner pays for time. The appeal is of the year 2013. However, learned counsel for the appellant undertakes to address his argument on the next date of hearing without fail. Submission is placed on record, list on. Yes. Next date of hearing, please address the argument. ಎಲ್ಲಿ ಅದೇನು who is for the appellant ಬರ್ಲಿ ನೋಡೋಣ, let me see. First list ಆಯ್ತಾ, next second list. ಅಸೂರ ಆಮೇಲೆ ತಗೊಳ್ಳೋದು. ಆಯ್ತು. ಸೌಮ್ಯ.
Court officer. Court officer.
Yes. Yes.
My lords kindly,
Hmm.
but serial number 35, my lord, I was not there. It is connected to my lord serial number 28,
List number 2.
list 1.
List number ಮುಗೀತಲ್ಲ.
It is akin to my lord serial number 28.
Hmm.
May I request my lord, there is an interim order, my lord, I am seeking for extension only for a limited period.
So
my lord.
prayer is against ACB,
But I,
not in existence.
my lord,
You have not amended the petition.
But
And still you want to maintain the petition and extend the interim order.
but I may be permitted to amend the cause title, my lord.
In the application, sir, that is why it is kept.
Today only, my lord, your lordship may
Yes.
permit.
How long it was, the ACP was abolished?
uh,
When it was, the order was passed?
but August 2022, my lord.
Then
It was not
no
listed,
steps were taken all these days.
but it is mistake
Wait
on.
for time, extend the interim order. You are happy, we are also happy, all are happy.
Thereafter, my lord, matter.
Why these matters are to be kept pending, sir? Is there any justification for us? Either for you or for the court? At least we have to introspect, sir.
But I may be permitted to amend, my lord. I will amend, my lord, in
For that, you have to file an application. Without
application.
filing the application, how can you, I permit you? That is what I asked you.
For that, my lord,
For that, pray for time.
petitioner.
Extend the interim order. The
Petition-
same submission. Either way. That hurts me, that's all. Even though the matters are being listed for years together, there is not even an inch of progress we are making. Why we are sitting here? That is the question. What we are doing? Why the public should repose confidence in this institution? ಏನಾದ್ರು ಹೇಳಿದ್ರೆ ನಿಮಗೆ ಬೇಜಾರಾಗುತ್ತೆ, ಏನೋ ಹೇಳ್ತಾರೆ ಅಂತ. ಇವ್ರೊಬ್ರೇನ ಕೆಲಸ ಮಾಡೋದು ಅಂತ ಬರುತ್ತೆ, ಎಲ್ಲ ಬರುತ್ತೆ, I know that. But I am expressing my feeling ಅಷ್ಟೇ. Nearly 7,000 criminal appeals are pending since from 2011. And criminal petition 2011. All proceedings are stayed, luckily. What signal we are giving? For 13 years, if the criminal proceedings are stayed, what remains? That is the only anxiety I am having. Once the stay is granted, it will continue forever. 10 years, 15 years, 25 years, let it go. Neither you are bothered nor we are bothered. Not only in your case, generally I am speaking.
As a final chance, my lord, your lordship.
Finally, it has lost its meaning. When nobody is respecting that term, finally, why should it be used? At least in 10 matters, 10 advocates, yes, we are ready in this matter. If you come forward, I will be happy, more than happy. Otherwise, why we should sit here? Why the matters are to be listed? At whose cost it is being listed? I am asking the question to myself. How many persons are working on that to list a matter? What is the amount that is the state is spending for that? That is out of our own tax-paid money. It could have been spent for better purposes. That is the anguish I am having. 28 to 35, praise for time. Next. 35 and 28, next. Yes.
20.
Huh.
35, my lord.
35 also agenda.
The interim order may be extended
Actually,
till
automatically.
next year.
As of right, you are entitled for extension.
Not me, my lord.
Yes, I feel I
I'm-
should not have.
I'm requesting.
Just extend the interim order. Okay. Why should I bother? Next. List 2.
Matters.
But I'm sorry, my lord.
No, sir, there is nothing. See, I am not referring to you as an individual. After seeing the list, this is my anxiety. You question yourself. I'm requesting the entire fraternity of advocates. I am questioning myself. Why I am here, what I am doing here. If everyone start thinking in that line, we can make some progress at least. 7,000 criminal appeals, 4,000 criminal petitions, writ petitions. Starting from 2010-11. At least in the old matters, we will get ready. No, never. Even in 2011 matter, pray for time, extend the interim order. Yes.
List 2, serial number 1, GS Balagangadhar, NR Ravi Kumar.
Appellant. Appellant kindly 2 weeks time granted me. Steps party
When he died?
ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
Referred
advocate ಹೇಳಿದ್ರು ಡೆತ್ ಆಗಿದೆ ಅಂತೇಳಿ.
When it was reported?
2011-2023 and 5/12/2023.
Then counsel for the petitioner.
2 weeks time
appellant
granted.
Again, prays for 2 weeks time to take steps against the deceased appellant. The death of the appellant is reported.
ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ, ಇಂಟಿಮೇಷನ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳಿ.
You until today, the learned counsel for the appellant is not aware of the date of death of the appellant, nor he knows about the details of the legal representatives left behind by the deceased. The appeal is of the year 2014. I do not find any reason to adjourn the matter, as the appeal is already abated. However, to afford one more opportunity to the appellant, list finally as the last chance. Friday.
Please.
Serial number 2, Raju CN, P. Rangaswamy, PG Gopal Swamy.
Lord, respondent number 4 purposely, my lord, avoiding taking service of notice may be issued to NBW, my lord. 4-5 times I have taken steps. Is residing in the same address. He is avoiding, my lord. The appellant is the complainant.
File an affidavit to that effect.
Please.
Please, next.
Serial number 3, K. Neelakantachar.
ಯಾರಿಗೆ? Counsel for the appellant is absent, no representation. Every respondent. Even on the last date of hearing, the counsel for the appellant was absent. The appeal is of the year 2021. Notice was ordered to be issued to the respondent on 14/2/2022. PF for issuance of notice is not furnished. Till date. Hence appeal is dismissed as for non-prosecution. Next.
Serial number 4, Madhukar M. Deshpande.
Yes, I seek for 2 weeks' time, my lords. Respondent is a Namibian citizen, my lords. Notice has to be served in a particular format. Copy of format I have received it today from the registry, my lords.
When issuance of notice was ordered? When notice was ordered? In the month of February.
Yes, my lords.
Still you are at the stage of receiving the format.
My lords, he is a Namibian citizen, my lords.
Maybe you know that when you filed, you preferred an appeal.
No, my lords. No, I mean, by that time he was in India, my lords. He is now absconding. He is not in India.
Whereabouts are known to you.
The last whereabout we know, we have served copy there. There's no response from
But
that.
admittedly, he is not there.
Yes.
Then how will you serve?
A week's time may be granted. I will keep IO present
How
on next.
will you serve? Tell me that. What is the procedure to be adopted?
I'll keep the IO present on next date of hearing, my lords.
Huh?
I will keep the intelligence officer on next date of hearing.
What is your instructions today?
We'll
Pray for time, Ashte. Praise for time. Next.
Serial number 5, Krishna S. Vyasa.
Counsel for the appellant is absent, no representation. Notice was ordered to be issued. Notice was ordered against respondent as per order dated 24/2/2023. Till date. PF for issuance of notice is not furnished, hence petition dismissed. And it appears that the appellant is not interested to prosecute the appeal, hence appeal is and dismissed. Next.
Serial number 6, Somshekaraya RP.
Your Honor, serial number 5, Krishna Vyasa. Advocate and change ಮಾಡಿದ್ರೆ
ಯಾವ್ದಮ್ಮ?
Krishna Vyasa, serial number 5.
ನೀವು ಯಾರಿಗೆ? ನೀವು ಯಾರು?
ಸುಜಾತ ಹೆಗಡೆ ಅಂತ ನಾ ಸೀರಿಯಲ್ ಆಕ್ಚುಲಿ ಹಾಕಿದ್ದೀನಿ. ಅಪೀಲ್ ಹಾಕಿ
ನೀವು ಅಪೀಲ್ ಹಾಕಿದೋರಾ?
ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡಿ ನಾನು ಇನ್ನು 1 ವಾರದಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ನೇಮಕ ಮಾಡ್ಕೊತೀನಿ.
ನೀವು ಸ್ಟೆಪ್ಸೇ ತಗೊಂಡಿಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ?
ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಬೇಡ, ಅಬ್ಸೆಂಟ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅದೆಲ್ಲ ಆಯ್ತು. ದಿ ಅಪಲೆಂಟ್ ಶ್ರೀಮತಿ ಸುಜಾತ ಹೆಗಡೆ. ನಿಮ್ಮ ಹೆಸರು ಸುಜಾತ ಹೆಗಡೆನಾ? is present before the court and prays for time. Please down. Yes. ಅವ್ರಿಗೆ ಡೇಟ್ ಕೊಡಿ ಹೇಳಿ.
7th August.
August 7th ಗೆ ಅವತ್ತು ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡ್ಕೋಬೇಕು, ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು. Yes. Consent of the appellant is absent, no representation. Even though the notice is ordered to be issued as per order dated 28/2/2023, till date the PF is not paid for issuance of notice. Nor there is any representation. It appears the appellant is not interested in prosecuting the appeal, dismissed. Next.
Serial number 7, Ravindranath K.
Counsel for the appellant submits that PF for issuance of notice is paid. Office to verify. If PF is paid, issue notice. Next.
Hearing on IS, serial number 8, MS Raghavendra Prasad, Manjunath G. Kandekar.
For the respondent.
Yes.
For recalling they have filed, I am the respondent.
You are for the respondent.
Please.
Appellant, Mr. Raghavendra. Counsel for the appellant is absent, no representation. Counsel for the respondent is present. They use the materials on the file. The appeal was going to be dismissed for non-prosecution with the order dated 23/8/2023. The application for recalling the said order was filed in IA 1 of 2023 on 23/8/2023. In spite of that, there is no representation. I do not find any justification. Otherwise, one could.
On 23/8/2023 it was.
A justification of the Kiltamagla. I will peruse the application and the affidavit accompanying the application. Filed by the learned counsel representing the appellant. He pleads health reasons for not being present before the court when the appeal was going to be dismissed for default. In spite of that, there is no representation today, which makes clear that neither the appellant shall not put it, nor their counsel, his counsel, nor counsel are interested in prosecuting the matter. I do not find any justification to entertain the application, hence IA 1 of 2023 is dismissed. Application dismissed. Next.
Serial number 9, Manjunath B.R. Narayan Pedalkar.
My objection to the application filed by the appellant. Objection.
Who is the appellant?
I represent the appellant.
Whether he is complainant.
Please, my lord, I am the complainant before the trial court.
Objection to the application filed under section 391 CRPC.
Again, what is that?
But I had filed an application.
No, because we want to add some
What is
evidence,
that, sir?
additional evidence.
He is filing statement of objections to IA number 1, which is filed by me, my lord.
File in the office in accordance with rules. What is the additional documents you have produced?
But the additional documents are the company documents wherein, my lord, the respondent accused had incorporated. But those are the first documents. The other documents are the sale deeds, my lords, in order to show that I had the financial capacity of lending amount to the.
Those documents are not produced before the trial court.
But he was under the impression that, my lord, the accused would be.
Automatically, your complaint will be considered. And the accused will be
But
convicted.
subsequently, after the judgment of Krishna Janardhan, but, my lord, additional document was required under 138. But when the
that
complaint
decision-
was filed,
When that decision came,
2008, my lord.
when your complaint came to be dismissed,
But my complaint was dismissed in the year 2014.
after 6 years.
he could not produce those documents, my lord, and now he has filed an appeal.
Your justification goes away. Counsel for respondent prays for time to file objection to IA 24. IA 1 of 2020 and IA 1 of 2015. Sufficient time is already granted. However, to afford one more opportunity, list down.
Serial number 10, K. Krishnappa.
Counsel for the petitioner appellant is absent, no representation. It is noticed that IA 1 of 2024 is filed seeking issuance of notice through paper publication under Order 5 Rule 20 CPC. The notice to respondent is issued only once, and therefore the application cannot be considered at this stage. Counsel for the appellant to take steps for issuance of notice to respondent. This term. Next.
For admission, serial number 11, Manjunatha P. B.M. Alaswamy.
Although IA 1 of 2024 dismissed might be. Hence, IA 1 of 2024 is dismissed.
Serial number 11, Manjunath P. B.M. Alaswamy.
When counsel for the appellant is absent in representation. The appeal is of the year 2019. Do not find any reason to adjourn the matter, however, to afford final opportunity based on. Next. 12.
Serial number 12, Kenchegowda B.
I appear for respondent number 9, my lords.
So Kenchegowda.
My lords are directed to submit the status.
Yes. Yes, tell me, sir. Yes, who is representing the respondent? Hello, bro. Counsel for respondent number 9.
Serial number 12, Kenchegowda B.M.
Appellant is absent, no representation. While condoning the delay of 223 days and allowing the A2 of 2020 video order dated 12/12/2023. This court ordered the appellant to deposit the sum of the cost of rupees 2,500 with High Court Legal Services Committee within 1 minute. Till date, compliance is not reported. Consequently, the conditional order passed on IA2 of 2020 and reversed. Accordingly, IA2 of 2020 is dismissed for non-compliance of the conditions. Consequently, the appeal stand dismissed. Yes.
Serial number 13, Ashwini Sanadi, HP Shivramu.
Appear for the appellant, my lord. Lords,
Kindly pass on.
Yes.
lords, the accused, my lord, is acquitted of the offences punishable under section 713(1)D of the Prevention of Corruption Act, my lord. Lords, the accused, my lord, the respondent, my lords, initially demanded a bribe of 10,000. My lords, 8 witnesses were examined on behalf of the prosecution, my lord, and 15 exhibits were marked. My lords, PW2, my lords, is the punch witness, my lord, and PW6 is the shadow witness. My lord, PW6, my lord, has turned hostile. My lord, the honorable judge.
Tenant is PW
My lord, for PW1, my lord.
1. We
Please.
supported.
Please, my lord. He has supported. Lord's PW6, my lord, is the shadow witness, my lord, who has turned hostile.
Then
My lords, the trap was conducted, my lords, in which, my lords, the solution has not turned into pink, my lord. My lord, thereafter, my lords, the honorable judge holds, my lord, that there is no demand, my lords, and acceptance of the bribe amount.
what about FSL report?
Please, my lord.
FSL report.
FSL report, my lords, is in the negative, my lords. But
Negative.
please, my lord, but PW2, my lords, exhibit.
Exhibit.
My lords, exhibit, my lord. My lords, exhibit P14, my lord.
14.
Please, my lords, the honorable judge, my lords, records a finding that, my lords, the complainant, my lords, in a departmental inquiry has deposed in favor of the accused. And therefore, my lords, since he has deposed contrary in this particular proceedings, my lord,
In the departmental inquiry, he deposed in favor of the
accused, my lord, that is the find.
Favored the accused.
No, my lord, he has not. The complainant has, my lord, supported the case of.
So in the departmental inquiry, you supported the accused.
That is not me, my lord, the complainant.
You are for the
I
complainant.
am for the Lokayukta institution, please.
Then,
My lord,
where is the scope for conviction, sir?
My lords, what has happened is, my lord, the presumption under section 20, my lords, has not been considered.
Only on the basis of presumption, you cannot seek conviction.
My lords, because PW2 has supported the case of the prosecution, my
So
lord.
you-
My lords, the punch witness, my lord.
Punch witness, but
Punch-
shadow witness has turned hostile.
But
Hand wash has not turned into pink color.
please, my lord,
FSL report negative.
negative.
What is there to convict?
My lords, the
Only
basis,
interested testimony of PW1.
PW1 and PW2 also, my lord, he was present during, my lords, the
It supported the accused in the departmental.
departmental inquiry. Here he has supported his case, my lord, the
Then-
complainant.
Conduct of PW1.
My
How
lords,
can we believe him?
my lords,
It is not.
my lords,
credit to
that evidence probably was given on a different footing, my lords, where, my lords, departmental inquiry, your lordships are well aware, my lords, that only preponderance of probabilities, my lord, here.
Even then,
Please, my lord.
see, it is not the case that the complainant has supported the case and the departmental inquiry ended in giving clean chit to the accused, not. The complainant has turned hostile there.
Please, it is not turned
He has
hostile.
given the evidence
it
in
is
favor
not-
of the accused.
It is not entirely turning hostile, my lord. My
And
lord, see, some
he favored
statements
the
he
accused.
says he favored the accused, not in the
In
entire
other
sense.
words, hostile anta ಹೇಳ್ತೀವಿ ನಾವು.
Not entirely, my lords, but that needs to be relooked by your lordship, my lord. If your lordships give me one more opportunity, my lords, we
ಎಲ್ಲಿ
will.
trial court records ಇದೆಯಾ? ಹ? Admission ಬಂದಿಲ್ಲ. ಇಷ್ಟೆಲ್ಲ ಇದ್ಮೇಲೆ ಮತ್ತೆ ಇನ್ನೇನಿದೆ ಸರ್? ಏನ್ ನೋಡ್ಬೇಕು?
Lordship may, lords, at least PW2, my lords, the evidence your lordship may kindly consider in the light of the presumption.
PW2 is not, is the punch witness.
Please,
But he is not the shadow witness.
not the shadow witness. Lords,
What
as
evidence could be attached to his evidence?
my lords, evidence to the effect that, my lords, he was present at the time of conducting the trap
During trap
proceeding.
panchanama.
Yes,
ಅಷ್ಟೇ. During trap, he will not be present.
he will not be present.
Then on the basis of his evidence, how can you seek conviction?
My lords,
Absolutely no material.
it's at least
ಅಷ್ಟೇ, ಇದೇನು ಇಲ್ಲ. ಬಿಡಿ.
Section 20, my lords, may kindly be considered,
20,
my lord, in presumption, my lord, in the
Presumption,
light of.
sorry. Evidence ಇಲ್ದೇ ಇದ್ರು presumption ಮೇಲೆ
ಅಲ್ಲ, ಇಲ್ಲ.
conviction ಅಂತನಾ?
Your lordship may have a relook at,
Okay.
lordship may have a relook at the evidence, my lord.
ಏನಿಲ್ಲ ಸರ್, ಸುಮ್ನೆ ಇಲ್ಲಿ shadow witness ಇಲ್ಲ, FSL ಇಲ್ಲ, solution pink color ಆದ್ರೂ ಇಲ್ಲ. And the evidence of PW1 is not credit worthy.
In this proceedings, he has supported, my lord.
These four circumstances are enough to acquit the accused. See, presumption says where public servant accepts any undue advantage. So you have to demonstrate acceptance of undue advantage.
My lords, undue
You are
advantage.
not successful at the first step itself.
An undue advantage would be, my lords, but that, my lords, the work of granting subsidy, my lords, was with the accused itself, my lord. My lords, who was the assistant horticulture officer. My lords,
Somebody must say that. There must be the evidence worth believing. Then the presumption arises. Primary burden is always on the prosecution. You have not discharged that. Futile exercise ಅದೇನು ಆಗಲ್ಲ. Befitting case ನಲ್ಲಿ ಮಾಡಿ, ಅದು ಸುಮ್ನೆ unnecessary ಇದೆಯಾ ತಗೊಳ್ಳಿ. The state by Karnataka Lokayukta Police referred the appeal impugning the judgment of acquittal dated 3/4/2019, passed in a special C number 121 of 2009 on the file of so and so. Acquitting the accused for the offence punishable under section 713(1)D, read with section 13(2) of IPC Act. Order so and so. Learned counsel for the appellant submitted that PW1, the complainant, has logged the first information, making specific allegations that the accused had demanded
demand was for rupees 10,000, my lords, which was
Demand
later
was
negotiated to
10,000.
8,000.
$10,000 to show the official favor. The FIR was came to be registered. Pre-trap Panchanama was drawn, entrusting the amount to the complainant in the presence of Panchas. Trap was held and the accused was apprehended. The entrusted amount was recovered under the trap measure. The prosecution has examined as many as 8 witnesses.
Please.
And got marked 13 documents,
Lords, 15.
15 documents. The trial court, without considering the oral and documentary evidence, and also not taking into consideration the presumption under section 20 of PC Act, proceeded to acquit the accused without any basis. Therefore, the appellant is before this court. Next, when counsel for the appellant submitted that the evidence of PW2, who is also a master witness, is to be considered by this court while appreciating the evidence of PW1. If the oral evidence on record are taken into consideration with the plain meaning, the appeal may have to be allowed. He further submitted that even though the complainant PW1 has given this evidence favoring the accused in the departmental inquiry, the same cannot be a ground to acquit the accused in the present case. The, in view of the oral evidence led by PW1 and 2, the accused is liable for conviction. Accordingly, he pays for allowing the appeal by setting aside the impugned judgment of acquittal passed by the trial court. For control and counsel for the respondent opposing the appeal submitted that the shadow witness examined as PW6 has not supported the case of the prosecution. Only the interested version of PW1 is available. But in the departmental inquiry, he has not supported the case of the prosecution. Under such circumstances, the trial court was right in acquitting the accused. No grounds are made out to reconsider the contention of the prosecution once again. Accordingly, pays for dismissal of the appeal. There is the materials on record in the light of the rival submissions. PW1 is the complainant who filed the first information, upon which the FIR was came to be registered for the aforesaid offences. Pre-type Panchanama was drawn in the presence of 2 witnesses. They are PW2 and 6. PW6 is the shadow witness. He is a witness to the entrustment, demand and acceptance of illegal gratification. But admittedly, PW6 has not supported the case of the prosecution and is treated hostile. Interestingly, PW1, the complainant, has not supported his contention, his own contention, during the departmental inquiry. However, he supported the case of the prosecution when examined as PW1, but his version is not creditworthy to be accepted as the sole basis to convict the accused. Admittedly, the version of PW1 remained uncorroborated. Moreover, the hand wash of the accused during trap Panchanama had not turned into pink color, and the FSL report is also negative. FSL report marked as Exhibit P14 is the negative for presence of phenolphthalein powder. Under these circumstances, the presumption under these circumstances, the prosecution is not successful in discharging its initial burden of proving the guilt of the accused. When the prosecution fails to discharge its initial burden, the presumption under Section 20 of PCI will not come to the rescue of the appellant. Hence, the accused is, hence it could be stated that the prosecution has not proved the guilt of the accused beyond reasonable doubt, and the accused is entitled for acquittal. Next, I have gone through the impugned judgment of acquittal passed by the trial court. It has taken into consideration the oral and documentary evidence placed before it, and I have arrived at a right conclusion. I do not find any illegality or perversity in the judgment impugned. Hence, I do not find any reason to, hence, I am of the opinion that no grounds are made out to entertain the appeal. Accordingly, I answer the other point in the negative. Dismissed. Next.
Serial number 14, S.V. Prakash, Santosh Raj Deshmukh.
Appeal for respondent, my lord.
Complaints appeal, my lord.
Yes.
The offence is under section 138 Act, my lord. The trial court finding is that, my lord, in para 25 of the judgment, ink page number 28,
Complainant is examined as,
PW1.
have you examined any witness?
Defense, no, no witness.
Only PW1 is
Yes.
examined. How many documents are marked?
Documents, exhibit P1 to 8, my lord.
Accused has not laid any evidence.
No, no defense evidence. And no documents.
What is the check amount?
In both cases, each 2 lakhs, my lord.
There are two checks.
2 checks, 2 cases. 2201 and 2206,
2 lakhs each.
2 lakhs each. The complaint is also carrying the business, my lord, paddy, coconut, and such other agriculture produce.
Why he was acquitted?
Thing is that he has not proved that it is lent.
Existence of legally recoverable debt.
Right.
Why
Check
the court
he-
held like that?
My lord, presumption under section 139 is clear, my lord.
But
Trial court-
primary burden you have to discharge.
Yes, it is what the defense, I have stated in my evidence, same has been taken into consideration, my lord. Because he is known person. He was carrying business with me. He was purchasing paddy and other agriculture produce on
Issue-
credit basis, my lord.
Issuance of the checks is admitted.
Yes. And in 313 statement, my lord, what the defense, what has been put in the cross examination, nothing has been stated in 313 statement.
313 statement, mere denial.
Yes, simply denied. In both cases, common judgment has been rendered, my lord.
What is the
The-
reason assigned for acquitting?
Acquitting parrot 25, my lord. I drive large, take to 25, ink page number 28. May I read my
Para number 25.
25?
Huh.
To rebut the presumption favoring the complainant, the accused relied on the materials submitted by the complainant. It is a specific defense of the accused that both checks are issued by the accused in favor of the complainant for security purpose. In respect of credit business transaction that accused had with the complainant in respect of purchase of paddy and other agricultural produce. The complainant PW1 has admitted in the cross-examination that complainant used to purchase the paddy and other agricultural produce from the farmers, and after collecting the same, he used to sell it to the accused. It is further brought from the mouth of PW1 in the cross-examination that the accused used to obtain agricultural produce from the complainant on credit basis. Even it is brought from the mouth of PW1 in the cross-examination that the accused had purchased agricultural produce on credit basis ranging from lakhs together. Therefore, it is defense of the accused that the check was were issued for the security purpose in respect of the credit transactions the accused had with the complainant. Though it has been denied by the PW1 complaint, the check were issued for security purpose in respect of purchase of agricultural produce by the accused from the complainant on credit basis. But it is to be noted in the complaints, the complainant has narrated that the accused approached the complainant in the month of January 2020 and sought for financial assistance for the development of business of the accused and sought for rupees 4 lakhs, agreeing to repay the said amount within 6 months. Based on the trust, the complainant has lent the amount of rupees 4 lakhs in the presence of Sri Vasant Kumar and Rajiv and Dattatreya. Prospect action. It is to be noted that there is that in the entire
The amount lent, or is it towards credit purchase?
no, it is not credit purchase.
You
What
lend the amount.
the relationship which they have developed in the business,
Yes.
he believed that and he assisted them by lending 4 lakh rupees.
Yes.
that what has been stated in my complaint and in my chief examination, that has been taken as a defense.
Yes.
And what he has stated and taken the defense has not been stated in the 313 statement, my lord. It has not transpired. And it cannot be taken into consideration as he rebutted the presumption.
Yes, read for the para 26.
In the cross-examination of PW1, when a specific question was posed to PW1 that when the complainant has lent the amount of rupees 4 lakhs to the accused, PW1 stated that it is in the month of 11th month of 2020. There is a discrepancy, my lord. In the complaint, it has been stated that in the month of January 2020. Only on that ground, the entire transaction cannot be disbelieved. Even the company failed to state as to what exact date the complainant has lent the amount to the accused. Here it is necessary to mention the decision reported in 2007 Part 2 CCC, page 763 between Parameshwarappa and Chavadappa, where it has been held that once we conclude that a trial under Section 138 Negotiable Instruments Act is a quasi-civil rules of pleadings as available under Order 6 Rule 2 is to be applied. As per Order 6 Rule 2 CPC, every pleading shall contain a statement in concise form of material fact on which parties relies for his claim or defense as the case may be, but not the evidence by which they are to be proved. It is to be noted that in the present case, there is no mention as to when exactly the complainant has lent the amount of rupees 4 lakhs to the accused. Therefore, such fact being material fact has not been mentioned by the complainant, which raises doubts as to the case of complainant as to lending of amount. That apart, it is necessary to mention the decision of Honorable High Court reported in in case of Yashwant Kumar versus Shant Kumar, wherein it has been held that non-mentioning of the date of lending, the amount is also ground to suspect the case of the complainant. In the present case, concluding manner, state of the complainant has not stated in the complaint as to on what date complainant has lent the amount to the accused. Even in the cross-examination PW1, when a specific question was posed as to when exactly the complainant lent the amount to the accused, the PW1 has stated that he has lent the amount in 11th month of 2020, but failed to state the exact date. It is necessary to note that in the complainant, it is specifically narrated that after receiving of the amount of rupees 4 lakh by accused from the complainant, accused has issued check after lapse of 1 year. If the said averment is taken into consideration in the backdrop of the evidence of PW1 stating that the complainant has lent the amount of rupees 4 lakhs in the month of, maybe it is a typographical mistake, November 2021, it is 2020 Act. The check should have been issued in the month of November 2022. But the Exhibit P1 checks in both cases disclose that he said that said checks were dated 28/6/2021. This observation is contrary to the documentary evidence.
Legal notice was served on the accused.
Yes,
Any reply?
not replied. Not replied. No. Exhibit P4 is the legal notice.
Postal cover on the it was not served.
One.
Not claimed.
Door lock.
Door locked first day. 7 ದಿನಗಳ ಕಾಲ ಇಲ್ಲದ ಕಾರಣ ವಾಪಸ್.
Cover ಮೇಲೆ endorsement ಆಗಿದೆ.
It is on the first day, sir.
First day, thereafter do on the
7 days. door lock.
7 days.
Then where is the service of notice?
My lord, in the cross examination, this address which has been sent, letter was sent, notice was sent, has not been disputed, my lord.
No, door lock anta iddaga, how can you say that it is served?
My lord. Because it is contested, my lord. In the while cross-examining the PW1, this aspect has not been disputed. Door lock, may I pass on this?
ಏನಿದು? ಆಯ್ತು, ಇಲ್ಲಿದೆ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಐ ಆಮ್ ಸೀಯಿಂಗ್.
Yeah, sir, records ಇದೆ.
ಹೌದು.
Regarding this, my lord, and address which has been written on this envelope has not been disputed.
No, what is the evidence? What is your evidence regarding that service of notice? Even according to you, it was not served.
ಇಲ್ಲದ ಕಾರಣ ವಾಪಸ್ ಕಳುಹಿಸಿದೆ ಎಂದು ದಿನಾಂಕ 27/9/21 ವಾಪಸ್
ಬಂದಿರುತ್ತೆ.
ಕಳಿಸಿದೆ. ಆದ್ದರಿಂದ ನನ್ನ ಈ ಫಿರ್ಯಾದು. This is
So
cheap.
even according to the complainant,
Yes.
notice is not served.
But my lord, it is invariably held by this honorable court as well as apex court, my lord. When the address has been mentioned in the legal notice on the envelope, which
When there are no materials to hold that the notice is not served, or was served anta illde iddaga, we can presume that if the address is correct, it is presumed to have been served. But here, the negative
lord,
evidence is you have led.
the same address, my lord, in the complaint also
Maybe
same
the
address.
door was locked, sir.
Yes.
He is not disputing.
My,
When it was turned, when
two-
the
two
postman
aspects,
has
my
gone
lord.
there, the door was locked.
The service of notice not disputed, my lord. That aspect has not at all been.
Burden is on the complainant to prove. That is the requirement of 138.
140, it is burden lies upon me, but I have sent it and complained. For having served the notice, it is not disputed by the accused, my lord. My lord, that area has not at all been taken by the.
I am asking you now.
Yes, my lord, I have sent it. And what the address written on the envelope.
You may say so many things, sir. But the evidence, your evidence is that the notice sent to the accused returned unserved, jari agade iruttade.
Yes.
Then the document exhibit P6, it shows it is returned to the sender as door locked.
Yes. On this, kindly 2 days time may be granted, I will argue it on that. I'll show the material. Because the accused has not at all even whispered in the
Necessary,
cross-examination.
Not necessary. Let us assume that the accused has not contested. The primary burden is on the complainant to prove the requirement of section 138.
No, his case is totally different premise, my lord. Because he has taken that
What
as
I'm
a
saying.
security, I had given this
Yes.
notice.
I am
Checks.
not on that, sir. About service of notice.
I will convince your lordship. I will
Necessary or
convince your
not?
lordship. Kindly 2 days time.
This is all well settled propositions of law.
I'll
ಇದಕ್ಕೆ
satisfy.
ನೀವು 2 days ಅಲ್ಲ 20 days ತಗೊಂಡ್ರು you cannot convince.
I will put effort and convince your lordship.
ಅದಕ್ಕೆ ಏನೇ ಕೊಡಿ. ಇಲ್ಲ. Hmm, 138 proviso B. That is the requirement of law. Issuing a notice in writing to the drawer of the check.
And 2 days. I'll convince your lordship.
In the other appeal, the notice is served.
That also. Yes, it has been served in that case.
Yes.
In another case, it has been delivered.
ಅದಕ್ಕೆ ನೋಡ್ದೆ ನಾನು ನೋಡಿದ್ನೇ ಕೇಳಿದ್ದೀನಿ.
ಅದಕ್ಕೆ, in this matter, my lord, the service of notice has not been raked up by him. He
Needless to
considered
say,
it.
even according to you, PW1 affidavit, you say ಮರುಪಾವತಿಸುವಂತೆ ನೋಟಿಸ್ ಕಳುಹಿಸಿದ್ದು ಸದರಿ ನೋಟಿಸು ಸದರಿ ವಿಳಾಸದಾರರು 7 ದಿನಗಳ ಕಾಲ ಇಲ್ಲದ ಕಾರಣ ವಾಪಸ್ ಕಳುಹಿಸಿದೆ.
ಅಲ್ಲ, ಡೋರ್ ಲಾಕ್ ಅಂತ ಬಂದಿದೆ, ಅದು
Even
ಬರ್ದಿದ್ರಲ್ಲಿ
according to
ಸ್ವಲ್ಪ
you, it is
ತಪ್ಪಾಗಿದೆ.
returned answered.
Yes.
P6 is the envelope returned answered. Where is the
Due
question
to
of?
door lock.
Huh?
Yes.
Where is the question of accused taking?
And it is not the defense of the accused, my lord, that I am not residing in that address.
Let him be.
I have changed my
present.
abode.
Let him be present. Let him be residing in the same address.
ಅಲ್ಲ, I will convince you.
Door lock ಇದ್ದಾಗ ಹೇಗೆ? How can you say that it is served?
ಅಲ್ಲ, 7 ದಿವಸನೂ ಲಾಕ್ ಆಗಿದೆ ಅಂತ.
Unserved.
If it is address, abode is changed.
Yes, sir, that is not the proposition of law.
That I will convince your lordship, certainly. Because in the cross examination, nothing has been whispered.
Not
His
necessary.
defense is totally different.
Not necessary. The burden is on the complainant.
Yes, certainly. And
Accused need not have to take a defense.
my lord, one thing. he has not denied the issuance of check. Signature not denied.
But still.
Only the purpose is disputed.
requirement-
The purpose is
under-
disputed, my lord.
Requirement under section 138 is to be compliant.
No, I will convince your lordship.
Plus
my lord,
that is
on the-
compliant, you cannot
this
maintain the
premise.
complaint. Third learned counsel for the appellant, after addressing the argument for some time, and counsel for the appellant waits for time to convince the court that even though as per exhibit P6, the legal notice was returned and served as door lock, it amounts to valid service on the accused this time.
It may be on 5th, my lord.
Huh? 7, yes, next,
On 5th, my lord.
7.
7.
Serial number 15 Arjun, 16 Archanamurthy, Nehru MN.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ 2201 ನಲ್ಲಿ ಮಾಡಿ.
Senior is in portal 24 argument.
ಯಾವ್ದಿದು 16.
Prayer for a time.
Learned counsel for the petitioner, appellant wait for time. Next.
Serial number 17, Leeladhar HP, Vijay Kumar K.
Appear for the respondent.
ಬಂದಿದೆ. Await records. Next.
Serial number 18, Somshekar KM, Nagratnamma KN.
Appear for the appellant minutes. Is held up in some other court minutes. Portal number.
Order sheet. Counsel for the appellant prays for time. Next.
RP Somshekaraya, serial number 19.
Counsel for the appellant is absent, no representation, list on.
Serial number 20, BB Piddo, Rupesh NR.
Counsel for the appellant is absent, no representation.
For further hearing, serial number 21, Jeevan Kumar BS, Simana.
For the respondent. For appellant, kindly pass over, he is in, end up in another court, please, Lord.
Pass over.
Grateful.
For final hearing, serial number 22, BS Prasad, Nagarajappa A.
I'm appealing for appellant, my lord. Kindly grants 2 weeks time, my lord. I'm informed, my lord. Morning I have moved, my lord.
12 years ಆಯ್ತಮ್ಮ.
Please, my lord. My lord, senior is not well, my lord. Morning I have moved adjournment, my lord. Also. I have also informed to.
You are for the appellant or respondent?
Respondent.
Appellant.
I am for the appellant. It's a PC Act.
Ready.
Kindly pass over, ready, madam, kindly pass over the matter.
Ready ಇದ್ಮೇಲೆ ಮತ್ತೆ pass over.
ಅಲ್ಲ, ಅವ್ರು ನಾನ್ ರೆಡಿ ಇಲ್ಲ. ಸೀನಿಯರ್ ಅವಾರ್ಡ್.
ಎಲ್ಲ
PC Act.
seniors engaged, huh?
No, it's a PC Act matter, it's a local act matter.
So what? Counsel for the appellant and respondent, pray for time. Both the learned counsel undertake to address their arguments on the next date of hearing without fail. The appeal is of the year 2012. Facing this, the undertaking of the learned counsel on record. List on. Short date today. Next date of hearing, both of you should address the argument.
Serial number 23, CM Desai, Mr. Dev, Hari Prasad.
Appearing for the respondent number 3, Your Honor.
Yes, tell me about the facts.
My lords, I seek a short date. We'll address our arguments on the next date of hearing. A week's time may be granted, my lords.
Counsel for the appellant is absent, no representation. Learned counsel for respondent number 3 is present, but he prays for time. The appeal is of the year 2012. I do not find any reason to adjourn the matter. However, to afford final opportunity list on.
Serial number 24, Nishit Kumar
Great.
Shetty, Arun Kumar K, Sundar Raman.
For the appellant, my lords.
Hmm.
The offence is under section 138 of NI Act, my lords. The appellant is the complainant before the trial court and respondent before the first appellate court, my lords.
Yes.
My lords, the check amount is for rupees 34 lakhs, my lords. The trial court was pleased to convict the respondent and has sentenced him to pay a sum of rupees 50 lakhs, my lord. The first appellate court has reversed the conviction and acquitted the respondent.
Complainant is examined as
PW1, my lords. Ten documents have been marked on behalf of appellant, my lords. And respondent has been examined as DW1, my lords. And he has marked one document, my lords, in his support.
yes.
Lords, the appellant was in the business of running a supermarket, my lords, in the name of Home Links, my lords.
Hmm.
And the said supermarket market was running in the loss. So in the year 2004, the respondent was called in as consultant to improve the business of supermarket, my lords. And next, my lords, as per Exhibit P10, the respondent, he has also has been made as one of the partner, my lords, according to partnership deed, Exhibit P10, my lords. So the respondent.
When he was inducted as a partner.
Lords, 23/7/2004, my lords.
As per?
Exhibit P10, my lords.
Yes.
Later, my lords. As per Exhibit P1, my lords, the respondent and the appellant, they have entered into a sale cum dissolution deed, my lords, where the appellant has sold his part of share to the respondent, my lords. That is Exhibit P1, my lords.
Respondent sold.
No, my lords. The
Complainant-
appellant has sold his part of share to the respondent.
Yes.
Yes, my lords.
What was the consideration amount?
Rupees 35 lakhs, my lords. It is mentioned in the clause 5 of Exhibit P1, my lords.
Yes, then
My lords, the subject matter of the check is rupees 34 lakhs, my lords. That is mentioned in clause 5, subclause A, my lords.
so regarding the check exhibit P2, there is reference in to.
In Exhibit P1, my lords.
Clause number, P1 clause,
Clause 5, subclause A, my lords.
Subclause A.
subclause A. In clause 5 of exhibit P1,
Yes.
that's subclause A.
Hmm.
My lords, in this, the sale consideration of it was for rupees 35 lakhs, my lords. And 34 lakhs check was given. It was a post dated check, my lords, for 31/3/2006, my lord. The sale cum dissolution of partnership deed was executed on 6/12/2005, my lords. 6/12/2005. And on the same day, the check was issued, that is the check in question, my lords.
Yes.
It was a post dated check for 31/3/2006, my lords. The said check was
And the date is mentioned in the clause 5.
clause 5, subclause A.
Yes.
Yes. Lords, when the said check was given for encashment, my lords, it was dishonored for insufficient funds, my lords.
Yes.
Later, my lords, when the appellant has asked the respondent, he has issued again 7 checks, my lords, in lieu of for the payment of rupees 35 lakhs, my lords.
Dishonor of the check, have you issued legal notice?
Please, my lords.
Whether that was served,
Please, my lords.
then later, any reply?
Not for the present check in question, my lords, but as for the as subclause check in question was dishonored, my lords, he has issued 7 other separate checks, my lord.
He has not issued any reply.
Not to the present check in question, my lords. Not to the present check in question.
Yes.
After, my lords, he has again issued 7 checks for the present check in question, my lords. Those checks was also dishonored, my lords.
What is the amount of those checks?
My lords, it was for sum of 35 lakhs, my lords. For one check, it was 50,000, and another check, it was 4 lakhs.
Is 35,000.
My lords,
35 lakhs,
35 lakhs, my lords.
total amount.
Total amount, but the check in question is for 34 lakhs, my lord.
That is not the subject matter of this complaint.
Please, my lords.
Yes, then.
Lords, when these 7 checks were dishonored, my lords, again, legal notice was sent from the appellant. For that, my lords, the respondent has issued the reply, my lords. And the present check in question and the other 7 checks which were dishonored, all the matters were connected and taken up together, my lords. The appellant has not pressed the other 7 checks, only the present check was pressed. And the others, in the other 7 cases, he has been acquitted.
What is the defense taken by him in the reply?
Please, my lord, the said reply is not marked in this case, my lord. I have the certified copy of it. The lordship permit, I'll.
Not marked, leave it, then.
My lords, their defense is that, my lords, may kindly see clause 9 of exhibit P1, my lords.
Exhibit?
P1, my lords.
Hmm.
Clause 9, my lords. The parties here in further covenant that if the parties to this agreement coming any breach of this agreement, then the dissolution shall be void and the first party shall hand over the business to the second parties, subject to settling of their accounts as per the partnership deed executed by the parties. Now, my lords, clause 5 is, my lords, regarding payment, my lords. That is the checking question. Now, their defense is that, my lords, as the check has been dishonored, the payment has not been made. So the said sale cum dissolution deed is void. So is not bound to pay any.
Yes.
That is their defense, my lords. In fact, my lords, the observation of the first appellate court, my lords. Lords, may kindly see internal page 8 of the judgment of first appellate court, my lords. Page number 21 of the petition. Internal page 8, my lords.
Judgment.
The first appellate court.
Judgment of trial court by the appellate court. There is no judge. Judgment of the trial court.
Page number 21 of the petition.
Para number.
Para number 10, my lords. Internal page 8.
Yes.
From third line, my lords. One of the condition is that the accused shall pay rupees 35 lakhs to the complainant.
Para number.
10, my lords.
1 minute.
Internal page 8.
Para 10.
Para 10, my lords.
Page.
Internal page 8, my lords.
Hmm.
From third line, my lords. One of the condition is that the accused shall pay a rupees 35 lakhs to the complainant, the original partner Radha Krishna, and the other two conditions are that the complainant and original partner shall have to withdraw the suits pending against the firm within 30 days from the date of the agreement. So unless and until the first parties indemnifying their liability prior to 3/10/2004 and the first party indemnifying the second party with regard to the liabilities of the firm subsequent to 3/10/2004 and withdrawing of the suits pending against the firm as per clause 7.
Who is the first party?
Lords, the first party is the respondent and the respondent and the another partner, my lords. It cannot be said that the partnership firm come to an end as on the date of the execution of Exhibit P1. So even if the accused issued any check for rupees 34 lakhs or rupees 35 lakhs, as the case may be, it is only in respect of the dissolution of the firm in future. After fulfilling the conditions of all the terms of agreement comprised in the document Exhibit P1. So even if the accused issued check Exhibit P2 rupees 34 lakhs agreeing his liability, it is only in respect of future event where the partnership firm is going to be dissolved after fulfilling all the terms and conditions of the agreement. Anyhow, payment of rupees 35 lakhs is also one of the condition precedent for dissolution of the partnership firm as per clause 9 of Exhibit P1. So in case of non-payment of the agreed liability of rupees 35 lakhs by the accused, then also the dissolution agreement will itself become void as the accused committed breach of the agreement. Hence, the question of dissolution of the firm will not arise for consideration. So when the firm is not dissolved, the question of the accused having a liability to pay the amount of rupees 35 lakhs will not arise for consideration. Lords, in this reasoning, my lords, the lordship has referred to the clause 9 of the Exhibit P1, my lords, that is sale cum dissolution deed. Clause 7 of Exhibit P1. That the parties herein have mutually agreed that the second party shall indemnify the first parties as against any claims, suit, recoveries or debts arising out of the partnership from the term prior to 3/10/2004. And the first party shall keep the second parties indemnified as against any claims, suits, recoveries or debts arising out of the partnership for the period subsequent to 3/10/2004 and thereafter. Within 30 days of this agreement, second parties agree to withdraw the injunction suit filed at ITPL and ensure without eviction suit filed by the ITPL against Homelinks, my lord. My lords, this clause 7 of the exhibit P1 states that, my lord, in respect of any liability, if it arises and the first parties, that is the respondent, pay, that then I am the appellant, I should indemnify him. That is the condition in clause 7, my lords. But, my lords, the first appellate court has held that, my lords, they have not cleared the liability. So it is in respect to future liability, that is, if clause 7 is to be interpreted in that way, my lords, then the business of the firm will be always going on. And if any claims comes, it will be going on. And then the transaction will never take place, my lords. This clause 7 particularly states that, my lords, in case if there's any liability and if the respondent has settled the liability and then the appellant is bound to indemnify the respondent, my lords. Please, my lords. So, my lords, it is not the case of respondent that there was any liability pending. Their only specific defense is that, my lord, in fact, my lords, it has come in the evidence of DW1, my lord. I'll read the 11th. Also, my lords, a reference may be seen into clause 6 of exhibit P1, my lords. Whereas, my lord, the sale consideration for rupees 35 lakhs, they have only issued for 34 lakhs one check and another check they have issued for rupees 1 lakh, which is dated 1/9 on 1/10/2006, my lords. And that 1 lakh rupees check they have issued, my lord, stating that if there is any liability, in case any liability occurs, then the check will not be put into collection, my lord. For security, they have said in case if any future liability arises, for that particular reason only, they have withheld 1 lakh rupees and they have issued a post-dated check, my lords.
Yes.
Lords, I'll read the 11th portion of evidence of DW1, my lords. Internal page 4 of evidence of DW1, my lord.
Now, in the chief examination, what is his defense?
Please, my lords. He has stated that, my lords, Mr. Satkani was to bring them in internal page 4, my lords. In the last 5th line from the first paragraph.
Chief examination, what is his defense?
His defense is that, my lord, I have not paid the money, so the sale cum dissolution deed has not been given effect. So as the sale cum dissolution deed is void, so I am not liable to pay any money. That is his.
Nodi specific defense in the chief examination.
Please, my lord. My lords, in internal page 4, in the last.
My
lords, they have clearly stated, my lord. The sale cum dissolution deed not given effect as the payment not made. The partnership deed continues till today. The partners are John Fernandez, Radhakrishna, Mr. Satkani and myself.
Whether the complainant is taking part in the business?
No, my lords. Lords, I'll produce the reply given to the other 7 checks, my lords, wherein the respondent has admitted that he has holding the physical possession of the supermarket, my lords. He has admitted in the reply notice given to the other 7 checks.
Exhibit,
My lords, that has not been marked in the present case, my lords.
next.
My lords, the first appellate court has held that, my lords,
Hmm.
as the sale cum dissolution due became void, as the check given.
What is your cross-examination to DW1?
My lords, in page 10, my lords. The respondent has taken the physical possession of the supermarket and he was managing day-to-day affairs of the supermarket, my lords. So I was neither given profits in the supermarket, my lords.
Where it is?
Please, my lords, page 10 of the internal page of evidence of DW1, my lords.
Yes.
It is not true to suggest that I took over the home links and started managing the firm after resolution due came into existence. It is not true to suggest that even today I am managing the firm. I do not know who is running home link supermarket. It is not true to suggest that now I am running the firm and not allowing the complainant and Mr. Radhakrishnan. But my lord, for this particular, my lord, the appellant had filed application under 91 of CRPC for calling the manager of the said supermarket to ask as to who is running the said supermarket. The said application was dismissed by the trial court and the same was challenged before this court. This honorable court was also dismissed the application, stating that it is not necessary to see whether the check was given in respect of legally enforceable debt terms. Now, my lords, the question which is to be looked into is when at the time of issuance of check, whether there was legally enforceable debt, my lords. This sale cum dissolution deed was full in force, my lords, as the respondent has taken the possession of the supermarket, my lords. Now, only after the dishonor of the check, they are claiming that the payment has not been made, the check has been dishonored, so the sale cum dissolution deed has become void, so I'm not able to pay any money. So lordship permit, my lords, I'll file the appropriate application for producing the reply given by the respondent.
Then.
Please, my lord. Lords, may I look, I'll see observations by the trial court members while connecting the respondent.
Arun Kumar K. Serial number 24.
My lords, I'm appear for the respondent, my lords. Today I have got the information that earlier council has given NOC, my lords.
Yes.
I may be permitted to file NOC wakalat, my lords. By next date of hearing, I will commence my arguments, my lords.
Tomorrow.
My lords, I have to receive the NOC wakalat, my lords. Still now,
Madam. No.
my lords, 1 week time may be granted, my lords. I have now, I don't have any copies of the appellant memo.
Learned counsel for the appellant. What is your name?
Pushpalata, my lords.
Initials?
Pushpalata Y.
Why? Counsel submits that she is instructed to appear on behalf of the respondent in the undertakes to file wakalat and address her argument on next date of hearing. The appeal is of the year 2012. I do not find any reason to adjourn the matter.
That's 1 week, my lords.
The learned counsel for the appellant is already heard. However, to afford an opportunity to the counsel made submission list on next Monday, Wednesday, yes.
Oblige, my lords.
No further date for arguments.
Please, my lords.
Serial number 25, Divakar Vasant Yadav.
The learned counsel for the appellant is absent, no representation. Even in the last date of hearing, there was no representation on behalf of the appellant. Court notice was ordered to be issued to the appellant through jurisdictional police. Yenagide Saroda. The office note discloses that the notice is served on the appellant. Thereafter, the learned counsel has filed their caller, but still he remained absent. The appeal is of the year 2012. I do not find any reason to adjourn the matter. Appeal is dismissed. Next.
Serial number 26, R. Kumar, Shalas Mamadpur.
To Benaki, it appears the appellant is not interested. Yes, 26.
I beg to appear for the respondent, my lords.
Yes.
I prepare the appellant in this case, my lord. Transaction is in the year 2006, my lord.
Good.
Check amount is 1,50,000.
You are the complainant.
Complaint.
138. There's the check amount.
Check amount is 1,50,000, my lord. Accused was approached the complainant in the year 2006 for lending a loan.
Hand loan. You have issued the hand loan
Hand loan, my lord.
of rupees 1,50,000.
1,50,000.
Yes. When
And that, my lord, to that.
when the loan was granted?
In the year 2006, my lord.
2006.
Six.
Date you have not mentioned.
Date is not mentioned.
Then
My lord, check was issued by the complainant accused in the year on 19/5/2008. 19/5/2008. It was that was presented on 24/6/2008. The bank has given an endorsement stating that no such account. No such account. No such account. As per the legal notice issued by the reply notice issued by the accused, my lord. As per the legal notice, reply notice, she was closed the account in the year 2000 itself. In the reply notice, in para 7 of the reply notice, she stated that.
reply notice exhibit.
Exhibit, my lord.
B2, my lords.
B2, my lord. In the reply notice stated that all checks, account was closed in the year 2000 itself. All check sleeves were given to the bank in the year 2000 itself.
No, where is the reply notice? Exhibit P2 is the endorsement.
Exhibit D2, my lords. Exhibit D2. Defendant has led as evidence. She has been examined as DW1.
The account
My
was closed in 2000.
2000 itself.
2001, my lords.
My lord, in the reply notice, para 7, my lord, my client instruct me to state that our client has closed her bank account in the year December 2000. At the time closing of the account, my client voluntarily handed over all the checks leaves to the said bank. Hence, stated in your legal notice, the question of issuing the check to our client does not arise at all. My lord, in the complaint, before the trial court, my lord, their contention, the check issued by the complaint was stolen. Stolen by the complaint. They have not filed any complaint regarding this.
Where they have taken such defense?
Defense, my lord, in the legal examination, cross-examination of accused, my lord.
The defense of the accused is that there was in the milk vending business, the complainant used to come and sit in the shop owned by the husband of the accused, my lords. And then when he used to come and sit there and he used to assist him in the daily course, that time the check was stolen is what is the defense of the
If it is,
And the same,
Whether the defense finds a place in your reply.
my lords, in the cross examination, there is admission by the PW1, wherein,
I'm not asking about the admission. What is
Please,
your
my lords.
defense, whether it is reflected in exhibit D2? You have not taken such defense in exhibit D2.
my lords, in exhibit D2, the defense taken was that way back
You have
in the.
returned all the checks to the
Please, my
bank.
lords. Please, my lords.
Is it not contradictory?
No, my lords, and with respect to this particular check, in the cross examination, there is admission by PW1 himself that he used to come and sit in the shop which was owned by
Let him
the
sit,
husband
sir.
of the
Let him
accused.
sit. That will
Please,
not
my lords.
probabilize your defense simply because the complainant was coming and sitting in your shop. That will not probabilize your defense.
My lords, the transaction on behalf of the complainant is that in the year 2006, this particular
Yes.
loan was taken, my lords. After 5 to 7 years, that is after a span of almost 6 years, after my closing of account, even as per exhibit D1, I have also produced the bank statement.
Yes.
Bearing numbers, bank statement exhibit D1, which is closed on
All these facts are admitted now.
Please, my lords.
Whether he has probabilized his contention, whether you have probabilized your defense is the question
Please.
to be considered.
Please, my lords. I have, in view of the evidence produced.
According to him, with malafide intention, you have issued the check pertaining to the account which is already closed by you.
Please, my lords.
And you have not taken such defense in your reply exhibit D2. The defense in exhibit D2 is entirely different.
My lords, that may be the case. That I would have told that with respect to returning of the checks to the bank. But also apart from that, specifically even in the cross examination, the financial capacity is also questioned, my lords. He himself admits that his financial capacity is 2,50,000 per annum.
Yes.
Such being the say, 2,50,000 being the case, lending of 1,50,000.
So first
Would
defense
not be-
what you have taken is not proved, not probabilized.
My lords, with with respect to exhibit D1, I have produced the bank statement of having closed the account.
That is
It is
different.
also one of my defense. Closing of the bank account and that the particular
See,
check
all
was
those
misused.
facts are admitted. All those facts are admitted. You need not have to prove it. The bank endorsement discloses that the account was closed in December
Please, my lords.
2000. Even according to you, it was
Exhibit
closed.
D1, it is closed.
Yes.
Yes, ma'am. And also yes, even though that was not taken in my reply notice, my lords, I am successfully established in my cross examination. I have defended my rebellion.
Where is the admission, so-called admission of complainant?
Let's in the
examination. Process deferred.
In the judgment also, the Honorable Trial Court has relied on the admissions of the complainant himself, my lords.
Deferred. ಇದು ಕೂಡ ಮುಂದಲ್ಲಿದೆ. Cross examination deferred. ಎಲ್ಲಿಂದ ನೋಡ್ಬೇಕು ನಾವು? Yes.
Millards, in the page 11, Millards, in page 5. Page 5 particularly.
Yes, read it.
Please, Millards. Page 5 of the judgment, Millards. On
Judgment,
looking.
I am not referring to the judgment, sir. According to you, there is an admission on the part of PW1. Read
Which
the
is-
relevant portion.
Means, records, the trial court records I'm not having, my lords. In the judgment itself, it is placed. In the judgment,
It is
the
extracted. The evidence is extracted.
I will produce I'll
Lord.
produce the judgment.
Examination chief by.
Para 7 and 8, both it is discussed, my lords.
On 27/11/2010, my lord. In the next day, my lord, on 4/1/2012, cross-examination of PW1 by the accused. I have been
Cross-examination dated.
dated, my lord, 4/1/2012.
Hmm.
I have been doing electrical contract business. I know accused since 10 to 15 years through her husband. Earlier, myself and accused, her husband have been residing in JC Nagar. It is true that earlier accused husband has been doing provisional store, and after that they have started milk vending business. It is true that I used to purchase from provision store from accused. It is true that used to assist husband of the accused in the above said business. I used to
Please.
sit in the milk vending shop. Accused used to run business on behalf of the so-and-so. I do not whether very account of exhibit P1 check was closed in the year 2000 itself. It falls to, I have stolen, it is false to say that I have stolen exhibit V1 check from milk shop when I was sat there on run business on behalf of the accused husband. The accused and her husband were present when I lent loan to accused in their house. I kept 1,50,000 in my house and lent the same to the accused. I have average income of rupees 25,000 per month from my business. I have not been doing any lending business. I have not got executed loan agreement from accused pertaining to the loan and interest. It is false. Accused has not borrowed loan from me and not issued exhibit check to discharge the debt. My lord, if it is so, my lord, she would have filed a complaint against him.
No, what is the occasion of the complainant? What
My
is
lord, issuing electrical contract business.
Is there any cross-examination with regard to the financial capacity?
This only, my lord, that is the cross-examination by the accused.
So on the single day, the cross-examination was concluded.
Examination of DW1 was a further exam on 10/10/2012. On 10/10/2012, my lord. Cross-examination of DW1.
Read it.
I was running a provision store up to 1999-2000. It is true that I was running the shop till 2006. It is true that my house was different place. It is true that even before my marriage, complaint was the friend of my husband. It is not true that before 2006, the complaint had worked in Muscat for 2 years. The witness stated that the complaint was doing work of photographer. I do not know what complaint was doing electric contract work also. I do not know that complaint is class 1 electrical contractor. I do not prove that I suffered loss in provision stores. I do not prove that the Nandini milk business also I suffered loss. I do not prove that even I had taken loan from several other persons for payment of the amount to the Nandini milk agency. I had kept in the signed check signed check. Exhibit P1 is also one of such checks signed and kept by me. Lord, it is written all the checks. Long back in the year 2000 itself, how it is possible to keep these all checks?
Yes.
My lord, another my lord, exhibit U1 is my account. It is true that I was given one check to Vancouver for 50,000 from my same account. It is not true that in 2006 I had asked for hand loan for 1,50,000 to the complainant. It is not true that the complainant has given me the edition. It is also not true that for payment I have issued exhibit one check. It is not true that I had given promise to return the amount with interest of 24% per annum. It is not true that I have even kept interest for 3 months. It is not true that I have asked the complaint to present the check in the 2008. It is true that I have received the notice. It is true that I have given reply for exhibit T2. I have given instructions to reply notice. I have not given any complaint regarding the misplacing of my check. I have not taken any action against the complaint. It is not true that I am giving false evidence. It's the evidence cross-examination is admitted. Blood, the check is given false check with an intention to cheat the complainant. The accused has issued the check. She borrowed 1,50,000 rupees from complainant.
Yes.
In the reply notice, herself admitted that the account was closed in the year 2000 itself. All checks were returned back.
Yes. Respondent.
Please, Millards. Millards, first contention is the financial capacity. In cross-examination, there have been admission that 25,000 per annum is the monthly income of the complainant.
Per annum.
So if that per month, Millards, 25,000 per month.
Per month.
In which year?
In the year 2006.
Not now,
The year-
2006.
Please, Millards. And in the year 2006 itself is the
25,000
particular
was the big
transaction.
amount then.
Yes, 25,000 even for 12 per annum, if it is taken into consideration, it is 3 lakh. So out of 3 lakh, 1,50,000.
That will not go according to this arithmetical calculation. You have
Millards,
to
section-
ask what is the
Millards.
saving, what is the amount he has saved.
Please, Millards, section
over a period of
138.
time.
Please, Millards.
Where is the
Millards, section-
cross-examination regarding capacity? Except eliciting that 25,000 per month I was getting from my
Please,
business.
Millards. Please, Millards.
No.
Millards, section 138, no doubt there is a presumption that the check was issued towards legally recoverable debt, Millards.
Yes.
But what as accused, in view of leading of this particular defense, of first defenses of the account having been closed in the year 2000 itself.
Yes.
For an account which is closed in 2000, carrying of the check after 5 to 6 years and lending of that check for in view of some financial arrangement is not a probable case of the complainant, Millards. Where I have successfully rebutted the presumption under section
Here by
139.
raising the defense.
Millards, also by way of leading evidence and also by way of admissions of admissions of PW1.
What is
That
the
is-
admission, sir? Now the learned counsel has read the
Please,
entire
Millards,
cross-examination. Where is
the
the
admission, the admission with respect to the fact that the complainant used to assist the husband of the accused in the milk vending business. There is a specific admission and there is a categorical admissions as well, Millards.
Why you
It
are
is-
saying that it is the admission?
Please, Millards.
Why you are saying that it is an admission?
Millards, admission with respect to the assisting in the milk vending business is when the check has been stolen, Millards. Because I was also not aware. I was also not
Cannot
aware
be
that
the presumption, sir.
Only, my lords,
That
only.
is what I am saying. Simply because the complainant was assisting in your business, simply because the complainant was coming and sitting in your house or shop, that will not automatically go to the, we cannot raise the presumption that he has stolen the check.
My lords, coupled that with the fact that in the year 2000 itself, there was a closing of amount, and this particular transaction is done in the year 2006, my lords.
Why you
After
have-
span of 5 years.
Why you have not taken the defense in your reply? Exhibit D2.
My lords, mere non-taking of reply will not.
No, it makes all the difference. It is an afterthought. Only during
No, my lords.
trial you have taken the defense for the first time.
But I am able to establish that defense, establish the defense taken by me by way of evidence, my lords.
Yes.
Also, my lords, I will produce citations, my lords, in which case, just for whether the defense taken under legal notice as per Exhibit P1 and establishing by way of cross-examination, I will differentiate, my lords. Because only for that one reason that I've and also there have been categorical defense raised by me, my lords, and the detailed order is also passed by the Honorable Trial Court.
You have to say what are those materials?
I will produce, my lords. I will.
What
My
do you
lords,
say?
ma'am. My lords,
I am
the
not
trial
asking
court.
you to produce anything. I am
No,
asking
my lords,
you
I
to
will.
highlight.
My lords, I will convince your lordship with respect to the fact that
Hmm.
for a check, my lords, for a check which the present complainant says that was issued in the year 2006, my lords, wherein there is even as per the evidence and admission, admittedly in the year 2000 my bank account is closed. It is something which will not which not come to the rescue of the complainant, my lords. It is also a fact that just for the purpose of that he was having the check in his custody to cheat the accused person, and the check has been produced, my lords.
For the first time, when you came to know that the check was not.
As per my lords, as per when the legal notice was issued and the first possible opportunity, I have replied to the legal notice.
You have replied, but you have not
Please.
taken the defense that the check was stolen by the complainant. That is what I am
My
saying.
My lord, I would also like to, my lords, if it is put in this sense, the defense taken was that I have given back all the checks. And I would not have in my
Makes
purview.
all the difference, sir. It makes all the
My lords,
difference.
my lords,
To
I
say
will
that-
not.
To say that all the remaining check leaves were returned to the bank, it is one defense. And saying that
Please.
the check leaf was stolen by the complainant, entirely different.
Please, my lords, my lords, this particular fact, yes, I have replied in my legal notice that all the check leaves were returned, and hence there is no possibility, because legal notice there won't be any displaying of the alleged check. Once I entered my appearance, and when the evidence was marked and exhibits were produced, that is then that is an obvious fact that yes, this check would have been stolen, my lords. Because any which way, when I have given back all the check
So
leaves,
the court has to presume all those things.
my lords, that is my defense which the accused has taken, my lords. And in while giving of the legal notice, I will not have I will not be in an opportunity to see that particular check, my lords. So the defense, even then, when at the first instance,
That
what I
is
have
why
given
I
is,
asked you, that is why I asked you for the first time when you came to know regarding the check in question, which was in the possession of the complainant. You said when you received the legal notice.
please, my lords, please.
That was the first opportunity to deny that. You
No,
have not
yes, my
availed that
lords.
opportunity.
My lords, in the first legal notice which was sent, yes, no doubt it is asked by the complainant that it is told by that, yes, I have this check is issued to us legally recoverable debt. But my defense, what I have taken is, I do not know if that check is already, it is there with him, because that will come only on the base of trial, my lords, when the evidence is marked and exhibit is produced that that particular check is there. And that is when I have cross-examined, my lords.
So in the legal notice, the complainant has specifically stated, the check leaf in question is with me You have issued it. I have presented
Please.
for encashment. It was dishonored as account
Please.
closed. All
Please,
those
Manoj.
details were given in the legal notice.
For which I have denied that. That cannot be the case because already the account is closed in the year 2000 itself.
And the checklist
And
is in question is returned to the bank.
all the checks, not this particular check, all the check leaves, my lords. My lords may note, I have not mentioned about this particular check.
So good. Yes, is there any other defense?
My lords, I'll produce citations, my lords, that cannot
Is
be
there
an
any
only
other
ground.
defense?
My lords, financial capacity is one of the defense.
But nothing, there is nothing in the cross-examination.
In cross-examination, there is an admission that 20 rupees, 25,000 is the per month income of the complainant, my lords. Based on that, it is very improbable that the amount of rupees 1,50,000 will be given, my lords, as a hand loan. And also, with respect to these transactions, my lords, initial burden is on the complainant himself, my lords, to prove that there was this hand loan of rupees 1,50,000 was whether this transaction took place. Initial, no document is produced to show that there was 1,50,000 hand loan advanced to the accused person, my lords.
Yes, anything else?
Exhibit D1 is also the bank statement which I have produced, my lords, to say that the account is closed in the year
That is not
2001
in
itself.
dispute, sir. That is admitted fact now.
Please, my lords, and one of the grounds, my lords, is that the complainant has failed to establish any transaction between
Yes.
the complainant and accused, my lords, with respect to this 1 lakh payment of 1,50,000 as a hand loan.
Yes.
And also, there is also in the examination, in the cross-examination for DW1, they have tried to establish that on this 1,50,000, there was interest paid for 3 months, my lords. Not even those documents are also produced on the payment of interest of for 3 months, my lords.
Yes.
The transaction is not established, my lords.
Yes. So what? The complainant is impugning the judgment of acquittal. Judgment of the trial court passed dated 21/1/2013, passed in CC 10772 of 2019 on the file of so and so, acquitting the accused for the offense punishable under section 138 of the Act. Parties are referred to as per their heard so and so. Then counsel for the complainant submitted that the complainant had lent an amount of rupees 1,50,000 to the accused during 2006 towards repayment of the said amount. The check exhibit P1 was issued by the accused on 19/5/2008. When the check was presented for encashment, the same was dishonored as there is no such account. Legal notice was issued to the accused as per exhibit P3. The same was served on the accused as per postal acknowledgement exhibit P3A. The accused has issued the reply as per exhibit D2, contending that the account in question was closed during December 2000 and all the remaining check leaves were already returned to the bank. And therefore, there is no question of the accused repaying the check amount to the complainant. Next part. When counsel submitted that the complainant has examined himself as PW1 and spoken about his contention. During cross-examination, it is elicited from PW1 that he was doing electric contract work, electric contract business, and was earning rupees 25,000 per month. There is absolutely no other, there is absolutely nothing has been elicited from the complainant to deny the financial capacity to lend the home and loan of rupees 1,50,000. Next, when counsel further submitted that during cross-examination, it is suggested that the complainant has taken away the checklist in question, but the same was denied by PW1. Admittedly, no complaint was filed for loss of check, and it is not stated as to when the checklist was stolen by the complainant. This defense was not taken while issuing the Exhibit D2. Next, continuing. DW1 further states that the complainant was also working as a photographer and his financial capacity was never denied. Never denied. Therefore, it is clear that the accused has taken the defense of the complainant stealing the check Exhibit P1 only during trial and not while issuing Exhibit D2, and hence it is an afterthought. Even though a defense that the complainant was not having financial capacity to lend the hand loan was taken, the same is not probabilized. On the other hand, the financial capacity of the complainant was substantiated. The signature on the check in question is admitted by the accused, and therefore the presumption under Section 139 of NI Act arises, and the accused is liable for conviction. Next paragraph. When counsel submitted that the trial court, ignoring all these facts and circumstances and also the position of law, passed the impugned judgment acquitting the accused, which calls for interference by this court. Accordingly, place for allowing the appeal. Per contra, and counsel for the respondent, opposing the appeal, submitted that admittedly the account in question was closed during December 2000. But according to the complainant, it lent the home loan during 2006. Nothing has been placed before the court to probabilize lending of the amount. It is the contention of the complainant that the check in question was issued on 19/5/2008. That is after about 8 years after closure of the bank account, which is most improbable to be accepted. When counsel submitted that during cross-examination of PW1, he stated that his income during 2006 was only rupees 25,000 per month. Under such circumstances, he lent a huge amount of rupees 1,50,000 to the accused is most improbable. Complainant admits that he used to assist the accused in his milk vending business, which also probabilizes stealing of the check by the complainant without notice of the accused. When the complainant has not proved lending of the amount and also issuance of the check towards discharge of the legally recoverable debt, the presumption under Section 139 of NI Act cannot be raised. The trial court was right in holding that the complainant has not proved the guilt of the accused for the offense punishable under Section 138 of NI Act, and accordingly dismissed the complainant. There are no reasons to interfere with the impugned judgment of acquittal. Accordingly, prays for dismissal of the review the materials, including the trial court records. It is next trial court records point for consideration. My answer to the point was it is the contention of the complainant that he was having acquaintance with the accused since several years, which is not in dispute. It is further contention of the complainant that during 2006 he has lent an amount of rupees 1,50,000 to the accused, which is denied by the accused. It is the further contention of the complainant that on 19/5/2008 he had issued the check as per Exhibit P1 towards discharge of the legally recoverable debt. This fact is also denied by the accused. However, the check in question and the signature found thereon are not denied by the accused. When the check Exhibit P1 was presented for encashment, the same was dishonored as per endorsement Exhibit P2 that the account is closed. Now it is the contention of the complainant that the accused, knowing fully well about closure of the check, issued the check with an intention to cheat the complainant, and he has committed the offense punishable under Section 138 of NIA. Next. On the basis of the oral and documentary evidence placed before the court, I have considered the contention taken by the complainant and also the defense taken by the accused that the check leaf in question was stolen by the complainant and presented the same for encashment about 8 years after closure of the account. Even though it is contended by the accused that the complainant had no financial capacity to lend the amount of rupees 1,50,000, the complainant, who is examined as PW1, stated that he was doing electrical contract business. During cross-examination, it is elicited from the witness that he was having the income of 25,000 per month during 2006. There is no further cross-examination to deny the financial capacity of the complainant. It is pertinent to note that after a receipt of the legal notice issued by the complainant as per Exhibit P3, the accused has issued the reply as per Exhibit D2. The specific defense, the only defense taken in Exhibit D2 is that the account in question was closed in December 2000 and all the remaining check leaves were returned to the bank. But however, during cross-examination, an attempt was made to contend that the check leaf in question was stolen by the complainant and presented for encashment. Conspicuously, the said defense was never taken while issuing Exhibit D2. The defense taken subsequently is prima facie an afterthought. Next. It is pertinent to note that the check leaf and the signature on the check Exhibit P1 are admitted. When the defense taken by the accused is not probabilized, the admitted armele, the presumption under Section 139 of NIA Act would arise in favor of the complainant. When the accused has not failed to probabilize his defense, even after leading the evidence and producing the documents, it cannot be said that the accused has probabilized his defense. obliged in the defense. In this regard, I please reliance on the decision Niharika Denige. Niharika. So. Therefore, the position of law is very well settled. Very well settled. Next part. I have gone through the impugned judgment of acquittal passed by the trial court. It has not taken into consideration any of these facts and circumstances and also the position of law while acquitting the accused. Therefore, I am of opinion that the impugned judgment of acquittal passed by the trial court is liable to be set aside. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Appeal is allowed.
My lords, may I request 389 clause for suspension of it to prefer an appeal, my lords?
You
I'll
can
file
prefer
necessary
an-
application.
You can prefer an appeal. What is there?
In view of conviction,
You to
I'm
hear-
already on bail.
Yes, to hear regarding sentence. Yes, you are right.
Please, my lords.
Tell me about sentence. Accused
Let's
is-
see. This is in the year 2008, my lords.
Yes.
And now it's almost so many years have elapsed, my lords.
So,
Even now her financial capacity is. I need to seek instruction with respect to hearing of sentence. My lords may have it tomorrow, my lords. I'll file.
tomorrow to hear regarding sentence.
Please, my lord.
Much obliged.
Huh? ಇಲ್ಲ, ಇಲ್ಲ, ಆಯ್ತು. Other matters?
May I make the submission, my lord? Serial number 23, list number 1, my lord.
Wait for some time, sir. Wait.
Yes, ma'am.
Wait a minute.
Yes.
Passover ಏನಿದೆ? Passover ತಗೊಳ್ಳಿ ಏನಿದೆ?
One Passover matter, serial number 2, Tamallappa.
Paper, petitioner lordship. Today I have taken steps with the correct address, Your Honor. That is, I verified the record. In the trial court also, they have given the same address. Now they have changed the address.
Change the address ಅಂದ್ರೆ
The ascertain ಮಾಡೋದಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. PF I will pay this.
Sir, unfortunately, 8 years have lapsed. We are still ascertaining his address.
No, what they have given lordship, that is.
Yes, ಆಯ್ತು ಅದೆಲ್ಲ ಆಗೋಯ್ತಲ್ಲ ಮತ್ ಅದನ್ನ ಹೇಳೋದು ಏನಿದೆ? From the beginning, your submission is that the accused is residing in the same address. The police report says he is not available in the said address. Now you have changed your version saying that he has changed his address.
Lordship, after pass over the matter, I will request, verify the, is he staying there or not. After that only I will make a submission.
Already the police report is there saying that the accused is not available in that address. Huh?
ಗೊತ್ತಾಗಿದೆ.
ಅದೇ ಗೊತ್ತಾಗೋದಿಲ್ಲ ನಿಮಗೆ, ನಾವು ಹೇಳ್ಬೇಕು ಬಂದು ವಕೀಲ್ರೆ ಹೀಗಿದೆ ಅಂತ. ಇಲ್ಲಾಂದ್ರೆ ಯು ಆರ್ ನಾಟ್ ಬಾದರ್ಡ್. ನಿಮಗೆ ಯಾಕೆ ಗೊತ್ತಾಗುತ್ತೆ? ನಿಮಗೆ ಬೇಕಾಗಿಲ್ಲ ಅದು.
Next time may be granted, I will take up the.
Counsel for the petitioner, raise for time, a week's time to take steps against the respondent. It is noticed that the petition is filed 2016, 8 years have lapsed. Still, the respondent is not served. As per police report, the respondent is not residing and not available in the given address. Even though there are no justifiable ground for granting time, list finally as a last chance. Next.
Serial number 4, N. Srinivas.
Not given.
He is not residing in the cell.
Same. ನಿಮ್ದು ಅದೇ. ಅದೇ same ತಗೊಳ್ತಾರೆ. Next. 2013 ಅದು. 6 years have lapsed. Next.
Serial number 5, Anil Kumar HS.
When counsel for the petitioner is absent, no representation, even though matter is passed over 12th and again called at 4:45 PM. Please notice that the office has raised as many as 14 objections, and none of the office objections were complied with till today, even though the petition is of the year 2019. Under such circumstances, it appears that the petitioner is not interested in prosecuting the petition dismissed. Then
Serial number 8, Vandana PL.
what is that? Counsel for the petitioner is absent, no representation. PF for issuance of notice is paid, even though issuance of emergent notice was ordered as per order dated 26/2022. It appears the petitioner is not interested in prosecuting the petition, however, to afford final opportunity this time. Yes.
Serial number 11, Annapurna Bordale.
Sorry? Ready means when? When you will be ready?
We shall do it tomorrow. Submitting a memo on behalf of the petitioner.
What is that memo?
They've been asked to furnish something personally as well. We have paid. Requesting one more opportunity.
You are permitted to serve in the year 2021.
Shall comply tomorrow. Please, one more opportunity.
Counsel for the petitioner filed a memo seeking grant of time to serve the respondent as per order dated 11/11/2021. The writ petition is of the year 2019. I do not find any reason to adjourn the matter. The conduct of the appellant and his counsel discloses that they are not interested in prosecuting the petition. However, to afford final opportunity. Next.
Serial number 16, Shyamal Ahmed Patel.
And for petitioner, Your Lordship, 2 weeks time may be given, Your Lordship. Next date of hearing, I will proceed with the matter. Your Lordship. I'm sorry, Your Lordship.
No, what justification you can have, sir? Why you made this court to issue notice to the petitioner when you are having the wakalat for the petitioner and still continues to represent him?
No, Your Lordship, I have submitted, Your Lordship, that day. The actual fact I have submitted.
Actual fact, you said I have no instruction. Let the notice be issued to the petitioner. Now we are saying, I am having the wakalat, then itself, I continue to appear.
No, Your Lordship, yesterday.
Then why this misleading?
Yesterday only they have.
How could you file the wakalat long back?
At the time of filing of this one.
Is it not your duty to verify? You are asking your duty to be done by the work to be done by the court. I am your clerk, is it?
I'm sorry.
Sorry, indre ella mugit. Learned counsel submits that he continued to represent the petitioner and he holds wakalat since from the inception. The order sheet, order sheet. The order sheet dated 27/2/2024 discloses that since the learned counsel for the petitioner had expired, the court notice was issued to the petitioners. Now the court notice is served and the learned counsel submits that he is already having the wakalat for the petitioner and continues to represent the petitioner, which is nothing but misleading the court and getting an order to issue court notice once again. The conduct of the learned counsel for the petitioner cannot be appreciated. Learned counsel prays for time to address his arguments. It is noticed that the petition is of the year 2017. I do not find any reason to adjourn the matter, however, to afford final opportunity. Next.
Interim order may be extended.
Next, no interim order, sir. Next.
Serial number 20, Vidana Disagree, Arvind Babu.
Copies were supposed to furnish mods.
Yes, who is for the petitioner? Mr. Tigidi.
Vidana Disagree.
Counsel for the petitioner is absent, no representation. Even after a matter is passed over twice and called again at the end of the list. In the morning itself, the counsel for the respondent and the XCGP submitted that the copies of the petition are not served on the respondents. In spite of that, there is no representation. Copy of the petition is not served. I do not find any reason to adjourn the matter, however, to afford final opportunity list on Monday or Tuesday. Next.
Serial number 23, Keshavamurthy B.
It appears for the petitioner, my lord, in this case, the petition may kindly be dismissed as the become infructuous, my lord. The complaint itself was dismissed in the trial court.
Counsel for the petitioner.
The report has been filed and that has been accepted, madam.
Yes, my lord.
On 22/10/2019.
Submits that the B report has already been filed and the same is accepted by the trial court.
22/10.
The same. In view of the same, criminal petition be dismissed
As infructuous.
as rendered infructuous.
Much
Submission
of it.
Placed on record, dismissed. Next.
Much.
Serial number 35, adjourned. Serial number 36, Venkatesh TS.
ಈಗ ರೆಡಿ ಈಗ ಎಲ್ಲರೂ ರೆಡಿ ಇಂಥವ್ರೆಲ್ಲರೂ ರೆಡಿ ಅದೇ ಸರ್ ಏನು ನಾನು ಯಾರಿಗೂ ಏನು ಹೇಳಲ್ಲ. ಸರಿ ಸರಿ ನಿಮ್ಗೆ ಅರ್ಥ ಆದ್ರೆ ಸಾಕಷ್ಟು. Counsel for the petitioner prays for time. He undertakes to address his argument on the next date of hearing without fail. Submission is placed on record. This time. Next date of hearing, I will not adjourn it, nor pass over it. Yes.
Was here only the court.
Yes.
Serial number 40, Siddharthi Muchandi.
Respond number 2, madam.
Petitioner. Regarding the civil suit, my lord, I have the status of the suit, my lord. Three civil suits, one has been disposed of, and the other two, my lord, are pending before the.
You file a memo to that effect.
I will file a memo. And I'm also relying.
Is the memo?
I'll just file a memo. And
Counsel
also,
for
my lord, I
the
rely.
third learned counsel for the petitioner. After addressing the argument for some time, learned counsel for the petitioner submits that there are civil suits pending between the parties in respect of the same facts and circumstances. He undertakes to file a memo giving the particulars of the suit and the stage in which the same are pending. This time. ಯಾವಾಗ? ನಾಳೆ? Tomorrow? Tomorrow. ಆಯ್ತು, ಇದು ನನ್ನ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಆಯ್ತು. ಫರ್ದರ್. Yes. ಯಾರು who is for the respondent?
Respondent
number 2. ನಾಳೆ you should get ready.
Interim order will be extended. If interim order will be extended.
You are also there in 2 of the matters. So you should get ready. Interim order.
These two, serial number 21, Jeevan Kumar BS, Timana.
I appear for the point. Appellate.
Serial number?
21, the 21st, second.
ಏನ್ ಮಾಡ್ತೀರಿ ಇವಾಗ? 5 ಗಂಟೆ ಮೇಲೆ ಎಲ್ಲರೂ ರೆಡಿ ಆಗ್ತಾರೆ, ಎಲ್ಲರೂ ಅಲರ್ಟ್
ಇಲ್ಲ ಅಲ್ಲಿ ಇವಾಗ್ಲೂ ಮುಗಿತು, ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಓಡುವಾಗ
tomorrow, idu kuda further hearing. Next. Finally, as a last chance in February.
List number 3. List number 3, serial number 4, my lord.
That's tomorrow. Tomorrow, 20.
Time for fourth time. Danappa Guruppa. Order serial number 2. Ajay Kumar and.
For the petitioner, I comply the office.
Just thank you, sir. Just thank you.
Kindly have it tomorrow.
Yeah, you're not coming.
Yes. Serial number 3, Mahesh.
May I appear for the petitioner?
M for
306, my lords, your lordship was pleased to grant bail for accused number 1. In the meanwhile, the
My
first
lordship.
informant has filed an application 301, my lord. There was certain office objection. They have served as a copy. So lordship can have it after tomorrow, my lord.
Lord, ಇದರಲ್ಲಿ
First informant. Mr. Mohan Kumar.
ಲಾರ್ಡ್ ಇದರಲ್ಲಿ
PM.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಗೆ ನಾನು ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ.
Respondent number 2 ಅಲ್ಲ, sir.
301 ಅಪ್ಲಿಕೇಶನ್ ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಬೇಕು ಅಂತ ಆಫೀಸರ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಅದನ್ನ ಫೈಲ್ ಮಾಡ್ತೇನೆ ಸ್ವಾಮಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಇವ್ರಿಗೆ.
My lord.
ನಾಳೆ ಮಾಡ್ತೇನೆ ಡೇ ಆಫ್ಟರ್.
ಇಲ್ಲ, ಈ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಮೊನ್ನೆ ಇವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೆ 301.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಇದ್ರದ್ದು ಸರ್.
ಅದೇ ಇಲ್ಲ. But the flaw is for protection, my lord. I request for day after tomorrow. As such, they have got a limited scope. ನಾವು ಮಾಡಿಲ್ಲ. ಅವ್ರು 301 application ಹಾಕಿದ್ರು. Prosecution. ಮೊನ್ನೆ first.
Yes, my lord.
My lord.
ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಸರ್ ಅವರು.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಾನಲ್ಲಪ್ಪ.
ಅಲ್ಲ.
ಅಲ್ಲ.
ಇನ್ನು ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿಲ್ಲ. They have filed wakal. If your lordships allow the application, I mean amend the petition right away. ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Very well. But on that day, let them not take any adjournment, my lords, kindly. Great.
Kindly have done Monday, my lord. ಇದರಲ್ಲಿ senior counsel engage ಮಾಡ್ತಾರೆ. Yes, my lord. ಇದು ಇಲ್ಲ, my lord. I will while submit, my lord. ಇದರಲ್ಲಿ serious allegation is 306.
I am granting that. You come prepared to address the argument. Amen. Apart from filing the affidavit, whatever you want.
Monday, my lord.
Serial number 4, Devaraja
For
M.
the petitioner, my lord. My lords, 4 other co-accused have been granted bail by this honorable court. May be taken up tomorrow, my lord. Please.
Order first time matter, serial number 5.
For the petitioner, Your Honor. For the petitioner, Your Honor.
Serial number 6, Nagaya.
I appear for the petitioner's bills. When be taken up on day after tomorrow. I'm ready. Please.
Court officer. Court officer. Court officer.
ಅದು ಅವರು ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. ನೀನು ಇವಾಗ ಆಫೀಸಲ್ಲಿ ಮಾಡ್ಬೇಕು.
Second list ಅಲ್ಲಿ 15.
You go to
Court officer. Madam, court officer.
Sir, ಹೇಳಿ sir.
The second is to serial number 23 ಏನಾಯ್ತು ಮೇಡಮ್?
Number 23. 7-8 ಗೆ date ಹೋಗಿದೆ sir.
Madam.
Thank you.
21, second.
Madam 18. ಅದೇ ಲಿಸ್ಟ್ ಅಲ್ಲ 18. ಡೇಟ್ ಏನಿಲ್ಲ ತಾನೆ?
ಕಂಪ್ಲೈ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು, ಆಗಿದೆಯಾ? ನಾವೇನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರಾ? ಮಾಡಿದ್ರೆ ಬಂದ ಅಷ್ಟೇ, ಅದು ಟೈಮ್ ಕೊಟ್ಟಂಗೆ ಸರ್, ಅರ್ಜೆಂಟ್ ಆದಂಗೆ ಡೇಟ್ ಅನ್ಬಿಟ್ಟು 8. ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್
ಏನೋ ಫೈಲ್ ಮಾಡಕ್ ಕೇಳಿದ್ರು ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ.
ಫೈನಲಿ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ 28 ಇಂದ 31 ವರೆಗೂ ಇದೆಯಲ್ಲ, ಸೆಕೆಂಡ್ ಆಫೀಸ್ ಟು ವೆರಿಫೈ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. ನೀವು ಹೇಳಿದ್ರೆ ವೆರಿಫೈ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅದ್ ನಾನು ಬಂದ್ತೀನಿ ನಿಮಗೆ ತೋರಿಸಿರ್ತೀನಿ. ಡೇಟ್ ಸದ್ಯಕ್ಕೆ ಇದ್ರಲ್ಲಿ ನೋಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಬನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ಡರ್ಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನೆಕ್ಸ್ಟ್ ವೀಕ್, ನೋ ಪ್ರಾಬ್ಲಮ್. 3 ಬಂದು 18, 4 ಬಂದು ನಾಳೆ, 5 ಬಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೋಟಿಸ್
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ರಿಪೀಟ್ ಆಗಿದೆ ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 40
ನಾಳೆ
ಮೇಡಮ್ ಲಿಸ್ಟ್ 3 ಐಟಮ್ ನಂಬರ್ 2 ಅಡ್ಜರ್ನ್ ಆದ್ರು ಏನೋ ಆಫೀಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಏನೋ ಟು ಫೈಲ್ ಇಟ್ ಇನ್ ದಿ ಕೌಂಟರ್ ಅಂದ್ರು.
ಮೇಡಮ್ ಕೇಳಿದ್ರು, ಸಬ್ಮಿಟ್ ಮಾಡ್ಕೊತೀನಿ, ಆಫೀಸಲ್ಲಿ ಮಾಡ್ಕೊತೀನಿ, ಇಲ್ಲೇನಾರ ಕೊಟ್ರೆ ಕಳಿಸ್ತೀವಿ. ಇದೆಲ್ಲ ಮುಗಿಸೋಷ್ಟು ಕಳಿಸ್ಕೊಡ್ತೀವಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರೇನಾರ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ನಿಮ್ಗೆ ಆಮೇಲೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಫೋನ್ ಮಾಡ್ತೀವಿ ಬಂದ್ರೆ ಮೇಡಮ್ ಎಲ್ಲಿ ಹೋಗಿ ಅಂದ್ರೆ ಡೆಡ್ ಎಂಡ್ ಆಲ್ಮೋಸ್ಟ್ ರವಿ ಅಂದ್ರೆ